right now we want to Shout out to the chat. Shout out to the chat. What's going on here? Hold on. I don't know what's up with this thing. Hold on. Hold on. Can y'all hear me? My whole stuff just disappeared. Where is it? Look at this. My whole thing just ended up here. How did that happen? Shout out to the chat. Shout out to the chat. Ladies and gentlemen, how you doing? Shout out to the chat. Shout out to the chat. Light on. I turn my light on, man. Shout out to the chat. Hold on. Shout out to the chat. All right. Yeah, but I was dark for a second. Welcome to the Wabbit Crime Network. If you haven't been to the Wabbit Crime Network, this is channel 2. We got the Wabbit Crime Network 1 and we got the Wabbit Crime Network 2. This is Crime Network 2, where we do live trials over here. On the main Crime Network, we do smaller trials, civil cases, parole board hearings, stuff of that nature. Over here, we do actual court trials and in processing. And today, we're gonna revisit Karen Reed. I'm not familiar with the Karen Reed trial, hence why it's gonna be a learning experience for me as well as anyone who has not been familiar with Karen Reed. And also, if you have been familiar, it's a good way to revisit the whole Karen Reed thing. There were 2 trials. One was a mistrial. Second one, she ended up beating the case. We're gonna see how that went down. This is gonna be a series. This will be a series. We will be doing this multiple times a week as we get through these days and these cases. So look forward to that. That's where we're going today. We're going to start off by getting familiar with the case and the trial itself. We're going to do some of the preliminary, the motions, the early hearings leading up to day 1. We're gonna try to get through those in one live. This way, in the next live, we can just start with the first day of trial. So that's what we're doing. But 1 second, I'll be right back. Shout out to the chat. We got memes with the Wabbit Bot. We got Wabbit Bot in here. We got memes, no sound effects yet, but we got memes. I'll be right back. Hit the like button if you haven't already. Share this live. Thank you.
Someone is at the front door.
Shout out to the chat. Sorry about that. Did y'all hear my doorbell? Oh shit! I was supposed to mute the mic. I think y'all heard my doorbell. God damn it! Shout out to the chat. Thank you everybody for pulling up, man. We haven't been here in a while. I lost my monetization over here, y'all. I lost my monetization, but we're getting it back. I got 1,000+ watch hours still over here, so that's good. I got over 1,100 watch hours, so I just need 2,000 more, and we back in business. And we're gonna end up with some ads over here as well. And then back to the Crime Network. So we're doing the Karen Reed trial. We're just getting through this introduction here because I haven't been around in a while. But I'm back fighting crime. Your neighborhood sister man is back fighting crime in a neighborhood near you. Be on the lookout for me. Hey. But don't try to get me to fight crime in real life. I ain't doing it. But I can't do it in real life though. I can't fight crime in real life. Please don't hold me to it. All right. We got a lot to unpack. So let me stop wasting time. We got a lot to unpack. Let me stop wasting time. And we're gonna start. We're gonna start with an overview. Shout out to Law and Crime Network. You know the Law and Crime Network, Court TV. You know you really gonna immortalize that on camera. I hope Casey clips. Who's Casey? I'm sorry, I'm not familiar. Who's Casey? Shout out to the chat. Shout out to the people in the chat, man. Not it, Lady Wrench, Just Jay, Chase Spectives, Evil May, Courtney Peach, Mrs. Baker, K20EP1. How y'all doing? How y'all doing? How y'all doing? All right, so we're gonna get familiar with the case. So we're gonna do a little overview summary. JB2 reactions. What's up, man? We're gonna do a little overview summary of Karen Reed and what she got charged for, why she was arrested, and once we get through that, we will start with the actual proceedings, the actual hearings and proceedings. Shout out to the chat. Shout out to the chat. Uh, yeah. Hold on 1 second here. We'll start here. All right, so we got a video here that's gonna give us a little summary of what's been going on. Let me switch my screen here. Gosh, I gotta readjust all my stuff. I readjust everything. My God, my God. Make sure everything is moved. Everything right where it's supposed to be. Where it's supposed to be. Yeah, I'm over here. Yeah, I'm not in the middle anymore. I'm over here. Hey, it's me. Hey guys. All right, I'm over here now. We got a presentation that's about to be on the screen. I don't need to be up there no more. I need to be over here. All right. Hey. All right, I'm over here now. Hey, look at me. Hey, all right, I'm back here. I'm back here now. I'm back here. Y'all don't need me up there, do y'all? I don't need me all the way up there. Shout out to E Boogs, man. I'm liking my setup. See my background, right? Hey, do y'all notice that the stars is in my window? I got stars in my window. Stars in my window. Stars in my window. Look at, you see behind my chair in the window, I got stars back there, man. Listen, listen, man. You see me? I'm chilling, solving crime virtually. I got my gumshoe and my magnifying glass. Make sure you guys get your magnifying glass. Y'all know that's the official symbol over here. Shout out to the chat. Anyway. Good thing I don't think that these comments is about me. You know? So anyway, we gonna get to what we getting to. Keep the change. Hi. Let's start off with a summary so that we can get an understanding of what we are getting into. We're gonna watch a video to get some straightening. And it says, the name of the video is called "Woman Accused of Killing Cop Boyfriend Claims Police Framed Her for Murder." What? So with that being said, we already know that this woman boyfriend was a cop and he's dead. And the cops are saying she did it, and she's saying they trying to frame her. Now, this is interesting. One, police is involved. Oh, man. You know, when police is involved, you might not get all the information. Cover-ups. You know, because the people investigating is the police. So, you know, a lot of time with the crimes, police brutality and stuff, people feel like they're not going to get justice because you wait, who's going to? So the police is going to investigate the police and then lock the police up for doing wrong? You know, people start losing trust in that type of stuff. People lose trust in that. So, the cops would have to do everything right. Everything by the books. I mean, OJ was acquitted. It did not fit. OJ Simpson, after going on a high-speed chase in the Bronco, in the white Bronco, as a matter of fact, I don't even think Bronco sold anymore after that, unless you wanted to race. I'm not sure people bought Broncos after that. Do they even make Bronco anymore? Listen, man. OJ Simpson and Bronco is synonymous. Okay? And even after he took people on a high-speed chase, the glove did not fit, so they had to acquit. Okay? That's all I'm saying. Katana. That's all I'm saying. You better do it the right way. And even sometimes when you do it the right way, it's too much corruption in the system. So that's why we here with a close eye scrutinizing. We watching, we want every hearing to be televised. Because we want to see everything you guys are doing. I want to see what the prosecutor doing. Hey, bailiff. Hey, court reporter, I'm watching you. Jury, even though I can't see you. I don't try. Judge, we'll get you out of here. You see what Brian Steele did. Okay, Judge, we will get you out of here. You start doing something that hey, listen, I want to see everything. Shout out to the new age, where we get to be there even though we not there. Shout out to the new age, man. Hey, hey, Karen Reed, I'm about to supervise your trial. Yeah. Karen Reed, I'm going to overlook your trial and make sure I ain't missed nothing. Okay? So right now I'm grading Karen Reed's trial papers. Let me stop. I'm not here to be talking all this nonsense. All right, let me stop. I'm really not here to be talking all this nonsense. Let me get to my video. I can't help myself. I can't help myself. I just gotta talk shit. I don't know what's wrong with me. I need help. I need help. I need help. Like Rodney Reed. Who's Rodney Reed? See, I gotta get familiar. We got too much criminals in America, man. Shit. You know we can't run out of crime content? Somebody doing a crime right now we gonna probably react to in like 2 weeks. Somebody probably doing a crime right now that we about to read about tomorrow in the news. Listen, they always doing crime in America. Man, listen. All right, let's stop. Come on, guys, be serious, man. Hey, listen.
If you think I'm here to play around with y'all, God damn it, I'm not.
All right, listen, we came to work. We came to do serious business, man. Come on, y'all. And check out the Weeder Wabbit store. We got merch. You know what I mean? We got merch in the Weeder Wabbit store. You can check out the Weeder Wabbit store, see all type of stuff. You can also get the same shirt, different day. It's one way to support the channel. I ain't monetized on this channel. So we got anonymous donation and we got Cash App. If you want to support the channel, those is one of the ways, those different ways you can support the channel. Support the store, hit the Cash App, hit the anonymous donation link. If you like the content, support. Shout out to the chat. All right, let's get to it. Now let's get it.
The Commonwealth has fought the defense at every turn in our quest to get the phone records. They've persuaded this court that we were previously on a fishing expedition. To the extent the court once thought otherwise, it is clear this is no longer a fishing expedition.
Attorneys for Karen Reed arguing for access to cell phone records for witnesses in the case against her for the death of her boyfriend, Boston police officer John O'Keefe. Reed's trial is beginning in just a matter of weeks. Thanks for joining me for Crime Fix. I'm Anjanette
Shout out to the
Levy.
chat.
Karen Reed's trial is scheduled to begin April 16th. She faces several charges, including a second-degree murder charge for the death of her boyfriend, John O'Keefe, back in January of 2022. Prosecutors say the case is simple, that Reed was drunk, the two had a fight.
Yo, Lady Wrench. You did it. You did it, Lady Wrench. Shout out to you. Hey, you did it. You did it, lady. You did that, Lady Wrench. You did. Okay? You did that. Shout out to you. ASAP, okay? Right away. Shout out to, hey, Lady Wrench. You did that.
And she hit O'Keefe with her SUV outside of a house in Canton, Massachusetts, and then left him there to die. The pair had been out drinking at a couple of bars earlier that night and then planned to go to a friend's house. Hours later, Reed's SUV is seen leaving O'Keefe's home where she lived with him. She and two other women found O'Keefe unconscious in the snow. Reed has claimed she was framed as part of a massive police cover-up. Even the feds are investigating, hearing testimony from grand jury witnesses. Reed says O'Keefe's friends, who are police officers, actually beat him up inside that house where she dropped him off, and that he may have actually also been attacked by a dog.
What? You saying his friends beat him up? How'd she know that? What? Hold on, I'm sorry.
Reed says O'Keefe's friends, who are police officers, actually beat him up inside that house where she dropped him off, and that he may have actually also been attacked by a dog. And then those officers threw him into the snow and left him to die.
That's real hard to accept. Like cops? You saying some police officers beat up another police officer and left him to die? Not saying it's impossible, but you're going to have to prove that. You really going to have to prove that. For real.
But recently in court, attorneys for some of those witnesses, who include law enforcement officers, said they've been told by the U.S. attorney that they are not targets of the federal investigation.
Brian Higgins is not a target of the federal investigation. That has been confirmed by the United States Attorney's Office and confirmed to me that I could make that representation in court. The U.S. Attorney's Office has continuously confirmed throughout its investigation that Brian Higgins is not a target of their investigation.
But let's get back to John O'Keefe's injuries. Reed believes he was beaten and attacked by a dog, as I mentioned. But prosecutors have said in court documents that the autopsy showed that John O'Keefe died as a result of blunt force trauma to the head, and that he had tiny skull fractures that caused bleeding in his head. O'Keefe had a really large gash to the back of his head.
So somebody might have hit him with something really hard. No weapon, no murder weapon, no nothing?
The medical examiner did not believe that O'Keefe had been in any type of fight, despite bruising that you can see on his knuckles and what appears to be black eyes. I'm telling you, there are photos on the internet from O'Keefe's autopsy.
So bruises, black eyes. I mean, how he get that? On the knuckles? How he get that?
See, but we are not going to show those to you. They're just simply too graphic.
Wow.
And what about the scratches on O'Keefe's arm? How did he get them? They're kind of like up and down scratches. I thought we should ask an expert to find out. So joining me to discuss what we do know about the autopsy results for John O'Keefe is somebody who has performed many autopsies in her time. She is Dr. Michelle Dupree. She's a retired medical examiner. Dr. Dupree, thanks for coming on. We know that you haven't seen the autopsy report, but you've looked at some of these photographs that I found online and sent to you of John O'Keefe's injuries. And tell me, first of all, we see that there's a big gash on the back of John O'Keefe's head. So tell me, what could that have been caused by, in your opinion?
Well, that's a laceration, which means that he struck something hard. Maybe it was cement, maybe it was a rock or something like that, but a hard object. And that could very easily cause multiple skull fractures.
There's been a lot of talk online, and we know that there was a suggestion by the defense team in this case that John O'Keefe was not hit by a vehicle, that he was possibly beaten up inside the house on Fairview Road, possibly attacked by a
UWB.
dog. That's what one of Karen Reed's supporters has said. I believe maybe her defense team said it as well.
Well, you're gonna be talking to yourself in the chat.
And then left in the snow to die. So let's talk a little bit about that possibility, because if you look at these autopsy photos, John O'Keefe does have swollen black eyes. It does almost look like he's been in some type of fight. The medical examiner, according to the prosecutors, said that she did not believe he had been in any type of physical altercation, that swelling and that bleeding was caused by small fractures in the skull.
Right.
Okay, I would need a medical expert opinion, but I do know that, you know, certain injuries could cause you to get swollen in different places and stuff. I'm not sure exactly about the black eyes, but I do know that injuries could cause, you know, you to have bruises other places, yes. But I'm not sure in this case that's what that is.
You know, there is some credibility, I think, from looking at the photos, and you know, a little caveat here: they're not the best photos, so there's some margin of error. However, when we see black eyes, we call them raccoon eyes, and they can come from a skull fracture.
They can.
But that skull fracture is a particular type of fracture known as a basilar skull fracture, which is what your brain actually sits on top of. And it's fracturing those very small, thin bones where your eyes are. And then there does cause the black eyes from the bleeding there. However, one of the things that I was puzzled by in reading the reports is there's a small laceration or cut above his right eye. That typically comes from being struck. So if you're struck in the eye, say you're punched and getting a black eye, you may have a little cut of the skin right above that. So that leads some credibility to him possibly.
Laceration above the eye and a black eye. I mean, seemed like he got hit in the face.
Having been in a fight, I'm not sure how you would get a small cut like that from being struck by a car.
Right.
More facial injuries. When a car, of course, it's a large object. When it hits you, something else is going to be damaged on your face. So that does lead to some credibility. And there may have been more than one thing. He may have gotten into a fight and been struck by a car. You know, he has a lot of injuries on different parts of his body.
Okay.
Why would the ME, if he had possibly been into a fight, she's saying she didn't see any evidence of that. I mean, we see in some of the photos, and you're right, they're not the best photos.
So the medical examiner say that she ain't see evidence of that. And this is the problem when you're dealing with places where everybody know each other, and the prosecutors go to dinner with the cops, and the cops be having lunch with the judge, and everybody hang out and go to dinner and have, like, this is the type of stuff that you start, like, yo, do y'all know each other? Do you know the cop? Do you know? Did y'all go to school together or something? Because all that be in these small towns. I'm not sure if this is a small town, but it seemed like it the way she's like, he's a cop, his friends, like it seemed like everybody know each other around here in this situation.
I mean, we are not seeing the pristine images from the ME's office. We're seeing what's kind of been shown in court and then reposted online. There are some kind of bruises or some discoloration, I should say, to his hands and his knuckles.
There is. And again, that's usually indicative of someone being in an altercation of some kind. He has bruises and contusions on the back of his hand. And as far as the ME not thinking that he had been in an altercation, that's a matter of interpretation. You know, she obviously did not think that there was enough evidence to suggest that. I'm simply saying that I think there is a possibility that he may have actually been in a fight, given some of that that evidence that we see.
I'm starting to think the medical examiner might be a little shady, because just hearing what they saw, like, you saw bruises, you saw a cut, you saw a black eye, like, you ruling out the possibility of a physical altercation? You completely ruling that out, even with this? At least consider it. Nah, the medical examiner is starting to seem a little shady.
But also, there may have been some other, I guess, contributing factors. The scratches and the abrasions on his arm, there's several of them, and they're linear. those are not typically what we see from being hit by a car. I can't say that they look like dog scratches necessarily, but it would be unusual to receive those from being hit by a car. We often see something called road rash, which is several scratches and abrasions, on the surface of the skin.
It's not
That
the
is
same.
not what
Yeah,
these
that's not
are.
the
These
same.
are very different.
It's not the same at all.
So I don't think you
They,
can
they,
rule out that possibility.
they are different, and it was January. There's a blizzard going on. So John O'Keefe, as we saw in the surveillance footage from the bar, was wearing long sleeves. So where those scratches would have come from is kind of curious to me. Um, Whether or not they're dogs, I mean, dog scratches, dog bites, being attacked by a dog, I'm just not so sure, because would a dog just go for arm?
So this case was questionable from the beginning. Clearly, this case was very questionable from the start. The trial ain't even start here, and these questions is valid. Like, it's something seems off.
Wouldn't a dog maybe go for other parts of the body as well? I just don't know.
Exactly. And, it would be interesting to see the clothing that he was wearing and match up those injuries with that clothing, because obviously the clothing must have been torn in some way.
That's a fact.
Does it look like it was, shredded by dog nails or whatever it may be? But again, those are some of the, I guess, rather contradictory evidence findings in this case. There's also, I believe, evidence that he had been out drinking. So perhaps he even passed out and then sustained some of these injuries. Again, we don't really know that.
G. Grant,
There
what's
was
up?
some discussion too. The Commonwealth cites in this opposition to their motion to dismiss, they lay out their case and they talk about the ME's findings. And the ME makes it sound like he was left there for some time. I mean, he had hypothermia. But when he was found, his death, hypothermia, it sounds like, contributed to his death because of some discoloration in the pancreas and things of that nature. Does hypothermia make bleeding and things of that nature, maybe pooling of blood, does it make it worse because you're cold, you're laying there for several hours, and therefore you're not moving, and it allows blood to pool and settle?
Well, 2 points, Anjanette, really. The hypothermia, I'm sure, probably did contribute to his death. It doesn't take that long. Your body temperature reaches a certain level for you to pass out, become unconscious, and then die from that. As far as the pooling of the blood, it would actually slow down. Your heart would begin to slow down. The pumping of the blood would begin to slow down. I don't think that would have a significant factor. The factor is that the cold is going to decrease your body systems and therefore slow everything down. And eventually you will lose consciousness from being cold or hypothermic, in addition to his other injuries, which also certainly played a major factor.
Yeah, most definitely. I do find it interesting that one shoe was on and one was off. And you do see that in accidents or in incidents where somebody is hit by a vehicle and thrown, that sometimes they can be knocked out of their shoes. What did you make of that? He has one shoe on, one shoe off.
Yes, and you're absolutely right. When we see motor vehicle pedestrian collisions, we often see that. However,
That's a fact.
I don't think that's likely in this case, because when we see that type of event happen, the person is struck by a vehicle.
And usually
They're
far,
basically picked up
right,
off the ground and blown out of their
somewhere
shoes.
away from their shoes. The shoe ain't gonna be next to them. That's a fact. You gonna see their shoe, but they usually away from the shoe because they got knocked out of their shoe.
From usually a pretty high rate of impact.
Facts.
And I don't think that in this case there was that significant high rate of impact to throw him out of his shoe. I think that maybe he was just disoriented. It just got knocked off or something of that nature.
Interesting. There's no,
There's
I
more
guess
to this story,
the
man.
cause of death has not, I'm sorry, the manner of death, pardon me. The manner of death has been not determined. It's undetermined at this point. What do you make of that? Because the Commonwealth, I would think, would want this, or would want to convince a jury that this was indeed a homicide, but they're going to have to go in front of a jury, and the ME is going to say the manner of death is undetermined, given all of the information she has.
Yes, and every medical examiner office has undetermined cases, 1, 2, 3%, something like that. That's really not a bad thing. What it does is it leaves the investigation open so that when new evidence is found, then the case has not really been closed per se. We classify something as undetermined when we simply don't know the answer. And in this case, this is a perfect example. We know that it was blunt force trauma. We don't know if it was intentional. We don't know if it was accidental. We just simply don't know. It would be like, say, finding a skeleton at the bottom of a cliff. Did he jump? That would be suicide. Was he pushed? It would be homicide. Did he slip and fall? It would be accidental. So there's many things that it could be.
Interesting. So what do you see happening at this trial? Would you see this as being kind of a battle of the experts type situation? Because you're going to have the ME from the state testifying. I would assume that they'll have a reconstructionist too, a crime scene reconstruction type person to offer an opinion as to what had happened, along with the ME offering an opinion of what possibly could have happened to John O'Keefe. And then the defense, I'm assuming, is going to have their own experts.
I think you're absolutely right. I think this will be a battle of the experts. And I would think that both sides would have forensic pathologists or medical examiners. You get 2 or 3 of us in a room and you're going to get 2 or 3 opinions. But it's a matter of interpretation, experience and education and training. And then again, looking at all of that evidence. And as you know, I'm a former law enforcement officer, and we have a saying that we look at that totality of circumstances. We don't just look at one particular thing. And so in this case, I think that's what it's going to be. We need to look at the whole surrounding circumstances. We need to look at the evidence. There was evidence that one of the people at the party Googled how long does it take to die from being out in the cold. Well, that's really weird.
Who would Google that? What would make somebody Google that? What a coincidence that you happen to Google something like that while something like that is happening. That's interesting.
And there's some other very odd things when you look at all of that evidence. And ultimately, of course, as you know, it will be up to the jury to decide. This will be a very interesting case.
Yeah, it will
This
certainly
is going to be an
up to
interesting
the jury
case.
to decide. And we have differing opinions. We have the state
It's gonna be
saying
an interesting
how
case.
long, how long does it take to die in the cold? That text message, they say it happened at 6:23, 24 in the morning. Defense says it was 2:23 or 24 in the morning. So that'll be another point of contention as well. Dr. Michelle Dupree, thanks
Miss
as always
Eve.
for joining us. We appreciate it.
My pleasure. Thank you.
And that's it for this edition of Crime Fix. I'm Anjanette Levy. Thanks so much.
All right, so we got a pretty much good summary of what's going on here and why she's on trial. So they had the trial starts, but before the trial officially starts, they do these motions and hearings. So we're gonna get through those real quick.
Much.
Thank you. On behalf of Kevin Albert, present is Peter Paschuko, and on behalf of Brian Higgins is William Connolly.
Great. Thank you.
Let's see what's going on here.
All right, so counsel, I need you to spell your name for me, please.
Yes, Your Honor. The last name is Connolly, Connolly.
And what's your first name?
William.
Thank you. All right, I will hear you on behalf of Mr. Higgins.
Thank you, Your Honor. Your Honor, as the court is aware, Brian Higgins' phone records and communications are at issue in these motions.
Don't know who Brian Higgins is. I guess I will find out.
Brian Higgins is a federal ATF agent. He is a witness in the Commonwealth's prosecution of this case.
Okay. He's a witness, agent. Okay.
Cooperated fully in the Commonwealth's investigation. As this court knows, we've not had the benefit of seeing the factual support for these motions, but I want to provide some information that likely isn't contained within those materials submitted to the court, but of which I have a good faith basis to believe is information contained in the materials provided by the federal government to the parties in this case. I've represented Brian Higgins since April of 2023, the month when he received the federal grand jury subpoena. Like he has in this case, Brian has cooperated fully with the federal investigation. He has answered every question put to him in both investigations, and he will continue to do so because he has nothing to hide. Brian Higgins is not a target of the federal investigation. That has been confirmed by the United States Attorney's Office and confirmed to me that I could make that representation in court.
Is this guy because you remember this case is about actual cops. You know what I mean? So is Brian Higgins officially working on the case, or is he just a federal agent who happened to be a part of some of the stuff going on to where he's a witness? I'm trying to figure out if he's, because when they mention police now, I'm not sure if it's just a regular civilian or if it's somebody that's actually working on the case, because police is involved in the case. Police is being investigated. So, you know, so it's possible that this guy is an actual person that was there.
U.S. Attorney's Office has continuously confirmed throughout its investigation that Brian Higgins is not a target of their investigation. Brian Higgins has not participated in any kind of a cover-up or conspiracy to cover up the criminal activity of others.
The fact that he said that seems like Brian has been accused of trying to cover up some things.
Has spent his career saving lives. He was a firefighter before becoming an ATF agent. He has been an EMT since 1992. He received a congressional medal for saving the life of a fellow ATF task force officer after being shot 5 times in Somerville, Massachusetts. He has served our military in Iraq. Participating in a cover-up is contrary to who he is as a human being and a professional. I am here to represent Brian's interest in privacy. Brian Higgins, at my urging, will not capitulate and stand down when efforts are made to further intrude upon his privacy based upon sheer speculation. It is for that reason that we oppose these motions, not because Brian Higgins has done something wrong or has anything to hide. We know this court will give us an opportunity to review the motions and supplement our remarks if we deem it necessary. We know this court will fairly weigh the arguments before it and will render a fair decision, and we will respect that decision and we will comply with that decision. Respectfully, we do not believe there is a sufficient factual basis to support the relief requested in the motions before the court. Thank you, Your Honor.
All right. Thank you very much. Counsel?
Good afternoon, Your Honor. Attorney Peter Pisciuco on behalf of Kevin Albert.
All right, so you need to spell that last name.
Sure, it's P-A-S-C-I-U-C-C-O.
Good afternoon.
Yeah. Thank you, Your Honor. Just a little bit of background with respect to Mr. Albert, and we are objecting to this.
So Kevin Albert seems to be another witness in the case or something?
This Rule 17 motion. Kevin Albert's a 19-and-a-half-year veteran of the Canton Police Department, extremely well-respected.
All these witnesses, all these people involved is police. Law enforcement, some kind of law enforcement, man. This is... So we got law enforcement involved in a murder somehow, because the lady that's accused, she's connected to law enforcement, but she's not law enforcement. But everybody else that's around in the case is somehow law enforcement. Is there a possibility that they will try to cover up something? Highly likely. Me personally, I don't trust them enough to say, yeah, they're going to do it the way they're supposed. Nah, they corrupt. There's a lot of corruption in law enforcement, all in the 50-something states. There is corruption in law enforcement all throughout the whole United States. So I can't just say, nah, they won't do that. I can't say that. I will be naive. So, man, there's gonna have to be some real people with integrity that's really about justice looking over this case to make sure that things go the right way, because, you know, once you're part of that brotherhood, sisterhood, that club, you know, becomes protect each other instead of bring justice. So hopefully justice is on the mind of these people on this case.
Extremely well-liked. Any insinuation that he participated in a conspiracy or a cover-up is simply untrue. There's been no showing.
Okay, so Kevin Albert is getting accused of covering up too. So it seems like the cops that's involved in this case are being accused of covering stuff up. And maybe there's no basis to it, or maybe they have a lot of basis to it. So we'll see. We'll hear how this stuff unfolds. But I expect to get some information throughout this trial on why people think these cops have been trying to cover up some things.
How personal communications between my client and Mr. Higgins have any relevance here, let alone evidentiary value. Kevin Albert is not a Commonwealth witness. He did not testify in the federal grand jury, and his involvement is essentially zero. This is a clear intrusion, as Attorney Connolly indicated, into the privacy rights of these individuals. And I've advised Kevin that there is simply no reason to acquiesce to something that's just clearly a fishing expedition. So upon my advice, Kevin Albert is objecting to this Rule 17 motion, but we will honor and respect the court's decision and appreciate the time to supplement any response in writing after we see the motion and affidavit, which hasn't been provided to us yet.
Okay, thank you very much. All right, Mr. Yannetti, did you want to respond or no?
No, I would just move to the next motion if the court were ready.
Okay, so we'll move on to the next motion. Mr. Lally, you didn't want to add anything, did you?
No, thank you, Your Honor.
Okay. All right, so this motion concerns Brian Albert, Kenneth Berkowitz, Brian Higgins.
Yes, and Your Honor, with the court's permission, I'd like to start with Brian Higgins with regard to this motion.
All right, so Mr. Lally, is it safe to assume you did not provide, or you didn't comply with my order in providing the motions and supporting affidavits on this as well to the third party record holders and their lawyers?
Yes, Your Honor.
Okay. So the council will receive copies of this as well and be permitted to argue now and supplement it. All right.
Thank you, Your Honor. As I previously mentioned, Brian Higgins did testify before the federal grand jury. And at that time, he was specifically asked if on January 29th of 2022, he made any phone calls when he got home. He said that he did not. He testified that he lived alone. He testified that he was alone that night. He testified there was nobody else in his bedroom. He testified that when he went to bed, he placed his phone on the bedside table. After making those admissions, he was confronted by a federal prosecutor with his phone records. Those records revealed that Brian Albert called Brian Higgins at 2:22 in the morning on January 29.
Uh-oh. Why are you lying, officer? Is this...
Those records reveal, moreover, that 17 seconds later, Brian Higgins called Brian Albert back, and that call lasted for 22 seconds.
How does a police officer who works for law enforcement for years does not know that if he lies about his phone records, they're going to find out? What? That don't even make no sense. Like, why would you even do it? Red flag, red flag, red flag. Officer, you of all people should know that they are going to see if you called anybody or not. Regardless of what you say, they're going to be able to see. Why would you lie?
Now, when he was first confronted, Brian Higgins first tried to claim that it had to have been a butt dial. That term butt dial is used by many of the Commonwealth's witnesses to explain the many calls between them and among them. And I've never seen a case where there have been so many butt dials, to be frank. But Mr. Higgins was already locked in. He already testified his phone was on the bedside table. His butt was in the bed, the phone was on the table. The two could not have met, Your Honor. There was no possibility of a butt dial. And then Higgins admitted that. And that wasn't Mr. Higgins leaving Brian Albert a voicemail. He also admitted under oath that the toll records would have reflected a voicemail if they went to voicemail. He admitted that to call Brian Albert back, he would have had to first reach for his phone, then unlock it with the passcode or Face ID. Then he would have to press on Brian Albert's number. And that is exactly what he did. And he testified that that was what he did.
Bruh. Why we having this trial? We having this trial because we trying to figure out if she lying, because we know these guys is lying. Is they having a trial to figure out if Karen is lying? Because already I'm hearing on some lies. Already. Unnecessary lies if you're innocent.
He also testified that nobody from the Commonwealth, not Trooper Proctor, not ADA Lally, no one has ever asked him about that phone call from Brian Alberts to Higgins, or the return phone call from Higgins to Albert lasting 22 seconds. Rather than get everyone's phone records, as this court knows, the Commonwealth has fought the defense at every turn in our quest to get the phone records. They've persuaded this court that we were previously on a fishing expedition. To the extent the court once thought otherwise, it is clear this is no longer a fishing expedition. We do not have to go fishing to wonder anymore whether calls were made. We now know that someone who had been in that house when John O'Keefe arrived called the homeowner at 2:22 in the morning, 3.5 hours before John O'Keefe's body was found on the homeowner's lawn. We learned that neither party to that call ever revealed to police, investigators, or prosecutors that they connected by phone in those early morning hours. Just like Jennifer Mc...
Yo. Bro, they gonna have another trial. Look, somebody killed this man. Somebody killed this man, bro. And it might not have been Karen Reed, but it's somebody else. Bro, they gonna do another trial. Somebody gonna get locked up because this case still gonna be open, man. This murder's unsolved. I'm hearing that some people might need to go on trial after this. It sounds like they probably investigating right now, and some people got to go on trial because, yeah, Karen Reed might have got off, but Nick, some of you guys need to, nah. What's this? You what?
Cave never revealed that at around the same time she was Googling apps that they connected by phone in those early morning hours. Just like Jennifer McCabe never revealed that at around the same time she was Googling, asking how long it took for someone to die in the cold, a search that the FBI confirms happened at 2:27 in the morning. Again,
the FBI confirmed. Yo. Too much. Damn, the trial ain't even started yet, and I'm already understanding that there was multiple people involved in what happened. It already sounds like we got multiple people involved in what happened. And not because we know they was there or we know that they saw anything, but because we know that they're lying. And that's enough to have some eyes on them and start investigating for real. You lying. Yeah. Oh, you lying too? And you lying? Oh, man. Jenny, what's up, Jenny?
About 3.5 hours before John O'Keefe's body was found. Now, for his part, Brian Albert also first tried to claim that his phone call to Brian Higgins at 2:22 in the morning was a butt dial. He said that he was awake and watching TV, but he was called back to the grand jury to testify a second time. The second time, Brian Albert changed his testimony to say that at 2:22 in the morning, he and his wife were in bed in an intimate situation. He claimed that he had his phone with him in the bed. So now he's claiming that it was during that intimate situation with his wife that he supposedly butt-dialed Brian Higgins. He had no explanation, however, for how his phone picked up when Higgins called him back 17 seconds later. He had no explanation for the 22-second phone conversation that followed, and it's worth noting that Higgins testified he never heard any intimate noises on the other end of the line either. Brian Albert tried to maintain that he butt-dialed Higgins. But again, that would mean that his butt also answered the phone when Higgins called back, and it doesn't make any sense. Both men denied talking to each other despite being confronted with that mountain of evidence by federal prosecutors. But it wasn't just the January 29th, 2022 calls between Higgins and Albert. Brian Higgins' phone records, we learned, reveal that Canton Police Chief Kenneth Berkowitz was involved in interacting with both men shortly after John O'Keefe's body was found. And again, recall, they're supposedly conflicted out of this case.
So there's just a question I have, and I'll let you continue, Mr. Yannetti, but regarding the dates. So the dates of the records you're seeking for Brian Albert, so January 29th to February 4th.
Or 4th or 5th, yes.
4th. That's what you're seeking.
That's fine.
And for Kenneth Berkowitz, January 29th to February 18th, and Brian. All right, it's not entirely clear from the affidavit. Okay. All right, so go ahead. Thank you for answering that, and I'll hear you. Go ahead, continue.
Right. So as soon as John O'Keefe showed up deceased on Brian Albert's lawn, Canton Police decided it might not be a good idea for them to.
Okay, so all this happened at Kenneth Albert's house. What really could have happened that night, bro? What really possibly happened that night? It'll be real interesting to hear what actually happened that night, man. This happened at Albert's.
Be involved in investigating this case. And by the way, I'm reminded when I sat down that District Attorney Morrissey announced
Brian
that
Albert,
publicly.
sorry.
So we knew that early on.
Okay, so is that in his statement that I've had copies of?
It is not in the video statement that we moved to sanction him for. It was a previous statement that he issued.
All right, so get that to me, okay?
That's fine, Your Honor. So the question is, why was Chief Berkowitz inserting himself into this case almost immediately? United States Attorney Joshua Levy questioned Higgins about that in the federal grand jury.
I'm sorry, I gotta go back a little bit.
To sanction him for. It was a previous statement that he on. As soon as John O'Keefe showed up deceased on Brian Albert's lawn, Canton Police decided it might not be a good idea for them to be involved in investigating this case. And by the way, I'm reminded when I sat down that District Attorney Morrissey announced that publicly. So we knew that early on.
Okay.
Well, that makes sense because it's a conflict of interest. All y'all know each other. Y'all don't need to be the ones investigating this case. Let another police department take care of this.
So is that in his statement that I've had copies of?
It is not in the video statement that we moved to sanction him for. It was a previous statement that he issued.
All right, so get that to me, okay?
That's fine, Your Honor. So the question is, why was Chief Berkowitz inserting himself into this case almost immediately? United States Attorney Joshua Levy questioned Higgins about that in the federal grand jury. He summarized the phone records in their possession, records the feds have that we do not, records we're asking this court to order so that both parties in this case can review them. Mr. Levy directed a question to Mr. Higgins in the grand jury where he asked about all of the back and forth between him and Brian Albert and Chief Berkowitz.
And
Quote,
Chief Berkowitz.
You have a 3-minute call with Berkowitz at 7:22 in the morning. This is on January 29th. Another call with him then you have a call with Brian Albert that afternoon for 12 minutes. Another call with him for 6 minutes. Another call for a minute. Then another call with Albert for 10 minutes. Then a call with Berkowitz for 4 minutes. Higgins.
Sounds like a lot of relaying. Sound like Berkowitz speaking to one. All right, I'm gonna call you back. Call the other, speak to that one. All right, I'm gonna call you back. Call this one again. All right, I just spoke to him. All right, let me call you back. All right. And then call the other one like, yeah, I just got off the phone with him. All right, let me call you back. I just spoke to him again. That's what it sounded like Berkowitz was over there doing. Listen to the 1 minute, it sounded like he was doing some message relaying.
With Berkowitz at 7:22 in the morning. This was on January 29th. Another call with him for, then you have a call with Brian Albert that afternoon for 12 minutes. Another call with him for 6 minutes. Another call for a minute. Then another call with Albert for 10 minutes. Then a call with Berkowitz for 4 minutes. Higgins spoke with Berkowitz on January 29th, someone who was conflicted out of the investigation 4 times. And then they spoke many additional times between January 29th and February 4th.
But Higgins had nothing to do with the investigation, correct?
He was a witness in the investigation.
Okay, at that point,
We have a chief of police who's supposedly...
I'm sorry, I just need to, so at that point you say he was a witness?
I'm sorry?
At that point, the point of the phone calls, he was a witness?
Yes, he was in the home, Your Honor.
Okay.
He was not spoken to by investigators yet, but clearly he's a witness. He was at the home that night. Now, recall that Chief Berkowitz supposedly found a piece of taillight on Brian Albert's lawn on February 4th. After that lawn had been searched by trained investigators and other police officers multiple times without finding it. But somehow, Chief Berkowitz was able to spot that piece of taillight while he was driving past the property from his moving vehicle.
Why this thing sounds so clear that something's wrong here? I mean, it just sounds, the trial ain't even officially started. And it just sounds like something's completely wrong here.
And the phone records show that Berkowitz called Higgins that very day to tell him about the discovery, and then Higgins calls Brian Albert to tell him. In a case where we are alleging as part of our defense that there is a third-party culprit, and at least some people are involved in a conspiracy to cover up the guilt of that third-party culprit or culprits, contact between
I would have to agree, sir. It sounds like that. From what you're presenting, sir, it sounds like that.
conspirators could not be more relevant. Before the feds got involved, we fought for this information, but we were largely unsuccessful. Although we never had to prove that the phone records actually contained evidence of the conspiracy. That's something we couldn't do without having the records themselves. This court has previously ruled that it was all too speculative. Not anymore.
Right.
Not now. Not after we know that the records exist. Not after we know they prove what we suspected that they would prove. We now know that those records will tell a story that could not be more relevant to this case and to our defense. And the problem, Your Honor, is we know the records are there. We have them in summary fashion, but we don't have them in admissible form. The feds have revealed that they exist, but they haven't released the actual records to us. They have them. We don't have them.
Wow. Yeah, but you know, once the feds involved, they got all the resources, all the tools. They gonna get that information. They gonna get that information. But they'll tell you what you need to know, but they're not gonna give you what you need to show it in court. Man. Listen. I'll tell you this. The records say exactly what you said. However, that's all I can give you. That's all I can give you, man. That's the FBI. The FBI, like, listen, I'll tell you what it say, but bro, I'm staying out of that part where I gotta give it to you so you can go lock them up with it. Nah. I'm gonna tell you what you need, and you see what you can do with that. All right? I'll confirm that it say that, but I'm not giving you that stuff for you to bring into court. Okay.
That's why we're filing this Rule 17 motion. And again, we've more than met the requirements of Lampron. These records are relevant to our defense because they show suspicious contact between parties we allege to be in a conspiracy. They're relevant because they show the Canton police chief inserting himself into a case when it was previously determined that he was conflicted out. They're relevant because they impeach the credibility of Commonwealth witnesses who denied talking to each other, yet have no explanation for these records, which again, do not lie. We cannot get the records any other way. We cannot effectively prepare for trial without these records. The Commonwealth could have gotten them, but they chose not to. They fought our efforts to get them. But again, thank God, another law enforcement agency stepped in and did what the DA should have done. Going to trial without these records would violate my client's due process rights.
That's
and finally,
fact.
to the extent that this court previously...
That's a fact. If she didn't get those records, she'd be done probably, bro. How would she be able to cast doubt in the juror's mind if they can't show that? This is cops. Your word against theirs, are you done? If it's your word against the police word, then man, you might as well just forget it. So if you're going to have to prove that. So without that kind of proof, and then you just going up with your credibility against theirs, please.
That our requests were a fishing expedition. We can't maintain that now with a straight face. We now have the receipts. It's confirmed we were never on a fishing expedition. We were merely on an expedition to obtain relevant material and exculpatory evidence, and we're simply on a mission to defend our client, and I would ask the court to allow this motion.
All right, thank you very much. Mr. Lally?
Great argument.
So, Your
bro.
Honor, the Commonwealth does not object to this motion. The only question or clarification that I'd ask for is there seems to be a discrepancy in the dates that I'm not really finding any support for within the context of the motion. So
That's why I asked. So
my question was a different one as to the dates, though. So when it directed towards individual people, it's a time period beginning on January 29th. When it's directed towards the cell phone carriers or providers, it begins with a period on January 28th, which is the day prior to anything occurring. So
Okay. It's very important to get the dates. You know, them lawyers be thinking they slick. They'll just give you the general information, but the specifics actually changes the dynamic. So,
I'm not sure why anything on the 28th has any relevancy. There's nothing in the motion that I can glean.
oh, that's what he was doing? He was bringing up stuff from before that? Oh, come on, lawyer. Come on, lawyer. Stop playing.
That indicates that. I don't know if it's a Scrivener's error or if there's some other reason for that period for those providers to be starting a day early.
what do you say about that, Mr. Yannetti? Your affidavit says the 29th.
Right. I would orally amend that to the 29th, Your Honor. We're fine with that.
Okay.
All right. I'm going to hear from the third party
All right,
counsel
so
if
I guess
they
that 28th stuff was stuff that they didn't need but got. So he's like, man, I don't need that. Give me, man. All right, disregard that 28th stuff.
want to be heard.
Your Honor, if I may, just one further thing. I did speak with counsel. It's Attorney Kenneth Anderson, who represents Mr. Berkowitz. There's no objection on behalf of his client.
Okay, thank you. All right, so Mr. Conley?
Yes, thank you, Your Honor. Your Honor, with respect to our general arguments, we'll just rest on what I said previously, and we respect the parties' positions. I just want to point out one thing with respect to the factual assertion. I don't have the privilege of seeing the grand jury testimony, but I can represent to the court that before my client ever testified at the grand jury, he voluntarily appeared for an interview with the U.S. Attorney's Office. I attended that interview, and at that interview, he volunteered to the U.S. Attorney's Office that that morning he spoke to both Albert and Berkowitz. He was not asked and did not give a rundown of how many times, but he acknowledged long before he testified at the grand jury that he did speak with both of them that day. I don't think that impacts the substance of the arguments, but I just wanted to note that.
Okay, so just
So,
I'm clear, the Commonwealth hasn't objected to these records for that period of time that appears to be relevant time period.
And so I will waive argument on that, Your Honor.
All right, and does
man, get
counsel
outta here. Nobody cares
object
about
to
that.
these records? Mr. Henning on behalf of Brian Albert? All right, and counsel on behalf of, oh, that doesn't concern you. Okay.
all
right.
man, that don't change
Thank you.
nothing.
Defendant file, Mr.
He just brought some irrelevant information cause it don't change nothing that man said.
Yannetti, you filed a motion that I just got as I was walking out here.
Right. We're not asking to be heard on that motion. I had alerted your clerk that it would be coming. It's filed with a motion to impound as well. I figured I would hand deliver it today.
Okay,
The
great.
Commonwealth just got it today, so they'll need time to assess that.
All right, so today, all pre-trial, non-evidentiary motions have to be filed pursuant to
Yes.
the order.
Yes.
All right, so this is it? This is what
No, I expect by the end of the business today, the court will be receiving a motion to dismiss to be heard next week as well.
All right, and you can't be here next week.
I cannot, and on that point, Your Honor, I think the court probably was alerted that we filed a second motion to admit counsel from California, Pro Hoc Vice. I don't know that it's necessary, but
I'm glad you filed it because I think it is. If you're not here and you have to be here
that's
for
why we
that,
did-
so
that's why we did that, so,
Ms. Yannetti, I'll allow that motion now that you have filed your appearance.
thank you so much.
Okay. All right. So you expect that there will be more motions coming today?
I expect there'll be one additional motion coming today.
All right. Does the Commonwealth have anything that it expects to be filing by the end of today?
Your Honor, just filed a motion for reciprocal discovery. I'm not asking for any action on it, but I believe that would be it.
Okay. And I have one question. Are we all done with Bodie Labs? Have you received the information from them?
So on one part of the testing, yes. On the second piece of the testing, no.
All right. So I need a report on that orally on Tuesday.
Sure.
Where we are with that. All right. Great. I'll see everyone Tuesday. Thank you.
Your Honor.
Thank you.
26 now.
All right. Moving on. Moving right along. So they had another one.
Good morning, Mr. Yannetti. Good morning, Ms. Reed. All right, so to begin, and I have all the motions in limine. I'll talk about how exactly we'll go through them in a minute. But first, so in reviewing the motions in limine, I mean, clearly the defendant has an absolute right, a constitutional right, to present a third-party culprit defense, but counsel is well aware that that is not without limit, right?
Okay. So they trying to introduce that third-party culprit defense saying that, yo, the real killer is out there. Y'all need to look for them. Okay.
from the case law. Now, the defendant has stood here, defense counsel has stood in this court repeatedly, stood here and in other venues and in their pleadings, espousing various third-party culprit theories or scenarios. But now that it's time to actually try the case in the courtroom, I don't have a motion from the defense to admit third-party culprit testimony. So, and as you're well aware, I have to make findings before any mention of any third-party culprit evidence or even an opening goes before the jurors. You know, in order to admit it, given that I have no information at all, I mean, I don't know who the third-party culprit is, even after reading 4,500 pages of discovery. I don't know what motive a third-party culprit might have. I don't know how it's relevant. I don't know if it's remote or if it's current.
Ah, man. I mean, there is evidence of something, some kind. I guess they don't have enough. But you know, I mean, with these courts, you got to get the evidence.
The evidence is going to show.
You know, you got to get the evidence for real, man. You see how hard it is? Even though you got this theory, still, you got to get them more because they need more to just... I got you.
I don't know if it's speculative or if it's relevant. I don't know if it will prejudice or confuse the jury. And if it's hearsay, I have a whole other series of factors I have to consider. So, Ms. Giannetti, are you pursuing a third-party culprit defense?
We are, Your Honor, and I'm prepared to address that. The Commonwealth has raised the issue, and I am prepared to address that today.
So you filed your motions first, and you did not raise it. So if the Commonwealth had not raised it, you did not move to introduce it, correct? I have no motion from...
No, I understand, Your Honor. If you'd like something in writing for us, we can do that.
Of
I have
course.
a full argument prepared.
All right, so who is the third-party culprit?
We are under no obligation to name any specific third-party culprit.
Boy, it's a dangerous one. Boy, if he drop a name right now, he in trouble. That judge try to get him. He's like, come on, judge. You know damn well I can't say. He said, we are in no... He like, come on, judge. We in no position to be doing that. What's wrong with you, judge? Yo, the judge trying to get him to say it. Judge crazy. Hell no, he ain't saying that.
Argument prepared.
All right, so who is the third-party culprit?
We are under no obligation to name any specific third-party culprit.
How am I supposed... So you're prepared to argue all this?
I'm prepared to argue it, Judge.
All right, so we will get to that when we get to the Commonwealth's motion.
That's fine.
Now, the second thing I want to address, because again, it's very important at this point, the motion regarding the DNA, regarding excluding the DNA. Mr. Lally, why should I not allow that motion?
For a couple of reasons, Your Honor. Number one, what I can provide to the court by way of update is that most of the testing with regard to that item is complete. So first and foremost, the item is hair. That was confirmed by the Bodie testing prior to them conducting any sort of mitochondrial testing. The mitochondrial profile, the partial profile that was generated in regard to the hair sample is complete. The mitochondrial DNA profile in regard to Mr. O'Keefe's sample is complete. The preliminary analysis that I received by way of email from Bodie yesterday indicated that they were consistent with each other. I asked for some sort of preliminary report or something that I could share with counsel based on their lab's accreditation. That does not permit them to release anything by way of a report prior to it going through a full review process. My understanding is that not only that process, but the entire lab file should be produced by Tuesday. On top of that, what I would state as far as any sort of prejudice the defendant appears that they've suffered as a result of that, there is still zero reciprocal discovery that I've received in regard to anything from counsel. And then part of the delay, at least a portion of the delay in this specific testing, as the court is aware, as you've had a chance to review Bodie Technologies' observance policy as far as outside experts, there was a significant delay in hearing from counsel and for the defendant in regard to whether or not they wish to have someone present prior to...
How long a delay?
I believe it was at least several weeks, if not a month. I mean, we spoke about it in person in December, and I don't believe that...
My order was in November.
Correct. So when we received your order was in November. What took a little time on our part was to get the samples taken from the troopers in regard to the other testing, and in order to get all of those items shipped and transported from the MSPCL to Lorton, Virginia to Bodie.
When was that done?
Late November.
Go ahead.
And then there was a evidence viewing, which both counsel attended. We spoke about it there. I think that was December 1st. And then waited a few weeks, never heard back, followed up on it, and eventually heard back with regard to them not wishing to have anybody present for that.
When was that?
I don't have a specific date offhand, but...
I need you to find it.
I can.
All right, so I didn't know that the defendant decided not to have somebody there.
Right.
And that prolonged it? They weren't able to go forward, right?
Yes.
How long will it take you to find that information?
Shouldn't take too long. I would need to check my email.
All right, I'm going to take a 5-minute recess.
Thank you.
We mind that Mr. Lau.
The information.
Yes.
All right. and the defendant's asking me to exclude this in part because of the late disclosure of the information.
Yes.
All right, I'll hear from the defense on this, and then I'll give you an opportunity to address it, Mr. Lally. All right.
Thank you, Your Honor. I'd first like to address the timeline that Mr. Lally has just explained to the court. First of all, we were not made aware that we were allowed to test based on Bodie's protocols and procedures until December 1st. We were given a letter saying it would cost $21,000 for our expert to sit in on that testing. We reviewed that letter. We told Mr. Lally that it was most likely we were not going to have someone independently watch the.
I don't know. She sounds like she ready to cry. She sounds like she ready to cry.
Testing because of the price.
When was that?
December 1st.
When? December 1st?
On December 1st.
Okay.
We confirmed that in writing when he emailed us again on December 22nd. And I would note for the court that Bodie did not receive the hair from the Commonwealth until January 11th.
Okay.
So there was no delay on our part. As the court knows, to date we have received no reports from the Commonwealth regarding Bodie Technologies' analysis of the DNA. The Commonwealth has engaged in repeated and inexcusable delays regarding the testing of this particular item of evidence, which at this point is sanctionable. The hair has been in law enforcement custody for more than 2 years, Your Honor. On February 1st, 2022, Massachusetts State Police criminalist Maureen Hartnett purportedly recovered a hair from the bumper of Ms. Reed's vehicle. For a full year, the Commonwealth did nothing. Finally, on March 6, 2023, criminalist Maureen Hartnett got around for the first time.
Sorry, criminalist department? Is that what you said?
Criminalist Maureen Hartnett.
Okay, yes.
Got around to conducting a visual inspection of that hair for the very first time. On March 6, 2023, she opined that it appeared to be human. However, subsequent discovery produced by the Commonwealth revealed that she had failed her proficiency test in that precise subject matter only 1 month prior. Then, on August 25th, 2023, the Commonwealth submitted that hair to the Massachusetts State Police lab for DNA testing, and it was forensically determined that no human DNA was detected. Almost 6 months later, the Commonwealth made their third attempt to find evidence establishing that the hair was somehow probative in this case. It is now 4 days before trial, and we were told that we're going to receive this on the day trial is set to begin. Pursuant to Massachusetts Rule of Criminal Procedure 14C, subdivisions 1 and 2, the court has the discretion to exclude evidence based on the Commonwealth's failure to comply with its discovery obligations. There's no excuse for a 2-year delay. We immediately conferred with counsel when he notified us as to what the requirements were going to be if we decided to have an expert present for testing. We got back to him the day that he emailed us following up about that, and they didn't even bother sending the hair to the lab until weeks later. So I don't think it's fair to blame the defense for a 2-year delay in this regard. As the court may know from the notices of discovery, we've received an overwhelming amount of evidence. This week, last week, the week before that, we're on the eve of trial. It is not fair to throw at us yet another item of evidence that we have to retain an expert to assess. We have to review, we have to make tactical decisions. That's not a fair position to put the defense in. We've been asking for a continuance. I think the only fair thing if the court is going to force us to go to trial is to exclude this evidence.
Okay, thank you very much.
Thank you, Your Honor.
Mr. Lally?
Yes, Your Honor. Again, not faulting counsel for any sort of 2-year delay period, but there was a period of time, given sort of the close nature of when the Commonwealth is receiving this information, that a couple weeks, or a few weeks in this case, do matter. The other point I would make as far as, again, as far as the defendant being prejudiced, this isn't evidence that I anticipate introducing in the first day, the first week, or probably not even the first month of trial. So whatever time counsel needs in order to retain an expert, run that by an expert, run that by one of their experts they already have, I don't know that, whether or not they have any experts, because again, I don't have anything from them. So as far as ample time, I would submit that there's more than sufficient time once the report is received for counsel to make use of it in whichever way they deem appropriate. And for that reason, and I'm certainly not asking the court to continue the trial date, but for that reason, I would ask that the motion to exclude be denied, absent any prejudice to the defendant.
All right, so I'm going to take this under advisement. And I may as well tell you that the best way, I think, for us to proceed with the rest of these motions is because they were filed so late, which I understand they were filed, just to be clear, I know they were filed by the deadlines, but so close to trial, I don't have written oppositions, really, unless you both raised independently the same issue. So what I will do this morning is my intention is to hear from counsel, to hear at least from the other side, if the motion itself is clear enough, but to hear from counsel. Then we'll take a break, and at 2 o'clock, we'll come back, and anything I can decide, because I know you're preparing this weekend to go to trial on Tuesday, anything I can decide by this afternoon, I will. Anything that I cannot, I will let you know. And then we'll do housekeeping, which I consider, including, though it's certainly a very important part of the case, jury voir dire in that.
Yeah, it's sped up a little bit.
So that will come at the end of, that will come this afternoon. So starting with the view.
Your Honor, I was just going to notify the court, to your discretion, there are a number of motions that will be unopposed. I don't know if
All right, so what I'm going to do with that is the Commonwealth filed a very helpful list of what their numbers. We have, of course, the paper number, the docketed number. So when I get to that, we'll just go through those quickly.
Whatever the court wishes.
All right, I appreciate that. So you, well, I'm probably starting with one. You could have saved yourselves time in writing the motion regarding the view because you both want a view. I will conduct a view. You need to talk because you have different locations.
Yeah, and you know, we've, upon consideration, Your Honor, the Commonwealth has asked for a view of 34 Fairview Road. We would be satisfied with a view.
So you don't need to go to the waterfall?
I think that we can just agree to go to that one location.
All right, so you all figure out the view. I am going to take under advisement your request of the defendant coming with us. You know that there are all sorts of things I have to consider before deciding that.
Thank you.
So that part is under advisement. Before the end of today, figure out exactly what you want to do with the view. Mr. Lally, your office will provide state police escort for that view?
Yes, Your Honor.
Okay. All right, now court officers, Chief Rose usually gets the bus. So, all right, so for that. So the defendant's motion, it's our paper 283. Defendant's motion eliminate to exclude irrelevant, inadmissible, and prejudicial prior bad character and propensity evidence. So I'll hear whoever's arguing that for the Commonwealth. The Aruba incident, if you will. I mean, I'm sorry, who's arguing for the defense? That's what I'll hear from.
I am, Your Honor.
Okay.
Thank you.
You say 282?
283.
282.
Oh, this is all backwards. Pauline did this for me. All right, thank you.
Thank you, Your Honor. The Commonwealth seeks to admit irrelevant, inadmissible, and prejudicial prior bad character and propensity evidence against Ms. Reed by admitting inflammatory evidence of an event that purportedly transpired in Aruba on December 31st, 2021. As the court knows, this type of propensity evidence is extraordinarily prejudicial and serves no purpose other than to assassinate Ms. Reed's character in the eyes of the jury. The Commonwealth has put forth no reliable evidence to suggest that the incident that occurred in Aruba on New Year's Eve has anything whatsoever to do with O'Keefe's death, or that this remote and isolated incident was even a point of contention in their relationship at the time in question. And we aren't left guessing, Your Honor. All of the witnesses who were present at the Waterfall Bar and Grill on January 29th, 2022, along with high-quality video surveillance footage from that night, established that Ms. Reed and Mr. O'Keefe were happy, they were in good spirits, they were getting along. There is no evidence to suggest that this incident had anything to do with the facts at issue in this case. The Commonwealth points to purported angry voicemails left on the decedent's voicemail to suggest that there was some sort of hostile relationship between Ms. Reed and Mr. O'Keefe that night. However, these voicemails were left after Ms. Reed dropped O'Keefe off at Brian Albert's residence, and after he failed to come back outside to meet her. There is no logical relationship between the prior bad acts evidence in this case that the Commonwealth seeks to admit and the crime charged here, and therefore this evidence must be excluded.
Okay, come on.
Yes, Your Honor. So this also relates to Commonwealth's motion to eliminate number 20.
Yes.
So in regard to that, Your Honor, this is highly relevant evidence as it pertains to motive and as it pertains to the nature of the relationship between Mr. O'Keefe and Ms. Reed, which goes to motive, it goes to absence of accident, goes to motive, absence of mistake. And this is not a, as the defendant seems to continuously try to pose it as some sort of temporary or isolated incident. This isn't just the argument or the yelling of swears between the defendant and Ms. Sullivan in the lobby in Aruba. This then leads to an argument which both children indicate in their statements continued inside the room in front of them for about 20 minutes after it happened. This is also not a fleeting reference in the sense that the defendant continuously brings it up on her own, specifically in text communications with Mr. Higgins when she's talking about the nature of their relationship. And it's not just the voicemails that the defendant leaves on Mr. O'Keefe's phone after the murder occurs in front of 34 Fairview. It's also text messages exchanged between the two of them in the days leading up to that, in which they discuss the nature of their relationship. You also have statements from the children which indicate that the victim had tried to break up with the defendant multiple times in front of them, asked her to leave the home and she refused. You also have a text communication from Mr. O'Keefe to Ms. Reed in which he indicates that he thinks that their relationship is essentially...
What was the date of that one?
I believe that was the 28th. Then there's other text messages from the defendant to Mr. O'Keefe referring to their relationship between themselves and with the children as toxic. These are further statements regarding infidelity which continue on to the morning of, in which statements that she makes in the backseat of the vehicle with Ms. McCabe and Ms. Roberts as they're looking for Mr. O'Keefe just prior to locating his body on the front lawn of 34 Fairview. These are statements regarding her belief in Mr. O'Keefe's infidelity that she repeats again when she's having her recorded interview with Ms. Voss from Boston Magazine. These are not isolated statements. These are not just one time 4 weeks prior. It's not too remote in time, and it does show sort of the nature of the relationship and as it's evolving over the course of that month from the date of the incident in Aruba all the way through until the date that Mr. O'Keefe is killed. In furtherance of that, also, there were statements that the defendant makes to paramedics when she's being treated on scene, that the last time that she saw Mr. O'Keefe, they got into a fight or an argument, and she's upset because that's the last time that they spoke was during the course of a fight or an argument in front of the house on Fairview Road. So it literally continues from the Aruba incident all the way through to the murder's occurrence. So for those reasons, the Commonwealth would submit that it is relevant as to motive, it is relevant as to absence of accident, and it is relevant as to absence of mistake. Thank you.
All right. What I will need is exactly what the Commonwealth intends to introduce. I think you've outlined it, and I'm familiar with it. If I admit it, that would certainly be accompanied by very strong curative instructions, which you know is my right. I've heard argument now. I'm going to think about this and maybe decide it by this afternoon. But
thank you.
Okay. All right, so you were both in agreement on what's the defendant's motion to exclude irrelevant and prejudicial evidence regarding alleged harassment and or intimidation of a witness, and the Commonwealth's for different grounds and different scope, actually. Motion to exclude mention of Aiden Kearney, a.k.a. Turtle Boy, and his pending criminal charges for witness intimidation. So, though you both agree it's out, that doesn't necessarily mean that I agree with you that it should be out. I understand that the nature of the harassment, mindful of the grand jury minutes that I've read, that in response to some of the questions posed by those at the U.S. Attorney's Office, the answers explained away some conduct as a result of the extraordinary harassment witnesses were undergoing. So I'm not sure I agree with you. So go ahead and try and persuade me, but what I'm inclined to do is keep it out in the case in chief. But Kamala said you told your witnesses not to discuss it. Oh. So I'll hear the defendant.
Shit. Let's hear this.
I guess I would start, Your Honor, by saying that in order for evidence to come in, it has to be elicited by a party. It has to be offered by a party. You're being told that the Commonwealth does not intend to elicit this evidence and that the defense does not intend to elicit this evidence. So I guess the question that I would direct to the court is, do you intend to follow up with questions?
I'm not questioning the jury. It's clear that it may be a response, a natural response by a witness that neither one of you intended to get as a reason for something, that I'm not going to sanction the witness because I allowed the Commonwealth's motion.
Sure. So
Ms. Gianetti, yes. So it's clearly you try your case the way you want to try your case, and the Commonwealth decides how they want to do it. But I am not tying the hands of witnesses to natural responses to questions. So I'm taking this under advisement. If you open the door, it comes in.
Well, I completely understand that, Your Honor. I will say that I think probably, I don't want to speak for Mr. Lally, but I think...
So don't speak for Mr. Lally.
I'll speak for myself then, if the court will allow me, which is that if a witness opens the door to a further explanation of this, that could give rise to both sides exploring that, which, I suppose we'll deal with that when it comes to it.
The way the motion's written,
well, there you go.
It would be prohibited, and witnesses, I'm not tying the hands of witnesses to natural answers that are the result of questions asked by counsel.
Right, understood.
All right, so deny that.
Do you understand that, Mr.
Motion
Lally?
denied.
Absolutely, Your Honor. And that was not my intent. If
How the motion reads, your motion reads, Mr. Lally.
I understand. But it was more of a notice that the Commonwealth doesn't seek to introduce any evidence of that. But at the same time, obviously, if the truthful and honest answer to a question that's posed of a witness references that, then I think it comes in.
All right. So I think we're all on the same page. Neither of you intends to introduce this in your cases, but if you open the door, or if it's a natural response from a witness, it comes in.
That door.
Okay. All right. So, Jim, is 289 defendant's motion eliminated to exclude the plasma, serum plasma, the blood, the alcohol testing, or are my numbers all off?
That's 289.
Yeah. All right. And the Commonwealth has a paragraph or two responding in one of your other motions. So I will hear the defendant on the motion regarding the testing of the blood from the hospital for the alcohol levels.
Thank you, Your Honor. I'll be addressing this with the court's permission. This is number, just so we could be clear in my head, I had named this number 17, dealing with the retrograde extrapolation.
Okay, we don't have it as 17 anywhere.
I thought that was the list that the helpful list that the Commonwealth.
Oh, okay. So our number is 289.
Right. Okay. So.
And the Commonwealth's one paragraph response is 17, but you filed the motion, so why don't we hear from you as the moving party?
Thank you. So the Commonwealth wishes to have Ms. Reed's retrograde extrapolation records admitted over, naturally, a hearsay objection, because the Commonwealth, their position is that they are medical records. The Commonwealth misapprehends the definition, the base definition of what a medical record is. A medical record, as the court well knows, holds a very special place in the evidence code, and that's because it's not compiled in anticipation of litigation. And for that reason and that reason only, they're deemed non-testimonial and not subject to Crawford and the defendant's right to confront and cross-examine witnesses or the experts behind the reports. Medical records are different than what we have here. The extrapolation records we have here are not medical records that were generated for treatment or Ms. Reed's medical history. they're the opposite. Those records were generated specifically in anticipation of litigation and in association with this criminal investigation. Thus, they are rank hearsay. The Commonwealth claims that the records are not produced in anticipation of litigation, stating basically that during her hospitalization, law enforcement was at the, quote, beginning stages of their investigation. But what the Commonwealth fails to mention or address is that at approximately 6:30 a.m. on a dash cam video, an Officer Good, as a matter of fact, a Canton police officer, states to Detective Blank that he is going to, quote unquote, section her, which the court knows what that phrase means. He's going to place a hold on her medically. Thus, the clear intent of law enforcement hours before the blood draw was actually taken was to keep her under law enforcement's thumb as she was an immediate suspect. But there's a bigger issue, Your Honor, and that is that the parties lack the essential, both, and by the way, this goes to the Commonwealth as well, the Commonwealth, but more importantly, the defense, we all lack the essential information on how the blood was actually drawn and tested. Those standardized protocols that we all get used to in the average OUI case, drunk driving case, they don't exist here. The standardized protocols for reliable testing, they're tried and true, and every one of those protocols is missing, or are missing, and that leaves the defense having to sort of guess at the validity of the underlying test, and the validity of the underlying test is the foundation on which the extrapolation is made, which is the only thing the Commonwealth really cares about. They don't care about the underlying test, they care about extrapolating backward several hours. But this sort of goes along the theme of garbage in, garbage out. If the underlying test was not valid, or it can't be proven to be valid, then, of course, the extrapolation is also invalid. The question remaining is, was the testing done by gas chromatography? Was it enzymatic testing? We don't know, and we'll never find out. We don't have reports to suggest that, or exactly what the validity of those tests were. So the initial result is suspect, and by extension, the extrapolation is also suspect. It bears pointing out, Your Honor, and this is the only sort of granular detail I want to get into, the extrapolation, according to the Commonwealth's expert, is somewhere between 0.13 and 0.29 blood alcohol concentration. That is a swing of more than 123%. In other words, the swing of the extrapolation is larger than any one of the numbers themselves, which means it simply cannot be reliable. It illustrates the invalidity of the underlying serum plasma test, and for those reasons, the defense objects to the admission of both the blood test, the underlying test, as well as the concomitant extrapolation.
Okay, thank you. Come on.
Your Honor, so what the Commonwealth would submit is this may have been a valid basis for a motion to suppress, but it was a motion to suppress that was never filed, and one that the defendant specifically waived, that Mr. Yannetti waived all motions to suppress. As it pertains to Mr. Roberts from the Office of Alcohol Testing's testimony regarding the serum conversion and the retrograde extrapolation, the reason for the range is because it's math, and essentially taking into account a number of different variables. That is why the range is as it is. As it pertains to the specific item that would be introduced into evidence, meaning the defendant's medical records, that's what the Commonwealth is referring to as the records coming in. Mr. Roberts would come in and testify as to his own analysis, his mathematical calculations, and the results based on his training and experience, which the defendant has had for over 2 years, as Mr. Roberts testified at the grand jury to that exact set of scenarios. As it pertains to the testing itself, the Commonwealth, as indicated on its proposed final pretrial memorandum, has summoned in not only the doctor who ordered the testing, the registered nurse, the nurse practitioner, who would both have been involved in the taking of the sample from the defendant pursuant to her medical treatment and medical diagnoses, as well as the director of the lab at Good Samaritan Medical Center, who would testify as to what kind of testing is done and the nature of that testing and everything else. As it pertains to those witnesses, if the defendant wishes to conduct some sort of voir dire prior to the testimony in front of the jury, I certainly have no objection to that. But any sort of voir dire of Mr. Roberts or exclusion of his testimony would be inappropriate based on the fact that the defendant has had more than ample notice as to what the parameters of that testimony would be. So as far as what would be coming in as an exhibit, it would be the medical records with that amount in it, and it would be testimony from essentially anyone and everyone involved in the ordering, taking, and analyzing of that particular sample, which then provides the basis for Mr. Roberts' testimony.
Okay. So I have like one small paragraph from the Commonwealth on this. I want a memo on this.
Sure.
All right, so I'll take this under advisement.
EM 17. There's 17.
Yeah, there's 17 we still need to address some of. All right. So that's all of the defendant's motions eliminated, correct, Mr. Yannetti?
Just a moment.
Mr. Jackson, it's all of them, isn't it?
We filed a motion for attorney-conducted panel voir dire.
Yeah, that's a joint motion, and that's I already said we're going to talk about impanelment this afternoon.
That's being complete in answer to the court's question. That was one that was not addressed, but that's fine.
All right. Oh, the request just to have panel, your motion was a little bit confusing.
Right.
So you want panel voir dire?
Panel voir dire, correct.
I'm not going to do panel voir dire in this case. So we'll talk about the particulars of it later this afternoon. All right, so on the Commonwealth's list of motions, you said that there are some that you may agree with. What besides the view? Are there any of these numbers?
Yes, Your Honor. The defense does not object to the Commonwealth's motions in limine numbers 1 through 6. Number 8.
1 through 6?
Yes, number 8. Number 9. Number 11, we obviously joined in that request.
Yes.
Let's see. Number 14, we do not object to. Number 15, we have no objection in principle, but we do reserve the right to object to just individual exhibits as they come.
Yep.
Number 18, we have no objection. Number 19, we have no objection. Number 23, no objection. Number 26, no objection. I believe the court
That's
did
the one we
address
addressed, yeah.
And number 32, we have no objection.
All right, thank you. All right, Mr. Lally, I will hear you on our paper 297, your number 7.
So, Your Honor, this is the Commonwealth's motion to preclude reference and redact the manner of death contained on the victim's death certificate. This is a routine motion the Commonwealth files in really respect to any case. Manner of death.
That's not persuasive, so go ahead.
No. I'm just manner of death as elucidated in the motion is not something that is typically something that is permissible to be testified to from anybody to the jury, because that's sort of the question of liability ultimately that is left to their discretion as far as how they find the facts. But cause of death obviously is something that is a medical determination. Manner of death, as the court is well aware, is there are essentially 3 or 4 different selections, and they fall into different categories. They don't necessarily mean in the medical context what they might mean in the legal context. So for that just sort of simple differentiation of meaning between the two, manner of death is not something that the Commonwealth feels is appropriate for the court, for any witness to be testifying to as far as the jury is concerned, as that's a question for them ultimately to determine. For those reasons, the Commonwealth would ask that this motion be allowed.
All right, who's responding to this?
Thank you, Your Honor. The medical examiner who completed the death certificate in this case concluded that the manner of death was undetermined. The Commonwealth now seeks to have that portion of the death certificate redacted because it is quite clearly exculpatory. All of the cases cited by the Commonwealth deal with the issue of whether it was error for the Commonwealth to admit a death certificate listing the manner of death as a homicide, because it violates a defendant's right to due process and a fair trial under the 5th, 16th, and 14th Amendments to the United States Constitutions. None of the cases cited by the Commonwealth stand for the proposition that a medical examiner's determination that the manner of death is undetermined should be redacted. In fact, the Commonwealth cites Commonwealth versus Ellis at 373, Mass 1, it's a 1977 case, for the proposition that excluding the word undetermined is the better and safer course. But that's a misstatement of the law, and I would urge the court to read the Supreme Judicial Court's opinion in that case. What it actually says is this, quote, "Nothing contained in the record of a death which has reference to the question of liability for causing death shall be admissible in evidence. The better and safer course is to exclude from a death certificate the words homicide, suicide, or accident in a criminal trial. Notably missing from that list of words that the Supreme Judicial Court warned about is the word undetermined. That is what the Commonwealth seeks to have redacted here. The Commonwealth bears the burden of proof in this case. They have to prove beyond a reasonable doubt that a homicide occurred, and their own medical examiner has opined that she was unable to make that determination. That finding is relevant, it's exculpatory, and there's no authority that supports its redaction. Thank you.
Thank you. Oh man, round of applause for her. That sounded good. That's a hey. That was convincing. That was very convincing.
The medical examiner will be on your witness list, right? I haven't seen either of your witness list.
Yes, Your Honor.
Okay, so I'll take this under advisement.
Hey, that was pretty good.
All right, Mr. Lally, you're number 10, our number 300.
Yes, Your Honor. In this motion, the Commonwealth is simply seeking to obtain CORI information or records of potential jurors. I'm not looking for information pertaining to jurors that, as they come in, or some voluminous amounts of every possible potential juror, but only seated jurors. And essentially, what the Commonwealth is requesting is to simply have some sort of verification that the answers that are provided by the jurors are true and accurate. This is something that is permitted by the case law, it's permitted by the statute, and it's obviously something that the Commonwealth would share with the defense as required to. But the timing of it, of what I'm asking for, and the limited scope that I'm asking for in relation to just seated jurors, once we have a full sort of set of jurors, whether that be 12, 16, whatever the court chooses as far as the number, I'm assuming approximately 16 or so. But once those are seated, the Commonwealth is just asking for some time to run those CORIs and provide those to counsel, and then make any further objections for cause prior to the jury being sworn.
Okay, so I know you're not in agreement. Are you opposing this?
Yes, Your Honor. Your Honor, we object for several reasons. First, the jurors are given a questionnaire which specifically asks this question. They self-report. We rely on self-reporting from jurors with regard to all questions. The Commonwealth has cherry-picked this one question to verify whether or not they're telling the truth without dealing with any of the other questions that the jurors are asked. This proceeding right now, like many of these proceedings, is being broadcast widely, publicly. There are potential jurors out now listening to this, I'm sure, waiting for an answer from the court as to whether or not they will undergo that further invasion of privacy. And they are also, I would submit, aware that in this unusual case, the Commonwealth, through their special prosecutor, has sought to charge picketers, protesters in a very unusual manner. We would claim a harassing manner. And our position is that this is just another method of harassment. We believe it's unfair. We ask the court to deny this motion.
Do you have any case law to support your argument, Mr. Yannetti?
Your Honor, the case law is simply the constitutional rights to privacy that the jurors have. I mean, it's an issue of fairness, Judge. So that's what we're relying on.
All right. So the motion is allowed, Mr. Clerk, number 300.
Thank you.
All right. Mr. Lally, you're coming into number 12 with me quite skeptical. Number 12, leading questions for 13 and 16-year-olds.
And again, Your Honor, let me first start by saying I don't think that this is something that's going to be absolutely necessary, given what I know of the two child witnesses in this case. Only filing it under abundance of caution, more so should the need arise based on less so the age of the child, but the age of the child taken in conjunction or in the context of sort of the atmosphere of testifying specifically in this case, in this courtroom, with different things going on as far as the amount of people and things of that nature. So again, I don't foresee this being an issue, but just an issue that I wanted to flag for the court should it become an issue and seek sort of the court's ruling or permission in regard to it prior to any sort of incident arising.
Okay, given that caveat, is there any objection?
No objection at this point, Your Honor. We can address it as it arises.
Okay. Mr. Lally, keep in mind that jurors would much rather hear from the witnesses than from the Commonwealth.
Of course.
All right. Mr. Clerk, on that, we're just going to withhold ruling. Withhold ruling until a later time. Commonwealth, you'll raise this again if need be.
Yes, sir.
All right. All right. So on your next motion, your number 13, I had it. I don't have it in order. Just give me a minute. So I'm curious, do you happen to have, oh, we don't have the screen up. Do you happen, I'd like to see exactly what it is that you intend to introduce. So this is your motion eliminated to admit evidence that the defendant was in custody for a period of time after her arrest. Jim, is it possible for you to print that for me?
13.
Yes, please. Thank you. Okay. All right, I'll hear you on this, Mr. Lally, and remind me the date that this body cam footage was taken.
So, Your Honor, this is in reference to the defendant's arrest post-indictment by the grand jury in this case. So it's June 9th, 2022.
So that's why I have not seen the video itself.
Correct. And that's certainly something that the Commonwealth can provide for the court. But essentially, when she's arrested and during the booking process at the Milton State Police Barracks, the troopers who conducted that arrest were wearing body-worn camera pursuant to their BWC policy with the state police. Counsel has a copy of the policy, counsel has a copy of the video, and essentially there are a number of different statements which provide sort of third, fourth, fifth, sixth, I'm not sure what number we're up to at this point, of sort of varying accounts that the defendant has provided to numerous people.
Can you give me an idea now? Do you know the substance?
So the substance of these particular statements is the defendant, Ms. Reed, continuously is told by Sergeant Buchanan to essentially stop talking. He's advised her of Miranda and advised her to stop making statements, and repeatedly states that to her during the course of her making statements. But the sum and substance of it is she says something to the effect of, are you in on the joke? And then makes some sort of reference to having witnessed Brian Albert and Colin Albert essentially smash John O'Keefe's head into the taillight, indicating that that's how her taillight was broken. To having witnessed Brian Albert and Colin Albert essentially smash John O'Keefe's head into the taillight, indicating that that's how her taillight was broken. Doesn't make any sort of further statements about why she would then leave the scene after that occurred or anything like that. But these are, again, different accounts that have been made in direct variance to prior statements that she made January 29th to the troopers, to paramedics, to treating medical professionals, to Ms. Roberts, to Ms. McCabe, to the niece of Mr. O'Keefe, to a whole other sort of slew and variety of people with a different sort of variation on what transpired each time. So it's sort of inextricably intertwined with the fact that she's in custody.
How so? Is she in handcuffs? Is she in a cell?
She's seated at the booking desk or the booking rail in the state police barracks. So, I mean, I don't need to make direct reference to it. It's just, again, it's something out of abundance of caution based on sort of where it is and when it is that the statements are made, that it may naturally sort of come out as far as if the court wishes. I think it's something that the court can cure by issuing a curative instruction if there's any prejudice to be suffered by the defendant. But again, it is a statement by the defendant, which is admissible, as the court is well aware. And then it is sort of in the confines or in the context of her being in custody when she makes that statement. I certainly wouldn't be trying to elicit testimony that she was in custody, but it is kind of apparent that she is.
Can you have that here for this afternoon?
Yes, I can arrange for that.
So we can see it?
Sure.
All right, what's the defendant's position here?
We object. Your Honor, we're in a situation now where the Commonwealth arrested Ms. Reed twice when they didn't have to. I made the argument to you at arraignment back in June of 2022 that after John O'Keefe was found dead on the lawn of Brian Albert's home, I immediately got a letter out to the state police saying, I represent her, I will surrender her, no need to arrest her, just call me and I'll bring her in. They ignored that and they arrested her to get her into custody. I would assert ultimately to make the arguments that Mr. Lally's making today. Then, astonishingly to me, after the grand jury issued indictments, based on basically no new evidence, they upcharged her and once again did not contact me, despite the fact that she was completely in compliance with the terms of her release and had made every court appearance. They arrested her again. And so, again, I would assert to be in the position that they are in today. With regard to the case that they cited, Your Honor, Hoffer does not stand for the proposition that they claim that it does. In fact, the issue of that defendant being taken into custody was stricken by the court. The testimony in that case that was allowed or sanctioned by the SJC was evidence that the defendant had been living with his girlfriend but had unexplained absences. He didn't get along with her son. She was afraid of him, and that he associated with a convict that made her nervous. There was nothing about him being in custody that was admitted in that case. To the extent that these statements are, or the court deems these statements to be relevant and admissible, there are other ways to do it. I do urge the court to watch the video.
Yeah, I think we'll put it on the screen because I want to see how the jury would look at it.
Okay, that's fine. But I will suggest, Your Honor, that there are other ways to accomplish that, either to have testimony about what it was, or failing that, to have the audio of my client making whatever statements they seek to introduce without the video. An image of my client, in handcuffs at a police station is what this court generally tries to avoid, given the fact that as she sits here and as this trial is ongoing, she's presumed to be innocent. We wouldn't bring her up here in an orange jumpsuit and then ask the jury to make decisions about her, nor should we display her, after a perp walk at the police station in handcuffs making these statements.
All right, so I need the Commonwealth to, do you have your media person available, Ms. Gilman or Ms. Crawford or whomever?
Yes.
All right,
We're seeking to make arrangements for that.
All right, we'll put it on the screen just so I can see how the jury would see it. All right, thank you. So we'll look at that this afternoon.
Okay.
All right, so I'll hear you on the Celebrate motion, your motion number 16, Mr. Lally.
Thank you, Your Honor. So in this motion, what the Commonwealth is requesting is for permission for the Celebrate expert, Mr. Whiffen, to conduct a demonstration in the courtroom during the course of his testimony in regard to the examination that he did in regard to Ms. McCabe's extraction report, and specifically the alleged search, which the defendant purports occurred at 2:27 in the morning, and the Commonwealth maintains occurred at 6:23 and 6:24.
I'm going to stop you because one question is, how long will this take? If we allow it, how long will the demonstration take?
So really what I'm seeking to do ideally would be for sort of a live demonstration, which I had Mr. Whiffen do and record and provided a copy of that to counsel as well. So that recording that I provided has no audio to it, but there was also a PowerPoint presentation that Mr. Whiffen prepared in relation to the same issue that he produced, and then I provided that to counsel as well, which essentially goes through what he did. And it also—
You're not looking to do a PowerPoint presentation, are you?
No, the PowerPoint presentation would not be something I'd be looking to admit. The reason I did the video is in the event that technology is not our friend on that particular day and the live demonstration doesn't work, I would then be seeking to introduce the video and have him talk about it while it's playing. It mirrors essentially or exactly what Mr. Whiffen had included in his report, which was done back in almost a year ago at this point and has been provided to counsel, is essentially the same thing as what's contained in his report, but just as far as a visual aid and demonstration for the jury. I just think it's a bit, when particularly talking about sort of the technical aspects of his particular analysis, the Commonwealth would submit that it would be helpful and assistive to the jury in order for them to have that sort of visual demonstration to go along with, obviously, the oral testimony of the witness as well.
All right, who's arguing this for the defendant?
Thank you, Your Honor. We received from the Commonwealth the video that Mr. Lally just described about 48 hours ago. So we have not had an opportunity to confer with our expert about that particular issue.
Okay.
However, just from sort of a cursory review, it does appear that its admission is improper. As the Commonwealth acknowledges in its motion, in order for the court to allow a courtroom experiment or reenactment, there are very strict rules concerning that experiment. It has to replicate with exactitude the actual event so that it is fair and informative for the jury. Otherwise, it's prejudicial and would serve only to confuse the jurors. Here, just based on a cursory review, it does not appear that Mr. Whiffen's in-court experiment replicates all of the factors that we know were in existence at the time in question.
Does it replicate the factors that he says he considered?
So I'll need to have a little additional time if the court doesn't mind to confer with my expert.
Yeah, so I will give you time to confer with your expert and file a written response. But that's one of the factors that I'm asking you to look into.
Understood. And then just, if the court does intend, after a written briefing, to consider admitting that evidence, we would ask to be able to take their expert on voir dire as to that particular issue.
Okay.
Thank you.
All right. How much time, Ms. Little, do you think you'd need to confer with your expert and put something in writing?
I believe about a week should be sufficient, Your Honor.
Okay.
Thank you.
And I'm sorry, I neglected to answer the court's question as far as timing. The video demonstration, which is essentially what I'd be asking him to do, is about 19, 20 minutes.
Okay. All right. So, Mr. Clerk, that's under advisement. So what remains on Commonwealth's Motion 17? The statement, so I know this went to the blood draw, but there were statements. That's what separates this from the defense motion to exclude the testing. So I'll hear you on that.
Sure.
Is the defense objecting to that portion of the Commonwealth's motion?
Thank you for that opportunity. Not particularly, no. It's the blood draw and the extraction.
Yeah, so the motion had both. So that's why, all right, so I guess we don't need to hear, so the part of your motion that concerns the statements made by the defendant, the defense is not objecting to.
No, very obviously, they're admissions. Everybody knows what the rules are dealing with admissions. So I'm not concerned about that.
Okay. All right, so Jim, on 307, it's a split. The Commonwealth is permitted to introduce statements made for purposes of medical treatment. And the certified medical records. But there's an objection as to what we've heard regarding the alcohol testing, the blood testing for alcohol. Okay. All right, your number 20, Mr. Lally. Our number
20, Your Honor, I believe, refers back to the same argument that the Commonwealth had made in opposition to the defendant's motion to exclude anything about the nature of the relationship,
okay.
Things of that.
That's why I don't have it right here. Okay. 21, the out-of-court statements regarding the victim's state of mind.
So 21 sort of pertains to that same issue as 20. So essentially, it's the same argument. You're on the same facts underlying it as far as statements that the victim, Mr. O'Keefe, made to.
But were you making statements regarding like bins in those cases, Commonwealth versus bins, the state of mind of the defendant, state of mind of the victim, the defendant knowing it, the defendant being able to act as a result specifically? Okay.
So on that sort of specific application of it, and that's why we filed two separate motions in relation to it. But as it applies to that, the Commonwealth would submit it as clearly met its burden under the case law as it applies to that because of the nature of some of those communications. So it's not just communications that are observed by other parties as far as what the victim, Mr. O'Keefe, indicated to Ms. Reed, or these aren't situations like in some of the case law where it's an indication to a third party and the defendant wasn't present, and then there's sort of an inference that can be made that, well, if they're saying it to this friend of theirs, then they must have communicated that to the person with whom they're in the relationship with. In this instance, Your Honor, we have direct communication between Mr. O'Keefe and Ms. Reed via text communications from each of their phones indicating that communication about ending the relationship was made just prior to the date of his death in this particular case. So it not only enhances what...
So they really trying to push the case that, they was going to break up. That's why she killed him. All right. You're going to have to prove it.
The evidence is going to show.
You're going to have to prove that.
What I would submit is corroborates that testimony from other sources or from other family members and other witnesses. So for those reasons, the Commonwealth would ask that this motion be allowed.
All right.
Your Honor, on this motion, our position is that we'd like more specificity about which statements the Commonwealth is indicating they seek to admit. I imagine
it's the same thing I said to you, Mr. Lally, on the other one that was in connection with this. So the Commonwealth will do that?
Yes, Your Honor.
And I think then at that point we can evaluate it, Your Honor. Certainly some of these statements are going to come in, but we'd like the opportunity to be able to object if they...
No, I agree, so it has to be clearer. So, as far as your notice to the defense, you can even point to grand jury minutes or whatever, but I need to know the statements you intend to introduce.
Understood, Your Honor. And what I can do and what I aim to do to sort of an ancillary thing is I'd like to, if the court is amenable and counsel is amenable, to pre-mark as many exhibits as possible, just to make the situation easier for both sides as far as referencing documents, photographs, videos, things of that nature. So when it comes to, I'm not seeking to introduce, when it comes to any sort of the cell phone extractions, I'm certainly not opposed to admitting the entire extraction dump essentially from anybody's individual phone. But what I'd like to do as far as exhibits are concerned is to print out or create sort of extraction reports from those cell phones as far as different communications between person A, person B, just to make it more simple for the jury to digest it and more simple for, I think, everyone involved to understand sort of the exact communications that we intend to talk about. So in that vein as well, what I can do is provide a supplemental memorandum in regard to 20 and 21, referencing sort of those specific conversations.
Okay, that'd be great. And if you can work together, and this will be part of the housekeeping we talk about this afternoon, work together to pre-mark exhibits, that would be great. All right, so 22.
So again, with respect to 22, and I think the same can probably be said for 23 and 24 and 25, is that essentially, as I've stated earlier, the Commonwealth is somewhat operating in the dark, in that I don't have any discovery, I don't have a witness list, I don't have any investigator reports or notes or notice of an expert or notice of any sort of expert reports, curriculum vitae, really anything. So out of an abundance of caution, the Commonwealth filed motion to eliminate number 22, which is in reference to any alleged bad character or any prior misconduct of the victim or any witness that the defendant alleges to seek to elicit through whatever witnesses they may or may not have. But essentially, what I would state in regard to this specific issue is that, as the court is well aware, it has to be something that is, first of all, relevant to anything, and it also has to be relevant to a reputation, and not just an anecdotal something that's brought up from one witness, again, who I don't even know who those witnesses would be at this time. So I don't know that the court can rule on it without any sort of notice as to whether or not the defendant intends to seek to introduce such evidence or has any such evidence or who those witnesses would be or what their level of knowledge would be, but it's something that I at least wanted to flag for the court in regard to if it comes up as we go along.
Who's responding?
That would be me, Your Honor. Thank you. This will be very brief. The Commonwealth, at least in their moving papers, Mr. Lally, I think, has gently stepped back from the moving papers a little bit. The moving papers suggest that they seek to preclude the defense from presenting any evidence to the jury that one or more of their witnesses lied or gave false information in this case in any particular. They call this, they do this under the rubric of bad character, but that misunderstands or misapprehends what character evidence actually is. Character evidence or bad character evidence refers to using past behaviors or past traits of a person to prove a propensity to act in a certain way in the future. Conversely, proving that someone lied or gave false or misleading information in regards to a specific matter that's relevant and material to the case at hand, that's called impeachment. And that's allowed in every single courtroom.
Shout out to impeachment. Shout out to impeachment because, yeah. Whoa. If these people lying, they got a right to get impeached right on the stand. Right on the stand.
So impeachment's certainly allowed, but do you intend to put on witnesses regarding challenging character evidence?
No, we're not intending to. That's exactly what I was going to summarize by saying that the bad character focuses on general character traits, whereas impeachment deals with people who lied or were untruthful. We intend to do the latter.
Hold on, Mr. Lally, you're not objecting to impeachment, prior inconsistent statements, things like that.
No, of course
so
not.
Counsel, you mentioned that there is a distinction between character evidence and straight impeachment. Character evidence is not permissible because you're not going to introduce it, you said, right?
We're not seeking to introduce it at this point. We wouldn't. I mean, obviously, the trial has to play out, and it's going to be several weeks. And by the way, Mr. Lally has mentioned over and over and over about how he has no reports and no statements, et cetera. He's got more than 7,000 reports and statements, both from his own investigation and from the federal investigation, that in no small part encapsulates a lot of what we intend to impeach with. However, as I stand here today, I can report to the court that we don't intend at this juncture to put on bad character evidence. We don't know what that might look like, but if we did, obviously I know the rules. I would give the Commonwealth due notice and the court notice before we went that direction.
All right, so 312, Mr. Clerk, is allowed. If you need to readdress that, defense counsel, you need to file a motion. Okay, so 312, Jim, is allowed. Same thing. Do you intend to put on character evidence? It's a difficult standard or potentially problematic, but do you intend to do it?
Your Honor, we at this juncture do not intend to put on character evidence, but we will give the court notice as well as Mr. Lally notice if we do change our mind.
All right, so 313, Jim, is allowed and defendants can renew it.
I'm sorry, what's the second part?
Defendants can renew it by written motion. How about 24? Is there an objection to that?
I believe that was 24.
No, it's 23.
Oh, I apologize. 23, we had said we had no objection.
Okay, I didn't
And
have
24 is the opinion or character.
Okay, so 24 is, all right. 24 is allowed, Jim. 23 and 24 are allowed. All right, there's an objection.
Yo, there's a guy sleeping in the back of the court. This guy right here over here sleep. He probably snoring.
To 25, Ms. Little?
Oh, no, he just woke up. Oh, wait. His head, he just woke up. Shit. Boy, being in court all day, that shit make you tired, make you want to sleep.
Just yes or no? All right, so I'm going to hear from Mr. Lally on the motion. I just wanted to know if there was an objection.
Your Honor, I could probably, if I don't mean to step on Mr. Lally's toes. If he wants to talk, he can talk. We don't anticipate asking any of our experts to read from a treatise. If that's what his concern is, and that's how I read the motion, we don't anticipate going there. That might short circuit this.
So no treatise, no studies?
They will refer to studies, not to read from studies on the witness stand at this point, at this juncture. Certainly, their studies are the foundation of every expert's testimony.
Okay, but what he's saying is he has no discovery of even who your experts are, so how's he going to read all these articles?
I understand that. As the court knows, and we anticipate, and I think Mr. Unetti's going to address this with the court soon enough, he will be getting our expert reports. We now have, finally, their final notice of what their discovery is.
Certificate of compliance.
And we are anticipating by the beginning of trial, by Tuesday, to have something in response to that. But no, we're not going to elicit an expert to sit there and read from a study or read from a treatise, if that's what their concern is.
anything you wanted to add to this? It looks a little broader than that to me.
It is a little bit broader than that, as far as it also refers to anecdotal experiences or things of that nature, which obviously wouldn't be contained within a study or wouldn't be contained within certain materials. So I'm sure counsel is well aware, and I'm not certainly saying that they're not, as far as what an expert can testify to and what an expert cannot testify to. But essentially, what an expert can testify to is facts that they personally observe based on testing or things that they do themselves. The facts in regard to things that are in evidence or things that the counsel reasonably expects will be put into evidence. But the studies themselves, any sort of anecdotal experiences that they may have had or any sort of scientific literature is not something that is permissible to be admitted as an exhibit. So if that is something that they seek to talk about, the Commonwealth would submit that that's improper. You know, what they did in this particular case, sort of what their baseline of experience is, what their baseline as far as their educational background in order to form some sort of opinion based on the facts as the jury finds them is certainly fine. But making any reference to, because it happened in this study, it must be true in this case is something that's simply not permitted.
Okay.
If I may, just briefly.
Sure.
Mr. Lally uses the phrase anecdotal experience. That's the first time I've ever heard that in this context. I don't know what he means by that. But if what he means by that is
I don't know what he means by
something that the expert has done or experienced or has experience with, and then relating, I don't know what he means by that. But if what he means by that is bringing into court something that the expert has done or experienced or has experience with, and then relating that back to his opinion or her conclusion, isn't that what he's suggesting Mr. Whiffen do with his in-court experiment? That sounds like an anecdotal experience. But that's just me. I think we have to take this on a case-by-case basis and figure out what the experts are going to say. I don't know what anecdotal experience means. So I can't really defend against that because I've put hundreds, if not thousands of experts on the stand. I don't know that I've ever asked, can you tell the jury what your anecdotal experience is with fill in the blank? So I'm not sure what and I'm not being glib, I just don't know what that means. So I don't know if the court can absolutely rule on it. I think this may be something that we wait until.
So let's get the list of the experts. Take a look at the Commonwealth's the defense.
You got the lady over there laughing.
And it's expert discovery to you, and you can raise it again.
Thank you, Your Honor.
Thank you, Your Honor.
So, Jim, let's say no action taken. All right, 27. I'll hear you, Mr. Lally.
Yes. So, Your Honor, this motion eliminates in reference to prohibiting reference to any federal investigations conducted by the U.S. Attorney's Office or the Federal Bureau of Investigations. So, to this point, the U.S. Attorney's Office has publicly confirmed that at no time has the U.S. Attorney's Office named any person or entity as a target. So, any sort of reference to, and essentially what they've stated throughout the course of, and I know the court has had a chance to review those materials, but what they state is essentially their investigation into some unnamed criminal activity or some unnamed crime or there's nothing specific to any specific person or entity that is contained within those materials. So what the Commonwealth is submitting is that any reference to the fact that those things occurred is therefore unfair, essentially biases against one side or the other based on that, and it really has no relevancy. As far as making reference to, if counsel at some point, either side, wants to make reference to testimony or statements, reports, things of that nature that were provided in the course of that discovery pursuant to the TUI, obviously that's perfectly permissible, but it also can be done without making reference to where that item came from. As far as you testified previously in relation to some investigation on such and such a date, you spoke to a law enforcement agent on such and such a date and you said this. So if it's needed for those kinds of reasons, as far as impeachment and whatever, that's obviously perfectly permissible, but any reference to that in front of the jury, Your Honor, is something that the Commonwealth would submit is simply impermissible and irrelevant to the facts as they pertain to this case. So for those reasons, the Commonwealth would ask that this motion be allowed.
Is there an objection to this?
There is. Your Honor, the Commonwealth's position can be basically summed up in their moving papers with the following sentence that they drafted. The proceeding would be unfairly prejudiced if the defendant is permitted to rely on the mere appearance or existence of a federal investigation, especially where the investigation was shaped and influenced by the defense. First of all, the defense does not and did not shape or influence any federal investigation. The federal government is more than capable, Your Honor, and I think the Commonwealth knows this, of making its own decisions and about its own investigations. Second, and just as importantly, the Commonwealth cites no authority whatsoever that stands for the proposition that the mere mention of a federal investigation prejudices state court proceedings in any way, shape, form, or fashion, and that's because there is no authority. That authority does not exist. But most importantly, and this is critical, it is going to be critical to give the trier of fact, this jury, the proper context in which every one of the statements or every bit of the evidence is presented and how it came to light. It's essential for the jury.
How are you going to do that? How do you propose it? Is somebody from the U.S. Attorney's Office on your witness list to come in and talk about it?
There are federal agents. No. We don't anticipate presenting the fact that there's a federal investigation.
Isn't that what this does, if you mention it? Explain to me why that's not so.
That's what I'm doing.
Not yet, you haven't, so please explain that.
As the court knows, it's essential that the jury is given the context in which every single statement, whatever the statement might be, is brought to light.
Does that mean, do we say, in the prior trial that resulted in a mistrial, you said this?
No, but you would say, when you were speaking with Officer Smith, or Officer Jones from the Canton Police Department at the Canton Police Station in this particular context, did you say this? When you were questioned by the Commonwealth's attorney in this proceeding, did you say this? When you were questioned by the United States attorney in this hearing, did you say that? That's what we do. Otherwise, it's perpetrating a fraud on the jury. The information that's gleaned during the federal investigation was revealed, Your Honor, importantly, by a neutral third party, a neutral body that's not connected in any way to this case. The Commonwealth has a stake in this case, very obviously. The defense certainly has a stake in this case, but the federal authorities have no stake in the case of the Commonwealth versus Karen Reed. Thus, the evidence procured by that neutral agency, which is independent of the case, is subject to a different and completely different level of scrutiny, a completely different level of assessment by the jurors. That is an important fact. There is no other way to truthfully and honestly present this evidence to the jury. Think about some of the questions that the court just posed. What were the circumstances in which you changed your testimony, sir? He's going to say, well, I changed my testimony, potentially, when I was called before a federal grand jury and I was asked questions under penalty of perjury. Why did you finally admit certain things when you were confronted with additional evidence, ma'am? And where did that evidence come from? Well, I was called before a grand jury and I was asked, or I was interviewed by a federal agent and I was asked or confronted with additional information, text messages, phone calls, etc. Or the third example, where did that additional evidence come from, officer? Text messages, phone calls, private communications. Oh, it came from a hearing in which I was questioned by a United States attorney under penalty of perjury in front of a grand jury. The jury's entitled to those answers in that context. If we were to do what Mr. Lally suggests, if we were to take that invitation, oh, well, you were asked by a prosecutor at a former hearing, XYZ, that would leave the jurors with the imprimatur of the idea that the Commonwealth elicited those questions, that the Commonwealth did their job, when we know, in fact, it didn't. The answers to those questions directly go to Ms. Reed's Bowden defense. Bowden talks about the inadequacy of an investigation. Obviously, Mr. Yannetti can talk more about that in just a second. We have information that a different agency was able to uncover information that the state investigation ignored. That's important. And it's important for the jurors to be able to weigh and balance that information and how the information came to light. If the truth is actually hidden from the jury, which is what the Commonwealth is asking the court to do, that the evidence was produced was the product of a third party, the truth being that the evidence was the product of a third party inquiry, unconnected to the state court case, then that jury is left with a false impression, false information, and it'll be unable to properly assess the true facts, which is what we're trying to get to, the true facts. Why is the Commonwealth so intent on hiding the truth from this jury? I'll submit.
Okay. I'll likely rule on that today. So, number 28, Mr. Lally.
Thank you, Your Honor. So, again, similar to the motion previous to it, the Commonwealth is not seeking to hide anything from the jury. What the Commonwealth is simply seeking to do is ensure that whatever information that's provided to the jury is actual admissible and relevant information and not the product of rank speculation. So this motion is seeking to prohibit reference to any pending internal affairs investigation or unfounded allegations of misconduct. And really, primarily what we're talking about here is any sort of internal affairs investigation related to Trooper Proctor and the 20-something-year-old civil case which resulted in no findings of liability that was referenced by counsel in their motion to dismiss with reference to Sergeant Lank at the Canton Police Department. Under the case law, including McFarland and Graham, the most recent case law, what they essentially attribute is that those types of information, when there is no finding of liability, there is no sustained finding of misconduct, there is no findings of liability by the party at question, that is simply not admissible. And so for those reasons, the Commonwealth submits that this motion should also be allowed.
All right, who's arguing this for the defense? And Ms. Little, what I need to know is what exactly you intend to introduce and how you intend to introduce it.
Thank you, Your Honor. I think it's somewhat premature for the court to rule on this issue. Obviously, the testimony of both of these witnesses is going to be highly relevant as to whether this particular information is relevant. We are still actually receiving information with regard to the internal affairs investigation as recently as yesterday. So I'm happy to kind of defer ruling to the court and then address this as it comes up. I think the court will be in a much better position to rule on this issue once the witness testifies.
All right, so what would be helpful to me, once you know what it is you think you're going to try and introduce, to tell me how that complies with the holdings in both McFarland and Graham.
There are independent reasons why that is admissible outside of McFarland and Graham.
Okay, so I need to know all of that.
Sure.
Okay.
Thank you.
So I'll take this under advisement. And how much time do you need to give me at least a general response now? Can you have it by Tuesday?
We can do that, Your Honor.
Okay. All right, so I'll hold off on that, Mr. Clerk.
Yes, Your Honor.
All right. So number 29, Mr. Lally.
So this motion, Your Honor, is essentially entitled Motion to Eliminate for Advance Notice if defendant intends to cross-examine any witness about alleged bias and request for a pretrial ruling on whether proposed evidence demonstrates plausible showing of alleged bias. So the Commonwealth is not stating that there are no statements, as the court is well aware, that could be interpreted to reflect bias and could be used by counsel in cross-examination. So what the Commonwealth is not suggesting, and bless you, is for any prohibition on any statements whatsoever. What the Commonwealth is seeking here is a ruling as to what precise statements the defendant seeks to introduce in regard to that, so that the court can make a ruling prior to the witness testifying before the jury as to exactly what's in play and what is going to be admissible and what's going to be allowed as far as, obviously it's not a perfect world, and if a witness were to answer something in a way that would then open the door for further material to come in, that's understandable. But at least a preliminary showing as to exactly what the defendant submits are the statements they wish to introduce in relation to this issue.
Isn't the defendant given broad range on cross-examination as to bias?
Yes, and that's why I indicated early on that I understand that there is that there certainly is some areas that under the law, whether or not they're true or not, are able to be explored as far as cross-examination is concerned. But what this motion simply seeks to address is there are restrictions to that. It's not unfettered. It's not, just anything and everything that they could possibly think of or say as far as accusations go.
Is there any particular type of testimony you're concerned about? I mean, is there anything in particular that you say they should not be permitted to go into, based on what we've heard throughout the pendency of this case? Is there anything? I'm reluctant to tie the defendant's hands in any way on cross-examination without knowing exactly what it is you think is improper.
Okay. And what I would do, Your Honor, what I would suggest is similar to the other motions that we spoke of before. I can provide a supplemental with more specifics as to what the Commonwealth's concerns are, if the court would find that helpful.
Yes, I can't rule on this as is. So is there any objection to that, Ms. Giannetti? You're nodding.
Well, no, I think that makes sense.
Okay.
It was Ms. Little's motion.
Oh, I'm sorry. I saw you nodding.
I don't want to step on her toes.
No objection to that, Your Honor.
Okay. All right, so why don't you do that? So, sure. Mr. Clerk, we'll hold off on ruling on this until we get something from the Commonwealth.
Okay.
So Commonwealth will clarify. Right, and then no action taken. All right, so as you know, third-party culprit and Bowden are often argued together, often presented together. Why don't we just deal with the two motions together? So Commonwealth's file, you're number 30 and 31, Mr. Lally. Mr. Giannetti, are you arguing both? Does it make sense to sort of keep them together?
I agree that they should be kept together.
Yeah. All right, so why don't I hear you as to your concerns on both, and as you know, sometimes third-party culprit, as it goes to Bowden, is different than just straight third-party culprit. And actually, it might save us a lot of time. Is that what you intend to do, Mr. Giannetti, third-party culprit as it goes to Bowden, or straight third-party culprit as well?
Definitely third-party culprit as it goes to Bowden, that's for sure. And then depending on how the evidence develops at trial, there may be an offer to offer third-party culprit evidence with regard to third-party culprits. But I think I can speak further to that in response.
Mr. Lally, go ahead. You can argue these however you want to argue them.
No, and I would argue them sort of in that vein, Your Honor. So understanding that based on the state of the evidence, as I anticipate it to be, and in any case, regardless, I think a defendant in any criminal case has a much better shot, essentially, at getting evidence in regarding to Bowden as sort of a backdoor through, as the third-party culprit as sort of a backdoor through a Bowden defense. So what I'm primarily concerned with, Your Honor, is motion to eliminate number 30, because as the court is well aware, there have been a number of theories of sort of speculation, rank speculation, opinions without any evidentiary support, names of certain people that have been dropped at this microphone by counsel at different pretrial hearings who are not witnesses, who have nothing to do with this case, who don't know anything about this case, who counsel, when they said those names and sort of dropped those, whatever they supported to be facts, knew that they had nothing to say and nothing to do with this case. What I'm concerned about is whatever is acceptable as far as believability when it comes to arguing things in pretrial motions, shouting things from courthouse steps, or bandying about on Twitter is not what we do here. And so now it is a time where counsel is going to be relegated to what is actual, admissible, relevant evidence. And what I'm asking for in this motion is for the defendant, through her counsel, to actually provide any admissible or relevant evidence that pertains to third-party culprit, which to this point they have not done. So if this is something that's going to be raised as an issue on its own, as the court is well aware, what the case law indicates is that the acts of the other person are so closely connected in point of time and method of operation as to cast doubt upon the identification of the defendant as a person who committed the crime. It has to be specific. It has to be to at least a specific realm of person or a specifically identified person. who would have motive, opportunity to commit the act with which the defendant is charged. And up until this point, I have not seen anything specific as to that. As it pertains to the Bowden motion the Commonwealth filed, what the Commonwealth is asking for there is notice and voir dire in relation to a Bowden defense. So if there is, again, going to be some, I don't think the evidence comes anywhere close to a Bowden instruction, but certainly what the courts have said over time is that a Bowden defense is something that
he's boring.
If the evidence warrants it, counsel can elicit testimony in regard to it or attempt to and make arguments in reference to it. So I'm not seeking to preclude counsel from making arguments or from counsel asking questions. What I'm seeking clarification on is what exactly, and again, this is from a position of operating without any information whatsoever as to what a defense may be. And understanding that counsel was not required to provide any information until the Commonwealth filed its certificate of compliance. But there's been, regardless of whether they were required to or not, I'm going into trial on Tuesday without any information whatsoever as to who they've spoken to, what statements they might be, who their witnesses are, or anything of that nature. So for those reasons, the Commonwealth feels it appropriate to at least file a motion to be given notice as to exactly what the defendant intends to do. Trial by ambush is simply not something that's permitted by the case law, and that's what the Commonwealth is seeking to prohibit in that second motion.
Ambush?
Thank you.
Okay. All right, Mr. Yannetti, I'll hear you.
Trial by
And though they're argued together, I do want you to also start with the third-party culprit alone, not third-party culprit as it goes to Bowden, but third-party culprit alone, because of all those factors that I told you, as you well know, the case law is clear, that I have to consider. And if I had to do it now, and you know I can do it pre-trial, right? You know that today I can just exclude it. I'm not inclined to do that, but I need to be able to make those decisions, to weigh those factors, because right now I have zero information on
Right,
this.
I understand that, Your Honor, and that was my plan going into today anyway. So the initial question is, why is there a third-party culprit defense? Why is it relevant? And we start, Your Honor, with the fact that our forensic medical examiner, Frank Sheridan, a forensic pathologist who has performed himself thousands and thousands of autopsies, has already submitted a sworn affidavit to this court that John O'Keefe's injuries are consistent with having been in a fight and are not consistent with having been hit by a car. Since he submitted that affidavit, the federal authorities have provided us with their reports, whereby FBI experts also corroborate that John O'Keefe's injuries are not consistent with having been hit by a car. They employed experts in biomechanics and kinematics who have reviewed the evidence in this case, and they've confirmed that the physical evidence essentially shows and doesn't show what Dr. Sheridan has opined. So therefore, if John O'Keefe was not hit by a car, that means that Cameron Reed did not kill him. And we know that John O'Keefe did not die of natural causes. This was not a heart attack or a stroke. John O'Keefe was injured. He was mortally injured. If he was not hit by a car, as both our expert and FBI confirmed, then he was attacked. And if he was not hit by a car, then there is a third-party culprit or culprits. So by asking this court to prohibit the defense from introducing evidence that others had the motive, opportunity, and the means to attack John O'Keefe, the Commonwealth is essentially asking this court to prohibit Karen Reed from being able to defend herself.
So I don't think they're asking that you be prohibited from doing that. They're asking first to have you tell them what that is.
Right. Well, this is, Your Honor, I'm getting to that in terms of
go ahead. You have your remarks.
That we're either required to give them or not. It is not our job to solve this case for the prosecution. It's our contention. They had the opportunity to do that, but they failed. It is not our job to name a specific third-party culprit. We do not have to prove that Brian Albert or Colin Albert or Brian Higgins or some combination of them intended to kill John O'Keefe. We don't have to prove that any of them attacked John O'Keefe such that he eventually died. They have to prove beyond a reasonable doubt that they didn't. But the fact of the matter is there is evidence that all three of them had a motive, had the opportunity and the means to attack John O'Keefe. Now, the Commonwealth cites Commonwealth versus Conkey in their motion, and as this court started the discussion on this issue when you first took the bench, Conkey makes clear that a defendant has a constitutional right to argue that somebody else may have committed the crime. And certainly, no, the acts of that person can't be too attenuated in time or method of operation, as Mr. Lally mentions. But in terms of being the right time period, Your Honor, you can't get any closer than their presence at the scene at the very time that John O'Keefe was killed. And in terms of the method of operation, given that we have evidence that he was not hit by a car and that he was attacked, all three of these men, either alone or in combination, possessed the ability to attack him with or without a weapon. I mean, it's a very low standard here. The Commonwealth acknowledges that. It's a low standard of simple relevance. And the evidence here establishes relevance. Now, I would note, Your Honor, the Commonwealth cites Commonwealth versus Finney. I don't know if they realize this, but that was my case. I represented Roland Douglas Finney before the Supreme Judicial Court, and I represented him at his motion for new trial and at his retrial. And that case, the Finney case, provides strong support for the introduction of third-party culprit evidence here, irrespective of a Bowden defense. In fact, the reason that Mr. Finney's conviction was overturned was that his trial counsel failed to pursue a third-party culprit defense. And, Your Honor, the third-party culprit defense in Finney was weaker, far weaker than the third-party culprit defense we have here. The evidence of motive in that case was that the third-party culprit made derogatory statements about the victim after she was murdered. No witness in that case put the two of them together. No witness in that case put the third-party culprit at the scene of the murder where the victim was murdered. There was some consciousness of guilt evidence similar to what we have in this case. But in Finney, the SJC ruled that not only was that enough for a defense attorney to present a third-party culprit defense, but he was ineffective for not doing so. And as the court has also touched upon, the SJC found that on the basis of that third-party culprit evidence, which is weaker than what we have here, there were substantial connecting links between that third-party culprit that justified the admission of hearsay in that case. And I want to make it clear, we're not looking to introduce any hearsay statements, so we don't need substantial connecting links here. Now, Your Honor, I could go through with the court the specific evidence we have with regard to motive, opportunity, and means with regard to the 3 Commonwealth witnesses that I've named.
So go ahead.
Happy to do it. Starting with Brian Higgins. He was present at 34 Fairview Road on January 28th to 29th. He was close friends with the homeowner, Brian Albert. He had a prior romantic interest in Karen Reed. He did not expect Karen and John O'Keefe to be at the Waterfall, that bar, on January 28th. Karen Reed did not greet Higgins, despite the fact that they had previously exchanged flirtatious texts and that she had been at his apartment one evening, although there was nothing that took place between them any more than a peck of a kiss. At the Waterfall, Higgins does not engage with John O'Keefe. He does not say goodbye to John O'Keefe and Karen when he leaves, but before he leaves, he texts Karen, and that text was something to the effect of well, with a lot of...
Yeah. We got some motive right there. There sounds like Albert got some motive to want to do something to somebody. Oh, no. This is crazy.
We know that there was a preservation order from this court, your predecessor, Judge Krupp, to preserve his cell phone, and that Trooper Proctor gave him an edict, an order to serve on Brian Higgins, and he left it at the front desk of the Canton Police Station for him, and that Higgins, we learned through the federal investigation, Higgins became angry, demanded that Proctor come back, and he essentially upbraided him and read him the riot act, which shows a little bit about Higgins' personality. At the end of the night, everyone discussed going back to 34 Fairview, and when he gets back to 34 Fairview, he texts not Karen, he texts John O'Keefe at 12:20 a.m. He testified before the federal grand jury that he had no knowledge that they had been invited to 34 Fairview, but that is contradicted by this text message. And the inference is that he was coaxing John to come to that house. And, we're not saying this gives him a motive to kill John, but we don't have to show that. Any motive to feel hostility or animosity towards John O'Keefe goes to his motive. And, Your Honor,
that's a fact.
When Brian Higgins and Brian Albert are in that house, they're the only 2 people who are unaccounted for when the rest of the group was in the kitchen. And they claimed that they were looking at photographs together. And we have evidence that they were in the basement. We believe that Brian Albert made a mistake before the state grand jury by testifying they went upstairs to look at photos. Brian Higgins says unequivocally that the only place the 2 went was into the living room to look at photos and military ribbons, whatever they were looking at. Brian Higgins did not know that Brian Albert had said they went upstairs. And he also testified he had never been upstairs at Brian Albert's house in his life. That means that if Brian Albert said they went upstairs, they're coming up from the basement.
Bro. Yeah, this is overwhelmingly clear that these officers, their hands is not clean.
Before leaving 34 Fairview, Brian Higgins testified he was parked right in front of the mailbox. He would have had to have walked by where John O'Keefe's body was. His headlights, when he got in his vehicle, would have been illuminating where John O'Keefe's body would have been in the yard if it were actually there. So how does he not see it? He then goes back to the Canton Police Station at 1:30 in the morning after leaving 34 Fairview. He claimed to do some administrative work, but then he admitted to the federal grand jury that he was there to move his car because of the upcoming snowstorm. This suggests that he was fabricating a reason for going back to Canton Police to establish an alibi for himself. He was asked several times at the federal grand jury if he had any conversations with anyone before he went to bed. And when was he notified that John O'Keefe was dead? In the morning, he said. He testified under the pains and penalties of perjury that he had absolutely no contact with any person that night for any reason whatsoever. But he apparently was surprised that the federal authorities had subpoenaed his phone records, and he had to admit, and he did admit under oath, he made that 2:22 a.m. phone call. Around the same, about 5 minutes before Jennifer McCabe is Googling how long to die in the cold, about 8 minutes before Brian Loughran, the plow driver, first drives by the house and sees nobody at all. And the next morning, Brian Higgins, the first person he spoke to was Brian Albert.
I'm going to stop you for a minute. I think we need a break, Madam Court Reporter. Do you need a break? Can you go? How much longer do you think you have with this, Ms. Giannetti? How many more pages or how long you think?
Now, I've got about, in terms of my recitation of the facts, I've done about a page and a half, and I've got 3 left.
Madam Court Reporter, would you like to take a little break? It's hot in here and you've been going nonstop. Okay, let's take a 10-minute break.
Yo, I know the lawyer pissed. Like, really? Right in the middle of my stuff, you just go over and take a break. Yo, he was dropping bombs. Bomb over Baghdad. Man. Bombs were being dropped, bruh. My goodness. Something serious. Something serious. Lord of mercy. Shout out to the chat.
Just to be clear, this is a...
Make sure we don't miss nothing.
Your Honor, I left off with the morning of January 29th. The first person that Brian Higgins spoke to was Brian Albert. He had missed a call from Chief Kenneth Berkowitz earlier. Immediately after getting off the phone with Brian Albert, Brian Higgins drives back to 34 Fairview, where he has a meeting with just about all the witnesses in this case: Brian Albert, Julie Albert, Jennifer McCabe, Matthew McCabe. And immediately after that friends and family meeting on his day off, which is a Saturday, he returns to the Canton Police Department, where he speaks with all of the first responding officers who had anything to do with this case. So this is a quote-unquote witness accessing and communicating with all the first responding officers, we would argue monitoring what they're doing in regard to the investigation. According to Brian Higgins, he admitted that Chief Berkowitz is one of his best friends, and that's why he had access to all these people. We have a law enforcement witness who will testify to seeing Chief Kenneth Berkowitz and Brian Higgins alone with Karen Reed's vehicle on the afternoon of January 29th of 2022 for, quote, a wildly long time.
So is this a name?
They not even supposed to be around. It's a conflict of interest, bro. What y'all even doing on here? Don't even, man. Red flag.
That's been in the materials. Is this a name known to the Commonwealth?
Yes.
Or is this somebody new? Okay.
We've now received video surveillance from the Canton Police Department that shows that there is an interior camera in the Sallyport garage where the car was housed. But during the exact time that third-party officer indicates that Berkowitz and Higgins were in the Sallyport together, the video mysteriously cuts out for 42 minutes.
Oh, my goodness, bro. Bro. Oh, my. I mean, are they trying to hide this cover-up, or they just don't care? Because it's just so obvious what's happening right now. This is too cut and clear. This is like straight, direct, hey, cover-up. This is crazy.
Officer indicates that Berkowitz and Higgins were in the Sallyport together. The video mysteriously cuts out for 42 minutes between 5:08 and 5:50 p.m. And just to
look at the girl in the pink. She like, this is crazy. I mean, it's so straightforward. Not even gotta wonder, is this a cover-up? Yes. I mean, my goodness. Did the trial even start yet? Because this is crazy, bruh. Before you even get the jury in here, you already know, yo, this is a cover-up.
To be clear here, we never get to see the condition of the taillight when it's brought into the garage. When we do see the car, we see it after Brian Higgins, Chief Berkowitz, Michael Proctor, and Yuri Buchnick have all had access to it. At 5:36 p.m., the car pings that it's arrived in the Sallyport. That's during the missing video. Trooper Proctor, Trooper Buchnick never sees Brian Higgins' phone. They speak with him, and he takes it upon himself to use his own resources, Brian Higgins, within the federal government to ask a friend, Special Agent Matt Kelch, to download only the text messages in his phone between Karen and him and John. And that's it. We have to take his word for it that we got all of them. And we certainly don't have any communications between him and Brian Albert, for instance. On February 10th, when he shows up to his interview with Troopers Buchnick and Proctor, he brings with him copies of the text that he has deemed relevant in their murder investigation. And he hands them the copies of the extraction that he had his friend do. He then calls Matt Kelch the weekend of this incident to do the limited extraction. He never tells Trooper Buchnick or Trooper Proctor how he extracted the tests, despite the fact that it was done by a friend of his in the federal government. During the federal proffer, Brian Higgins admits that he had been served with a preservation order, and the Commonwealth told him he could destroy his phone despite the order. He then drives to a military base on Cape Cod, opens his phone, breaks the SIM card, and throws the phone away.
What? That is a serious over-the-top way to get rid of your phone. Why he couldn't just throw it in the garbage? He seriously ain't want nobody to get nothing that's on that phone. What is this about?
And he says that he discussed destroying his phone with Brian Albert. Brian Albert also destroyed his phone.
How both y'all destroy y'all phone? That's not normal. Both you guys break it, SIM card, everything. Like, you know where you see that at? When the two criminals just finished getting away with the murder or the bank robbery or the crime, and they getting rid of all the evidence. Destroy your cell phone, destroy your cell phone. Get rid of the dirty, get rid of the fingerprints. You got your glove, get in there. Yeah, put all that in the bag. We gonna burn it. Like, it sounds. This is what criminals do when they finish the crime and try to like. This is too straightforward, man. God.
Throws the phone away. And he says that he discussed destroying his phone with Brian Albert. Brian Albert also destroyed his phone. And Brian Albert said that he had received some text that concerns him as an explanation. And after that, Brian Higgins changes his phone number and changes his cell carrier. In short, he was present that night, he had a motive, and there is plenty of consciousness of guilt cover-up evidence with regard to Mr. Higgins. Moving on to Colin Albert. Shortly before January 29th of 2022, Colin Albert lived with his parents, Christopher Albert and Julie Albert, on John O'Keefe's street, just 2 doors down. We have evidence of bad blood between Colin Albert and John O'Keefe. We have evidence.
How old was Colin Albert at that time?
I believe he was 16 at that time.
Oh my God.
We have evidence that Colin Albert.
Yo, no. Yo. I have evidence that they had bad blood. How old is he? He's 50 years old. And when did they have bad blood? When he was about 14 or 15, Your Honor? Bro, get out my face. Yo, he trying to be slick. He trying to be slick, bro. Hey, listen, man. That slick stuff make me gotta side-eye you. You be doing good until you do stuff like that, bro. You be doing real good until you do that type of stuff. Now I gotta be like, man, let me wait till the trial come to see what's really going on. Because this guy right here, he think he's slick. You almost got me there. You almost had me. Shout out to the judge.
John O'Keefe. We have evidence.
How old was Colin Albert at that time?
I believe he was 16 at that time.
Okay.
We have evidence that Colin Albert and John O'Keefe used to get in confrontations because Colin Albert used to cut through his yard without permission, and John O'Keefe was not happy about that. We have evidence that Colin Albert used to throw beer cans intentionally into John O'Keefe's bushes, and John O'Keefe was not happy about that. We have evidence that Christopher and Julie Albert knew of this conflict. We have evidence that they referred to...
Hey, this beer can stuff don't sound like when they was 16.
John O'Keefe as Nebercracker. That's a character from Julie Albert knew of this conflict. We have evidence that they referred to John O'Keefe as Nebercracker. That's a character from I think a kid's movie, who was known as the Get Off My Lawn guy. When John O'Keefe and Karen Reed were vacationing in Aruba over New Year's Eve 2022, the Alberts, Christopher and Julie, taunted him. They went to his porch, and they had photos taken of themselves drinking on John's property when he wasn't there to do anything about it, evidencing they knew how upset he was at what Colin Albert had been doing. Now,
bro, this case sound like it's gonna be crazy.
the investigators in this case, Your Honor, including Michael Proctor, kept Colin Albert's name completely out of the police report. When this case began, I had no idea who Colin Albert was. I received a tip right from the jump that Brian Albert and his nephew had beaten up John O'Keefe. I didn't even know Brian Albert had a nephew at that time. But after receiving the tip, I learned of the conflict that Colin Albert had with John O'Keefe, so I sent a letter to Mr. Lally, I believe by certified mail. I knew that the DA's office was planning to present witnesses to a grand jury, and at that early juncture, before anybody had asked them to indict, I notified the DA of 3 potential suspects, the ones that I'm talking about now: Brian Higgins, Brian Albert, and Colin Albert. After he received that letter at our next court appearance, I'm sure Mr. Lally can confirm this, he acknowledged that both Brian Albert and Brian Higgins would be testifying or had testified before the grand jury, but he questioned why I included Colin Albert in my letter. He told me at the time that he had no evidence that Colin Albert was there that night. However, after receiving my letter, lo and behold, multiple witnesses testified that Colin Albert was at 34 Fairview the night of January 28th, 29th. And now the DA will argue, I'm sure, at trial, that he left before John O'Keefe arrived. We don't find their evidence compelling. We don't accept it. We are not required to accept their theory of the case. We're entitled to present a defense. His presence at 34 Fairview gave him the opportunity, along with the motive, to harm John O'Keefe. With regard to Brian Albert, Your Honor, this is a well-connected, well-known, powerful family in the town of Canton, Massachusetts. Brian Albert was present at that home when Colin Albert was there. Colin Albert is a member of the Albert family. He's a nephew of Brian Albert. We have evidence that Brian Albert had expressed hostility toward John O'Keefe as well. And we know that he initiated a phone call with Brian Higgins at 2:22 in the morning. He reached out to Brian Higgins. And then he picked up the phone when Brian Higgins came back, and they spoke for 22 seconds. And they never revealed any of that to investigators. Again, consciousness of guilt. And perhaps most of all, Brian Albert is a first responder. He is duty-bound to help somebody who's in trouble. He was notified that John O'Keefe was in trouble. Brian Albert stayed in his home. He knew what was going on outside. His sister-in-law was out there, civilians, medical personnel eventually arrived. He did nothing. That is also consciousness of guilt. Now, Your Honor, with regard to all of that third-party culprit evidence, to admit it substantively, which I would assert to the court is both overwhelming and powerful. With regard to the Bowden argument here, the police investigated none of that. That didn't come from the Commonwealth. They had a complete lack of curiosity as to what was going on in that house that night. They didn't care. Investigators never went in. The feds investigated, and that's where we got a majority of this evidence. So, you know,
Goddamn, shout out to the feds, man. Shout out to the feds.
The extent that the Commonwealth now claims that they didn't have notice of this, I beg to defer. They got notice of this when we got notice of this. You know, the Finney case, Your Honor, again, I'm well familiar with it. It stood for the proposition that, you know, if you want to point the finger at a third-party culprit, you've got a constitutional right to do that. And if you want to point out inadequacies in a police investigation, you have a constitutional right to do that. Right? It's for those reasons that I ask you to deny the Commonwealth's motions.
Okay, thank you. Any response, Mr. Lilly?
Sound good. Sound good.
Just first, again, what the case law requires is evidence and not just mere speculation, or saying that you have evidence is not actually evidence. Okay. I do find it somewhat interesting that Mr. Yannetti wrote apparently 4.5 pages of notes, but didn't have time to write a motion to admit the evidence that he claims that he has.
Oh, shots fired, God. Shots fired.
If you think I'm here to play around with y'all, got done on that.
Yo, yeah. Okay.
It's somewhat interesting that Mr. Yannetti wrote apparently 4.5 pages of notes, but didn't have time to write a motion to admit the evidence that he claims that he has. He references in regard to third-party culprit Dr. Sheridan, who indicated that the injuries are consistent with the fight. He's the same doctor who indicated that the injuries on Mr. O'Keefe's arm were consistent with the dog bite, which was then refuted by the DNA findings from UC Davis, as well as the fact that the injuries are only on one side of the arm. And last time I checked, dogs have teeth on the top and the bottom, and there's no...
Oh, my God. Shots fired. Man, hey. He ain't come to play.
Injuries to the bottom of Mr. O'Keefe's arm. Furthermore, the counsel references the federal grand jury materials in which I would say, as has been done numerous times previously, is severely mischaracterized as to what they actually contain. So what, and it's not a crash reconstructionist as it's been alleged here before, it's a biomechanical engineer. And essentially what they did was take painstaking lengths to go to determine that the defendant's vehicle did not strike Mr. O'Keefe in the back of the head, which is simply something that no one has ever said, intimated, at any point ever. There is also a medical examiner in the federal materials who concurs completely with Dr. Scortibello's findings as it pertains to the cause and manner of death. So with regard to each of these, the other thing that I would point out is counsel was counsel record with the Finney case. The Finney case relates to third-party culprit under the Bowden event, so it's not applicable to what counsel was arguing. It is a low standard, but it's also one that the defendant here has not met. It's not one without limits. As it pertains to much of the material that was summarized as far as speculation as to what different things counsel feels mean from various things regarding Mr. Higgins, Colin Albert, and Brian Albert, just starting with Colin Albert because that's frankly the easiest. He wasn't at the house, and that's what the federal materials confirm. With each of every single of the witnesses that were spoken to by the district attorney's office or the troopers or testified to the state grand jury, they testified to the exact same things in the federal grand jury. That Colin Albert had left the house prior to the defendant and the victim arriving there, and there's absolutely nothing to combat that whatsoever, other than, again, just rank speculation. So opportunity would be a little bit amiss if he's not even there at the same time as Mr. O'Keefe, regardless of the invalidity of any sort of ill feelings or ongoing feud that's reported from whatever unknown evidence counsel claims to have. In regard to Mr. Higgins, that was a fanciful story. But again, there's actually no actual evidence of most of those things, or at least the imputations or the connotations the counsel wants to put behind that. Whatever he feels things were observed. So Again, I'm not sure where the evidence from this is coming from. What I'm also a little confused in regard to is that if counsel is merely relying on materials within the federal grand jury and just learned of them at that same time as we learned of them when materials were provided pursuant to TUI, then it's a little peculiar that the exact same arguments were being made throughout the pendency of the case well before counsel was provided with any of those federal materials. What counsel just went through is essentially a list of rank speculation and not actual evidence. As far as the mysterious portion that's missing from the Sally Port, there's a number of different, it's a motion-activated camera for the most part. The other thing that I would direct the court's attention to, as it was contained within the state grand jury proceedings, is there is cruiser camera video from the Canton Police cruisers. Specifically, there is cruiser camera video from Cruiser 682. Specifically, there is cruiser camera video from Cruiser 682 at 8:22 in the morning when a lieutenant and sergeant from the Canton Police on their own go over to One Meadows Ave, which is the residence of Mr. O'Keefe, to do a well-being check because they had not received any information as to how the children were or if they were there being attended to. And they pull into the driveway at 8:22 in the morning, directly behind the defendant's vehicle, which is exactly where Ms. McCabe parked it when they stopped there to see if Mr. O'Keefe was there before then piling into Ms. Roberts' vehicle and proceeding to 34 Fairview. And what you can see within that cruiser camera video at 8:22 in the morning is the damage to the right rear taillight of the defendant's vehicle.
Hey, show me. Listen, I ain't doubting you.
The evidence is going to show.
If you saying it, then I expect to see it. All right.
Well before the defendant had then come back to the house after the hospital and then gotten in 3 separate cars with her family and driven in a blizzard all the way back to her parents' house in Dighton, and then the vehicle had then been towed from Dighton back to the Canton Police Station by the state police with the assistance of the Dighton police.
Do you know what exhibit number that is before the grand jury?
I believe it's 56, but I can certainly locate that information. And again, as far as Brian Albert is concerned, I heard nothing other than he's apparently in a well-connected family in Canton, and Colin is his nephew who wasn't present at the house when Mr. O'Keefe and Ms. Reed were present at the house. So again, I think it's a stronger argument, certainly, if we're trying to bootstrap onto a Bowdoin defense, and counsel will probably likely be allowed to at least investigate that as far as impeachment, cross-examination, things of that nature, but there is absolutely nothing beyond just a fertile imagination and rank speculation as it applies to a third-party culprit defense. And for that reason, the Commonwealth's motion to exclude it should be allowed.
The only thing I'd like to correct, Your Honor, is, well, or at least point out, is that, the car pinged at 5:30.
So hold on until you get to the microphone.
Yeah, I'm sorry. The car pinged at 5:36 p.m., indicating that it was in the Sally Port. There is an outdoor camera where you can see the car about to enter the Sally Port at 5:31. Of course, you can't see the taillight in that outdoor, camera. But Mr. Lally just argued before you, well, the reason why there's no, video of the car between 5:08 and 5:50 is that it's motion activated. And I just ask the court to use common sense here that if the car's entering, and by the way, the car's there at 5:50 with a couple of people around it. When the camera comes back on, you see the car. So unless it was teleported in a split second so that the interior camera would not pick up motion, it drove into the Sally Port. I believe that's the definition of motion, and it should have been picked up according to Mr. Lally's own words.
Okay, so when you walk away from the microphone, it's harder for the court reporter to
Hey,
hear
yo,
you, Mr. Unetti.
yo.
I apologize, Judge.
The lawyer keep acting like he dropping the mic. Yeah, and it's all the bang, walk off. Hey, we ain't get that last part. We ain't get that last part, bro. What's wrong with you? You're moving too fast. Hold on.
It should have been picked up according to Mr. Lally's own words.
Okay, so when you walk away from the microphone, it's harder for the court reporter to hear you, Mr. Unetti.
And I apologize, Judge. It's according to Mr. Lally's own words, it should have picked up the movement.
Okay. All right, so I believe that's the last motion. So why don't we recess until 2 o'clock, and I'll see you back here at 2. Mr. Lally, will you have Ms. Gilman, who I did see walk in here at one point, set up the screen right where we normally keep it?
All right, they're going on break. I'm going on break. Give me a second. I'll be right back. Let me play some real quick. Shout out to the chat. Play some background music. All right, I'll be back in a few. Give me a second. Shout out to the chat. Shout out to the chat. Shout out to the chat. Y'all hit the like button. Y'all hit the like button if you haven't already. We're gonna get to the we're gonna get to the next one. In 1 second. In 1 second. Shout out to the chat. Alright. Let my coffee do what it do, baby. I'm gonna let my coffee do what it do, baby. Shout out to the chat. Shout out to the chat. Oh. All right. Let's see. Don't look like much happened here. Let's see.
Of the
Let's start back here.
Computer, please. Okay, thank you.
Back on the record on the Karen Reed matter.
Okay, so good afternoon, counsel. Good afternoon, Ms. Gilman. I appreciate you being here. Before we see this video, just briefly, I just want to say that there were really only 2 motions that I'm comfortable with deciding by the 2 o'clock call here. Commonwealth's motion in limine of intent to obtain Corey. I don't know if I already allowed that, but that's allowed. And the Commonwealth's motion in limine, Jim, I think this is 317. Commonwealth's motion in limine to prohibit reference to any federal investigations conducted by the U.S. Attorney's Office or FBI. So that will come into evidence the way that it typically does here in Massachusetts. You can question as to a date where the statement was made under oath, and we can discuss it as it gets closer in more detail. So the other motions are under advisement. We'll talk about that when we come back to sort of housekeeping matters at the end of the day. So do you have that video all pulled up, Mr. Lally, for me to see?
Yes, Your Honor.
Okay.
And, Your Honor, for the record, it's a little bit lengthy as far as the entirety of the video. The portion that I would be submitting to the court is from 7 minutes and 4 seconds until 9 minutes and 55 seconds.
Okay. Can we, thank you.
So we got the house, so that door just did the knock lock.
Okay. Can you explain to me what the process is right now?
Absolutely. So you're going to be booked just like last time. Go through the same process. It's going to be a little less time consuming because we're not going to do major case prints as we did those last time. Once you're booked and you go through this portion of it, we'll let you make a phone call just like last time. We'll make a phone call. Your parents will be able to bring you whatever other additional need, things that you need.
Yeah.
And then tomorrow morning, you'll go and be arraigned at Norfolk Superior Court on the charges that were. I'm sure you'll go over the charges again with you on the warrant.
But I'm on bail, so how can I be spending the night here again?
All right, so I'll explain that portion to you, as long as it's not going to interfere with you. Are you ready to go?
Yeah, I'm just waiting for Ram to.
Okay. So initially, your arrest was on probable cause out of the district court. Okay. So the charges you were arrested on initially were out of district court, still in district. That's where the arraignment was. It was district level charges. Today, grand jury indicted you on these charges, which is second-degree murder, vehicular homicide, and leaving the scene of a death. Okay. So those are the charges the grand jury indicted you on. So now you're being charged and will be arraigned in Superior Court, Norfolk County Superior Court in death. Okay.
So bail doesn't apply anymore?
Typically, so we don't set a bail. But typically, once murder comes into play, people don't get bailed.
So it's not manslaughter anymore, is that the difference?
That's correct. It's a higher degree of taking a life. Okay, so that's the charges you're being charged with now. And you were indicted by grand jury.
Okay, you're aware he was beaten up by Brian and Colin Albert. I mean, we're all in on the same joke, right? My taillight was cracked and John was pulverized.
Okay, you need to abide by the rights that were afforded to you, okay? So
she like, are we serious? Is this? She said we're all in on the same joke, right? She's like y'all gotta be joking, right? Like, what was this, a prank? She don't think this. She think they playing.
Pulverized.
Okay, you need to abide by the rights that were afforded to you, okay? So you can talk if you want. If you want to tell us what happened, that's fine. We'll listen, but you were ready to do your rights, okay? And I'm sure he's gonna do it again. All right. If you want to talk to us, you want to give us a story, definitely. But we'll take it.
No, I mean, I know you already know the story, so I don't need to.
All right. How long is the entire tape?
So that is Trooper Pai, who was the arresting officer from the barracks. So it goes, I believe, at least 90 minutes or so.
All right. Do you have the entire? We're not playing it now, but do you have the entire video? All right. I would like it marked for identification. Sure. I'd also like a copy of it so I can view the whole entire thing, put it all in context. I never like to see just sections. Sure. Can I get that for the weekend as well?
Oh, absolutely. And for the record, as far as I think a lot of that sort of preliminary stuff was more meant as context for the court. There's certain discussions about court procedure and things that I don't think should be put in front of the jury.
All right. So that was my concern as well. Okay. So it's something I'll watch a few times and the whole thing as well. Okay. All right. Thank you.
Thank you, Your
Honor. For identification. Thank you very much.
Thank you.
All right. Okay, so housekeeping matters. A few things that I still need, as you know, before we have the jury here on Tuesday. I need a statement of the case. I know you have a short statement of the case in your proposed supplemental questionnaire. I think it needs to be more than that. So before you leave today, I'd like you all to agree on a joint statement of the case. I need witness lists. If the witnesses are going to be called, I have to read their names, as you know, to the jury on Tuesday morning. Once we get a jury, and I know none of us knows how long that might take, how long will it take to put in the Commonwealth's case? You can tell me with DNA and without DNA.
So with that piece of DNA, I don't think that's going to add much more than an hour or two at most. But best guess, given the schedule as outlined previously by the court, I'd say probably at least 4 weeks. My hope is there are some witnesses on the Commonwealth's witness list who are essentially testifying just in regard to administrative things, as far as working in an establishment. This is a true and accurate copy of surveillance video from said establishment.
Have you had preliminary discussions about whether there would be stipulations to authenticity like that?
No, but I plan to before Tuesday.
Okay. And you'll do that, Ms. Giannetti? You'll have these conversations before Tuesday?
I'm completely open to that.
Okay. So with the Commonwealth's case going 4 weeks, how long does the defense think their case will go?
With the schedule that the court has outlined, we're estimating about 2 weeks, Judge.
Okay. All right. I need to tell the jurors how long it will take. So if you say 6 weeks, I'm going to tell them 7, which will make it longer for us to get a jury. But
right, understood. And then there's also the X factor of how long it takes to get a jury. Right?
Oh, exactly. No, I'm going to tell them once we get a jury, it will be 7 weeks, give or take.
And just while we're on this subject, Your Honor, does the court have any idea in terms of the availability of jurors every day of the week?
We don't have jurors on Fridays.
No jurors on Fridays.
No, and it gets progressively lower as the week goes on. But we've got jurors. Once we start, the trial that is impaneling has priority over all other trials. So once we start, and I expect that we'll start on Tuesday, we'll do that. So there's a couple of things about the voir dire of the jurors. So we will do the voir dire, the individual voir dire of jurors over here at sidebar. And only one lawyer from each side is permitted to ask the questions of the jurors. I think I'd probably be able to give you 5 minutes or so for each witness, no more. And I'd like to talk to you all at sidebar now about your joint proposal of the questionnaire. This is something that is not public. It won't be made public until after it's decided upon and after it is presented to the jurors and they've filled it out. So a blank copy will be available then pursuant to what the law is. So why don't I see counsel at sidebar?
Is this safe, Your Honor?
Excuse me? Yes, thank you.
They got her in there by herself. Karen, you okay? Karen? You know you hear me, Karen. You know you hear me, girl. Act like you trying to... She acting like she don't want to look over here. Look, Karen. He stopped. They just got the camera on her. That's messed up. They just got the camera staring at her. They just got the camera staring at her. Yo, look, they just got, and she trying her best not to look at the camera, and they just got it. It's been like 10 minutes, they just got the camera staring right at her, and she trying her best not to look at it. Vicious. Wicked, wicked, wicked. Yo, they just got the camera on her the whole time. It's like 20 minutes. Bruh. Oh, they vicious. Boy, this news people is something else.
Is that everything regarding housekeeping, logistics, things like that?
Yes, Your Honor.
Okay. All right.
Else,
so
man.
We'll see you on Tuesday morning.
The media is something else. All right, moving right along, man. I want when I end this live, my next live be the actual trial. Actually, day 1 of the trial. So, and I'm rocking out. I'm here for watch hours anyway. I'm rocking out. Let's see what this is. Man, they spent all this time staring at the clock. Oh, I was about to say.
So,
282CR117. Can I have the Commonwealth identify themselves for the record?
Adam Lally for the Commonwealth.
all right, would I want to start with motions that were either allowed by agreement? I just want to make sure our record's completely accurate. And if it's not, it's my error. So motions that I have that were allowed by agreement. I may need to take 1 minute. Jim, I'll be right back. Is that your understanding of where we stand with this motion? The notation that I had written on this was that the defendant has no objection to the admission of statements made for the purpose of medical treatment and medical records. The court takes under advisement testimony regarding the blood alcohol testing because that's a separate issue, and we'll address that today. Is that your understanding of where we stand with this motion?
Yes, that's our understanding. Yes, Your Honor.
Okay. Jim, that was, I already said that, right? 307.
Yes, thank you.
The use of leading questions on John O'Keefe's young niece and nephew, we'll see where we stand. I think I said to Mr. Lally, jurors would rather hear from the witness than the lawyer. So let's see how it goes. And if you think that you need to switch to leading questions, please just come to sidebar. I'll give you the leeway you need, of course, based on the child's testimony or child's manner of testifying. All right, so you were both in an agreement on what I have as 316 and the defendant's motion number, paper 288, regarding any reference to Aiden Kearney, a.k.a. Turtle Boy, or his pending criminal charges for witness intimidation. So both parties have agreed to not introduce this in evidence in their case in chief. If anyone opens the door, the motion will be revisited. And I think I said that I sort of disagreed with you both. I do think if witnesses testify to this spontaneously, then it comes in. And it can be pursued further, but just come to sidebar. All right, 312, Commonwealth's motion to preclude reference to any bad character or any prior misconduct of the victim or any witness. That was allowed by agreement, Ms. Giannetti?
Oh, yes. Oh, no, that's agreed.
That was 312, Jim.
Thank you.
313, motion eliminate to exclude character, reputation evidence of the defendant. You're not putting in reputation evidence, right? We talked about this, Ms. Giannetti?
This is a motion to exclude good character evidence. Is that?
It's paper number.
By the Commonwealth.
It was filed by the defendant, and I questioned whether you intended to put in character evidence, and you told me no.
That is accurate.
Okay, so that's allowed too, Jim.
Which one was that?
313, let me just check.
That's a Commonwealth.
It is. Commonwealth's motion. It's 313, other Commonwealth date stamped, I guess, or date stamped 23.
Thank you.
There was no objection to the Commonwealth's motion eliminate to introduce certified records from the registry, correct, Ms. Giannetti? Okay.
Correct.
All right, and then motions that perhaps were not agreed upon, but I previously ruled on. So I think I ruled on them. If not, these are my rulings. 297, Commonwealth's number 7. Commonwealth's motion eliminate to preclude reference and redact the manner of death contained on the victim's death certificate. And I think I said in open court, this motion is denied as to cross-examination of the medical expert, but that undetermined language will not appear. That will be redacted from the death certificate. You'll have the live witness here to cross-examine as to that. So, Jim, that's 297.
Yes, Your Honor.
Commonwealth's motion eliminate to prohibit reference to any federal investigations, paper 317, Commonwealth bold stamp 27, to prohibit reference to any federal investigations conducted by the U.S. Attorney's Office and or Federal Bureau of Investigations. That motion was allowed after hearing. 305 is the motion regarding chalks. We'll address that when we address the defendant's motion regarding the audiovisual person. The third-party culprit, the ruling's clear on that, not in opening. That's 320-30. I think that was clear when we talked about it. All right, so those are the ones that were fairly quick to just go through. I've got another set that are sort of in the fairly quick range, and then we'll move on to the Commonwealth's discovery-type motions. So first, paper 284, defendant's motion for sanctions and exclusion of evidence based on the Commonwealth's failure to timely comply with discovery orders. Mr. Jackson, you told us at sidebar the other day that you are withdrawing that motion, correct?
Correct, Your Honor.
All right, so Mr. Clerk, that's motion 285, paper 285, withdrawn by counsel.
I'm sorry, 284?
Okay, I have it as 285. But
285.
Okay, yep, so 283.
Thank you.
Withdrawn by counsel. Motion eliminate for review. So as defense counsel plainly states that a defendant is not entitled to be present at a view, and what I've determined here is that based on concerns for security issues and frankly distracting the jurors, the defendant will not be present with us on the view. And as you've stated here, that is well within my discretion. All right, Commonwealth's motion eliminate to admit defendants' out-of-court statements as statements of a party opponent. So I think that this was one of the ones that you all agreed to. Paper 308, 18 on the top, and it's followed by paper 19 regarding the various statements made to the media, to Boston Magazine, to ABC News correspondents. So I think the defendant had said previously that you were in agreement that all these statements come in. Is that right, Ms. Giannetti?
Sorry, Your Honor. Yes, that's correct.
All right. So I had a logistical question about, I don't know how long the ABC News interview is. How long is that?
Your Honor, what I can say is as to each of those, the Commonwealth's intention would be to play, to omit the entirety of the interviews, but to only play selected portions of those interviews.
All right, because what I did, I re-listened to the nearly 4 hours, 3 hours and 40 minutes of the Boston Magazine audio, and there's no objection to it from counsel. What I listened to, it made sense, and I didn't know how you would play a 3 hour and 40 minute audio. If you think you need to, we just need time to be able to put it into the schedule.
Sure.
Okay?
No, I don't feel the need to play the entirety of it.
Okay. I was involved in a trial once where we watched a whole movie. So just give me a heads up if you think it's a lengthy segment. But how long is the ABC interview, just in case counsel wants to go back and fill in?
I think the portions that we have are not terribly lengthy. And as far as the statements are concerned, it's even less of that.
All right. So does defense counsel intend to also play? I'm trying to find out if we're going to need a whole 3 hour and 40 minutes. I need to know that. I still haven't got an answer as to how long the Dateline or ABC, whatever it was, video and audio is. How long is the entire thing? Do you know?
You're asking me?
Either of you. I don't have that, so I didn't review it.
May I have just a moment with
Yes.
counsel?
My memory and my belief is I think, and I can't recall specifically which one is one or the other, but I think one is about 10 minutes long, the other is about 5 minutes long, and again, I would only be playing, if any, portions of the defendant's statements, not the entirety of the broadcast.
Okay.
And if there are portions that weren't played, I would expect.
So that's what I'm trying to figure out. So I'm concerned on the 3 hour and 40 minute one, which seems to be all of it's admissible. There's no objection.
Yeah, damn, gotta be careful with them interviews too, because they got the interviews. They taking everything. Everything's in court. Everything. Hey, listen.
The evidence is going to show.
Everything in court, man.
To it, and if I just need to know if we're going to play something for 3 hours and 40 minutes. The other one, if it's 15 minutes, I don't need as much heads up.
My guess would be anything that we would want to present that wasn't presented would be in the 15, 20 minute
Okay,
category.
that's
Not 3
fine.
hours.
It's just for scheduling purposes. Right. All right. So Jim, paper 309 and 308, they're the same pretty much. Those are allowed by agreement. All right, and it's sort of in the same vein. So it's another statement of the defendant. It's the statement of the defendant at the Milton State Police Barracks that I had not seen before because it was post grand jury, and we watched it. I had the opportunity to watch what we all watched here in court last Friday, and over the weekend I watched the entire hour and a half or so of it. So you're in agreement that the statement comes in, and the Commonwealth says that the Commonwealth needs some leeway to show that she was in custody after arrest for a period of time, and Commonwealth wants to play the video. I don't think we need the video. Much of it is just looking at their computer. So the video part will be out. You don't want it in, correct?
That's correct. We
Yes.
asked for the audio only.
Yeah. Okay, so the audio only, but it needs some context. It's not just that she's sitting down having a cup of coffee with the police and makes these statements. So they're clearly voluntary, clearly unsolicited. How do you want to work that out? Can it be that this occurred at the Milton State Police Barracks on a particular date? Because if you can't work it out, then I'll decide it.
I mean, from our position, Your Honor, we don't object that the statements were made at the Milton State Police Barracks as they were, and it was in that context that she was speaking to the police at the barracks. We would object to introducing evidence that she was under arrest at that time.
Yeah, I don't think we need that. But so at the Milton State Police Barracks on a particular date.
That's acceptable.
Do you need more than that, Mr. Lally, for context?
No, Your Honor.
Okay. How is this going in?
Through the trooper to whom she was speaking.
Okay. All right. All right. So, Mr. Clerk, audio only. Commonwealth may elicit testimony. Statement occurred at the Milton State Police Barracks. Mr. Lally, do you remember the date?
June 9th, 2022.
Thank you.
22? Yes.
Okay. So audio only, Mr. Clerk. Commonwealth may elicit testimony that the statement occurred at the Massachusetts State Police Barracks on June 9th, 2022. All right, so those are the fairly quick ones. Before we get to what I think are the more complex ones, or the ones that I need a little bit more argument from you on, I am concerned about discovery. So Mr. Lally, when I was going through copies of what I had previously, the first time or one time that you, Commonwealth filed on March 21st of this year, a notice for reciprocal discovery and notice of experts. You then, last week, I think, filed a renewed motion for reciprocal discovery and request for voir dire of any defense experts. You asked that that be impounded, and that will be based on your motion and appears to be sort of an affidavit in support. So where do we stand with discovery?
So with reference to the reciprocal discovery, what Commonwealth is seeking is noted there are a number of witnesses listed on the defendant's witness list with no materials provided as to who these people are or what their intended testimony is. The issue with regard to experts is essentially there are 5 experts. Mr. Green, who there was an attachment to a motion with an affidavit and some materials. I think I have everything in relation to that. With regard to Dr. Sheridan, I have an affidavit and a curriculum vitae, and that's essentially it with respect to that. I just am inquiring as to whether or not there are any reports or any other sort of findings or anything post that. The other 3 experts all relate to that specific, I'm sorry. The next would be Dr. Van E., who...
Which, I'm sorry, I didn't hear you.
Dr. Christopher Van E.
Yeah.
He's a little... so essentially there are that gentleman and then 3 individuals from this ARCA company who are all purported to be testifying in the area of crash reconstruction. None of them are crash reconstructionists. They're all biomechanical or biomedical engineers. With regard to Dr. Van E., who I've had some experience with in the past, my typical dealings with him is there some sort of report written by him. I have nothing. I just have a CV and about a paragraph of what's anticipated as far as his testimony. The other 3 individuals, my issue is there is a report that's within the federal materials in relation to what they did. However, it's a single
In relation
report.
to what?
In regard to whatever examinations or tests or whatever that...
Does it include all 3 experts, though?
Well, so that's the issue.
Yeah.
The issue is the report is signed by all 3 individuals. So I have no idea who did what, who would testify to what, who has an opinion as to what, or what that would be. So I'm just looking for some additional information or any clarification as to what each of those respective people would be testifying to beyond just all 3 signed a report.
Okay, who's arguing this for the defense?
With the court's permission, I'd like to handle the issue regarding civilian witnesses and have Mr. Jackson address the experts.
All right.
So my argument's very brief, Your Honor. We're well aware of our obligations under Rule 14, and any statements that we have regarding civilian witnesses that fall into that rubric, we will turn over, and we have.
But why haven't you?
No, we've turned over what we have. In our view, we've complied with discovery with regard to the civilian witnesses that Mr. Lally speaks about.
All right. Do you have addresses for those witnesses, Mr. Lally? All right, so they need addresses, right? If there's nothing there, they need the addresses so the police can go out and interview them.
We will get them addresses by the end of the day today.
Okay. All right, so my concern was that when, Mr. Lally, when did you file your certificate of compliance?
That would have been, I believe the Wednesday, not last Wednesday, the Wednesday before that.
And I had previously told counsel I would expect within 2 days of that because obviously you've been preparing this case for a long time.
Of course, yes.
But so to have Mr. Lally stand here today and say that he doesn't have all this information that you know he's entitled to, I mean, dates of birth and addresses of witnesses are pretty standard, Ms. Giannetti, especially if you have, not provided anything that they're going to say. So that should have happened a week ago.
Your Honor, if I
About a week ago.
Okay. And we do have to talk about how we're going to do this at trial. Okay.
Yes.
Your Honor, I provided reciprocal discovery to Mr. Lally within 24 hours of receiving the certificate of compliance.
Anything about these witnesses that Ms. Giannetti says they have everything on?
Yes, he's received statements from all the witnesses that we have statements for, which included their dates of birth, addresses.
How many is that, Ms. Little? How many witnesses?
I don't know off the top of my head, but every single report that we have for these witnesses that Mr. Lally has received in his witness list, he has reports for.
Okay.
And a number of our witnesses, obviously, are witnesses that the Commonwealth has interviewed.
Right. I think I crossed out much of your list when I read the names of the witnesses, right? Because they were duplicates.
So we have complied with at least those obligations. And if there's any addresses that we haven't produced, I will make sure that gets done today, but he should have the vast majority of everything.
All right. Anything specific, Mr. Lally, on the civilian witnesses?
Well, just in looking at the defense witness list, there are 77 witnesses that are listed. 35 of them are on the Commonwealth's witness list, and I have statements from 4 witnesses, not including experts, so that would probably make it to 9, or if you include the investigator, 10 or 11. So there's still a substantial amount of witnesses that I don't have addresses, date of birth, or any statements from, or even what their anticipated testimony would be.
Your Honor, there's also probably an additional 10 to 12 witnesses that he has reports for from the federal materials, which include addresses, statements, that type of information.
All right. It's my view that that's still the defendant's obligation to provide, all right, or at least acknowledge where they are. All right. Let me hear the expert response, Mr. Jackson.
Your Honor, with regard to Dr. Van E., Chris Van E., first of all, he is technically a rebuttal witness. There's a trooper named Trooper Paul that's going to be called in the Commonwealth's case in chief, and he's going to testify to some key cycle information. Key cycles are trigger events or cycling events with regard to the SUV. Chris Van E. is expected to testify in rebuttal to Trooper Paul's testimony that his Trooper Paul's analysis of the key cycles is flawed in terms of timing and the number of key cycles that he relates back to an event that takes the SUV back to 34 Fairview. So Chris Van E has done a similar analysis, or at least overviewed or looked over Trooper Paul's analysis and has determined that Trooper Paul's analysis is incorrect. So we included his name, although he's a rebuttal witness, we included his name just to be in an abundance of caution. He's not produced a report.
Do you have to at least tell the Commonwealth what he bases his opinion on, what he has viewed, what he bases his opinion on?
The exact same information, the raw data that Trooper Paul based his opinion on.
All right, so is this the first you're hearing this, Mr. Lally?
There's kind of a vague description to that effect, but again, what I'm hearing is similar to that in the sense of he disagrees with the Commonwealth's expert, but I don't have any foundation for that or what specifically he disagrees about or what his points of contention would be with Trooper Paul's report, as far as no report, no basis of opinion, no anything of that nature. That's my concern.
Okay. And you've requested a voir dire?
Yes, Your Honor.
Of the experts? All right. We don't want to bring this witness out here early for a voir dire, so I suggest you get the information that was requested.
I'll be happy to.
If we have to bring him out, we have to bring him out.
No, I'm not looking to bring him out, and I don't think that he needs to be voir dired. He's going to look at the exact same, and I'll call Mr. Lally and explain to him what I think in a little bit more granular detail is going to be the sum and substance of his testimony, but Mr. Lally he certainly can conceive, as Trooper Paul walks through his analysis, Chris Van E is going to walk through the exact same analysis. It's the same data set. They're both working with apples and apples. He just has a different conclusion that the key cycles are not in keeping with what Trooper Paul analyzed because he left some key cycles out. Pretty simple stuff. But I'm happy to contact Mr. Lally offline and let him know exactly what it is that
All
has
right.
a
All right. So you do that, and if it's not resolved by Monday, we will pick a date within the next week to have voir dires of whatever experts that insufficient discovery has been provided to the Commonwealth on. So let's try and work everything out. The rules are very clear, and you need to provide this information.
And I thought we had, but I'm happy to have that additional conversation. And I'll do the same thing with regard to the ARCA witnesses as well.
So is there anything specifically, Mr. Lally, that you're looking for today in response to the biomechanical engineers?
Just specifically what their opinions are and what they're based on.
And who did what?
Who did what?
Should be fairly easy to provide, Mr. Jackson.
It has been in about a 9 or 10-page report that's detailed, single-spaced.
But does it say who did what? I read the report as part of the federal materials. I couldn't figure out who did what. So
okay, I'm happy to talk to Mr. Lally about that. I believe the answer is going to be, in sum and substance, all of them work together as a team to come to the opinions and conclusions that are recited in the report. But I'll be happy to have an additional conversation with Mr. Lally about that. I don't know that I know every single thing. As a matter of fact, I don't know every single thing that everybody did, who screwed what bolt into what nut, etc. But I think, by and large, Mr. Lally and I can come to an agreement about what the contours of each of their testimony would be.
Okay.
And by the way, they are accident reconstructionists, so there's a...
Do you have their CVs?
I do, and so does Mr. Lally.
I
do. Anything on the CV about being accident reconstructionist?
There is listings of accident reconstructionists, but I think that's part of the Commonwealth's request for a voir dire is the qualifications, I don't think, meet that standard for them to be able to testify in that area.
All right, so two things. When the two of you are working on this between now and Monday, if the Commonwealth is not satisfied in requesting a voir dire, I need to hear from the two of you whether we need to do that before the evidence really gets started, or if it can be done before the witness testifies.
Okay.
All right.
Understood, Your Honor.
All right, so Commonwealth's motion for voir dire of any witness to be asked for opinion or character of defendant or any witness. I had that this was allowed by agreement, 314, DS number 24.
That's agreed.
And 304, Commonwealth's bolded number 14, Commonwealth's motion for order regarding opening statements and notice of any visual aids defense intends to display to jury during opening statement. So I need to know what parties intend to put up for exhibits or for chalks, whatever you intend to put up in opening. And I know you're doing the opening, Ms. Gianetti, so I need to know what you intend to display.
Nothing.
Okay, that makes it easier. So while we're talking just briefly of openings, you had told me, Ms. Gianetti, that you thought you could get everything in 35 minutes. I will give you both 45 minutes.
Oh, that's perfect. Yes, I'll be less than 45.
I'll hold you to that.
I know you will.
All right, so Mr. Lally, 45 minutes for the Commonwealth?
Yes, sir.
Okay. All right. And Commonwealth, do you intend to put anything up during openings?
During openings, no, Your Honor.
All right. Okay. Commonwealth's motion eliminate for notice and voir dire of Bowden. I thought that was, we decided that there would be a voir dire regarding before the Bowden testimony comes in.
I don't recall that, Your Honor.
All right. Well, Commonwealth's entitled to a voir dire. There'll be a voir dire.
My understanding of the court's ruling, as it applies to opening statements, is that I cannot point the finger at a third-party culprit, but I can introduce the idea of an inadequate investigation and discuss Bowden evidence.
As long as you know what's coming into evidence.
That's perfectly fair.
Remember, I use that term competent evidence.
Of course.
That's what it has to be.
Of course.
All right. I'm sorry, Jim. 321, the Commonwealth's bolded 31, in case my number's not right.
Thank you.
319, So this is, we talked a little bit about this. It's Commonwealth's motion for advance notice if defendant intends to cross-examine any witness about alleged bias and request for pretrial ruling on whether the proposed evidence demonstrates a plausible showing of alleged bias. So as you well know, Mr. Lally, bias is definitely an area that is ripe for cross-examination and extensive cross-examination. I needed to know exactly what your concerns are.
And, Your Honor, I think what I would suggest might make the most sense with this is to sort of take it as it comes.
Okay.
I think it's a little difficult to put counsel in a position to, cite specific things that they wish. And
we have a couple of motions where we do need to do that.
Right.
But for generally with this, and because this was broad, that's why I did want to, when we had a brief hearing on this, I said that I did need to hear from you regarding specific statements. So what we're going to endorse this, Mr. Clerk, is that Commonwealth will object on a question-by-question basis. Does that work, Mr. Lally?
Yes, sir.
Does that work for the defense, Mr. Yannetti?
For sure.
Okay. Commonwealth will object to specific questions.
Thank you.
And Mr. Lally, if you know in advance, depending on how the testimony comes in, if a particular witness gets up and you know before any examination what your concerns are, we'll visit it before the testimony.
Understood.
Okay?
Thank you, Your Honor.
A similar motion to the defense expert issue. Mr. Clerk, I believe it's 315. It's bolded number 25 from the Commonwealth. Commonwealth's motion eliminate to prohibit defense experts from testifying regarding scientific studies or anecdotal experienced and request for voir dire. Mr. Jackson, do any of your witnesses intend to give anecdotal experiences?
I said this in the argument. I don't really know what that means, but no, in a common sense knowledge of, common sense definition of what that is, to my knowledge, they're not going to be talking about it.
Okay, I think it's pretty clear what it is, but if you think they're not going to do it, if it seems that they are, then we need to know. And how about the scientific studies?
The scientific studies would not be referred to in any of their testimony that I'm going to.
Okay.
They did some scientific studying of the material.
No, do you mean like learned treatises and things like that, Mr. Lally?
Exactly, Your Honor.
Yes.
They're not going to be citing some learned treatises that I'm going to listen to.
Okay. All right, that's it in my category of discovery. There's some overlap in the motions that I think the following motions may take a little bit more time, and it's sort of the somewhat complex ones. So 311, Commonwealth's bold number 21, Commonwealth's motion eliminate to admit the victim's out-of-court statements relating to his state of mind. There's sort of some overlap, Mr. Lally, that we'll get into with other statements. But so this is the Commonwealth versus Qualls, Commonwealth versus Binns, that whole line of cases. Why don't I hear you? Is there any objection to this?
We may have a moment.
The Commonwealth, we were here last, the Commonwealth was told that they need to provide with the statements or the areas they intend to introduce. They do so in this motion. They do more extensively in another motion that's sort of dovetails. And the other motion concerns the Aruba incident, the arguments between the defendant and Mr. O'Keefe, and also this Binns/Qualls type testimony.
Right, so I think our position, Your Honor, was that we need to know the specifics of what they intend to introduce. My expectation is that some of that will be admissible and some of it we won't have an objection to, but it's difficult to give either a blanket objection or a blanket assent without knowing the specifics.
Okay, but you did sort of make a blanket objection to the Aruba incident, if we call it that.
We had to without knowing the specifics.
So on the second page of this motion, the Commonwealth intends to introduce statements the victim made to his family members and friends close in time to the murder about his relationship with the defendant and his decision to terminate the relationship. The Commonwealth also intends to introduce the victim's statements through text messages authored by the victim and contained within the victim's cell phone that express his decision communicated directly to the defendant to terminate their relationship. That goes squarely with Qualls and Binns.
Right. With regard to the text messages, I don't believe we have a basis to object.
All right. So I'm also going to allow statement. Mr. Lally, tell us what the statements specifically, as best you can. Who would be testifying? What family members? Does this involve the two children?
Yes, Your Honor. So there are statements that are made by the victim to the defendant in front of each of the two children with his intention to...
What are they roughly?
Essentially that the relationship isn't working anymore and that he would like to break up with her, ask her to leave the house. She refuses, and this is in front of both the niece and the nephew.
All right. Ms. Giannetti, I'll hear you on that.
Our expectation is any statements that were made, allegedly made by Mr. O'Keefe to my client in front of other witnesses, we don't have a basis to object to that.
Okay, so that's coming in. And you've had the benefit of the sane interviews for a long time.
Correct.
Right, so.
We don't waive potential hearsay objections during trial, Your Honor, but I think generally that's our answer.
All right, so on 311, Mr. Clerk, I'm going to allow that.
Yes, Your Honor.
Okay. All right, so sort of the same. 310. And the defendant's is 283. It's a similar motion. So Mr. Lally, why don't I hear you on this? So this is the one when I said there are 3 areas here as I see it. If we call it the Aruba incident, the animosity between the defendant and the victim in weeks and days prior to the victim's death, and that the defendant admitted to numerous witnesses at different times that the last thing she recalls was getting into an argument with the victim. So that whole domestic violence line of cases with state of mind clearly is admissible. So why don't I start with you, Mr. Lally? Go ahead and argue your motion.
So, Your Honor, specifically, what the Commonwealth is seeking to introduce there is you have the incident in Aruba, which there are really 4 witnesses who have information to provide to the jury.
Do we need all 4?
Well, so from different perspectives is what I would say. So 2 of them are, the incident or altercation occurs in the lobby of the hotel where the defendant, the victim, and the children are staying along with a larger party of friends of the victim. Following that incident, both children indicate that there's approximately 20-minute screaming match or something to that effect.
Both children were present?
Yes, within the hotel room, and both indicate to that. Then you have the woman, Marietta Sullivan, who's involved in the incident in the lobby, and then you have her sister, who is the person who invited them on the trip in the first place.
There's some additional testimony from these witnesses too, other than just the statements?
Correct. So the additional testimony from the sister who invited them on the trip, she's not a recipient witness to the altercation. I wouldn't be asking her anything about that. What I would be asking her about is just her observation. So she had gone out the evening prior with the victim and the defendant to dinner, and sort of the disparity between sort of their demeanor on the night before versus post this incident. And there was some statements that Mr. O'Keefe made to her about sort of the nature of their relationship, or the nature of his relationship with the defendant.
And those statements have been provided to the defendant?
Yes, sir.
There was testimony in the grand jury regarding those statements?
There is, yes. There's state police reports as well as testimony from the witness in the grand jury. In addition to that, as far as statements relative to the nature of the relationship, there are some minimal statements that are made by the defendant to a couple of witnesses at the waterfall the night before. Again, those are also contained within troopers' reports in the grand jury testimony of those witnesses. There are also the text messages between the victim, Mr. O'Keefe, and the defendant, which specifically address the nature of their relationship. There are text messages from the defendant to Mr. Higgins, which again specifically address not only the Aruba incidents weeks later, as well as and being a continuing point of concern, at least from the defendant's perspective, as to the nature of their relationship. And then taking all of that sort of in conjunction with the text messages between the 2 that day and the voicemails messages that the defendant left on the victim's cell phone shortly after the murder occurs. And then there are further statements that the defendant makes to a number of different people, whether they be troopers, whether they be paramedics, whether they be Ms. McCabe and Ms. Roberts, or in the presence of them, as well as at least 3 paramedics, indicating that the last time that she saw the victim, Mr. O'Keefe, they had gotten into an argument essentially at the house at Fairview Road right before she had left. So those are sort of the totality of sort of specific areas in the nature of the relationship that the Commonwealth will be seeking to explore through the testimony of a number of different witnesses.
Okay. Who's arguing this for the defense?
I will, Judge. As I'm listening, there seems to be quite a few different categories of information that the Commonwealth is seeking to introduce, and through different means. So, it's difficult to, again, just give one blanket objection or one blanket assent to this. Generally speaking, witnesses who would testify about statements of Mr. O'Keefe's state of mind, that probably comes in.
We talked a little bit about that. That's the Qualls and the Bins line of cases. So
correct.
I did rule that those are coming in.
We recognize that,
okay.
Yes.
You said probably.
Well, yes. Well, Mr. Lally raised it again, so...
And you don't have to assent. You can object to anything you want to object to, and I make the call. I mean, so you don't need to point out, you don't need to apologize for objecting. Just go ahead and tell me the defendant's position.
Right, I understand, Judge. I think the position here is that we recognize that much of this will come in, but we don't waive the ability to object to a specific question in terms of what it asks for, how it's phrased, what could potentially come in if the question's too vague. So that's my hesitation on that.
So that's well taken. So even if you assent to it, doesn't mean that if a question crosses the line, you're prohibited from objecting to it. I've never done that before.
That's my point.
Yeah. So you haven't tried before me before. I would not do that. So I find that, let's say for the Aruba statement, all of these go to state of mind and motive. I will give a limiting instruction. I will make the findings that I need to find. Pursuant to Commonwealth versus Samir, it's a footnote in that case. It's footnote 8, I believe. I will make those findings at the time. There's certainly been a sufficient showing from the Commonwealth. So I will give a limiting instruction. I will welcome proposed limiting instructions if you want to file them. I know you're all busy. If you don't want to, that's fine. I can handle that. Regarding the animosity, again, it's close in time. It goes to the nature of the relationship. I will give a limiting instruction. I'm confident that the limiting instructions will be followed by the jurors, that they're understandable. I will make observations at the time, and if they appear to be understanding and nodding, which you often see on limiting instructions, I will make those findings as well. But I'm satisfied that the jurors will be able to understand a limiting instruction and use the testimony only for the intended purpose. And the animosity goes to the nature of the relationship, goes to the domestic violence line of cases. And the argument being the last thing that the defendant says she recalled, and the children's testimony regarding ending the relationship, again, that goes to state of mind, and it goes to the Qualls and Bins line of cases. And I will give a limiting instruction. I'm confident the jurors will understand. So that's my ruling on that, which actually, so it would be a denial, Jim, of defendant's motion 283.
Just for the record.
2. And that's denied. I mean, it will not go to propensity, and we can make sure of that. And the Commonwealth's motion is 310, Jim, the bold 20, and that was sort of hand in hand with the other one. All right. So moving on to, I think we just briefly talked about, so it's paper number 306, Commonwealth's motion eliminate to admit expert celebrate demonstration. I think we briefly talked about it, and I wanted to know, so are the defendants objecting to the, so your witness's name again? I read it every day for the last week.
That's okay. So Mr. Ian Whiffen.
Yes. So about him doing a demonstration, is there an objection to that from the defense?
Your Honor, since the last time we were in court, we've had an opportunity to look at that.
Yeah, I'd like to look at it, but okay, so you looked at it?
We did. It's not that long. It's maybe, I don't know, I want to say 22, 25 minutes, something like that. We'll submit on the papers and stand on the objection that we previously made, that it doesn't comport with the exactitude that we think is necessary for a demonstration, but I don't think it bears. It's not an enormous deal for us. We do stand on the objection, but I'll submit on the papers.
All right, so I'm going to allow it, but Mr. Lely, I'd also like to see it.
Of course.
Okay, so if you could get me a copy, Ms. Gilman, can you get me a copy of that before the end of today?
I think so, yes.
All right,
I'm
thank
speaking
you.
for him.
All right, so Jim, 306 is allowed?
Thank you.
All right, so the two that may take, there's 3 actually, but the 2 that we'll cover here before we get to sort of logistics and sequestration. Commonwealth's motion to prohibit reference to any pending internal affairs investigations or unfounded allegations. And I did just, I don't know why, I know you filed it previously, Ms. Little, but I just today had the opportunity to read your supplemental memo in opposition. Okay, so, all right, so this is twofold. So I'll hear the Commonwealth regarding Trooper Proctor and also regarding Sergeant Lang.
Sure. Your Honor, with regard to, I think the recent sort of progeny of cases between McFarland and Graham are sort of entirely instructive, I would submit, as far as this particular area is concerned. So when it comes to Sergeant Lang, you're talking about a civil case with no judgment. There was no finding. There was no trial. So I think Graham and McFarland are pretty clear that is not conduct that can be used in a criminal case to impeach a witness.
Why can't it be used regarding? I think what separates this in some respects from those cases, even though there's no finding, is just like the pure bias part of it, right? If there's bias in favor of the Alberts, which is what the defendants say their defense is among the possible third-party culprits. Why can't they cross-examine on that?
But the information that I've seen, I don't think specifically lends to a defense of the Alberts. I think if it lends to anything, it lends to Sergeant Lang being involved in some sort of altercation himself, in whatever extent there's any veracity to whatever is alleged by the other parties to have occurred. Firstly. Secondly, I don't even believe, again, I think we're going to, one Albert equals the entire Albert family kind of thing. And I don't think that any of the Alberts that they point to, or at least that Mr. Yannetti got up and spoke about being potential third-party culprit targets, were even present, involved, or had anything to do with this prior incident. So whether or not Sergeant Lang knows or was 20-some-odd years ago friendly with one member of the Albert family, or even 2, if they're not any people that were at the residence on Fairview Road that night, that were present there in the morning when he arrived, pursuant to a call from a sergeant on scene to investigate, or anything of that like, I don't see how it's relevant to that form of questioning or impeachment, particularly where it's an unsustained finding and there's nothing concrete as to what transpired.
Okay, I guess my question was simply because something might not fit squarely in McFarland and Graham. If it's admissible for other purposes, then it can come in. Right. So who's arguing this part? We'll take these in 2 parts. So we'll do the Trooper Proctor part afterwards. But Ms. Little, I did say I'd give you the opportunity to argue those 2 cases, but if you want to, you can. But I'm more focused on the bias or motive.
I'll just briefly address Graham and McFarland because I do think it's very important that we make clear that both of those cases are completely an opposite to the issue that's before this court, which is admissibility at trial. McFarland and Graham both deal with whether the Commonwealth has an obligation to turn over certain discovery. That's not where we are right now, right? We filed the appropriate motion to receive discovery. We obtained information about an IA investigation. We obviously...
Let's focus on Lank first.
Sure.
Okay. So, I agree with you. They're discovery cases. They're not admissibility cases.
Okay. So that issue aside, Lank has... he's one of the first responders, obviously, who went to 34 Fairview on the morning of January 29th. He's the first person to enter the Albert residence that morning. And he has a long-standing relationship with the Albert family, which is brought in by this sort of prior lawsuit that we brought to the court.
The Albert family appears to be huge, right?
Well,
or very extended family.
Well, I'm getting there. So the altercation that Lank was involved in was after he deputized himself to involve himself in a fight that Chris Albert had been in. Chris Albert is one of the Commonwealth's witnesses in this case. He is Brian Albert's brother. He was with them all that night on the 28th. His son, Colin Albert, as you know, is a third-party culprit. So this is not some tangential family member. This is...
Who would you intend to... If I allow this, and we really need to see how things develop beforehand. So, Mr. Yannetti, I can tell you right now, I'm not going to allow you to open on this because I need to see how the evidence comes in.
It's not part of my opening.
Okay. Who would you intend? I see you have the Lapalito brothers on the witness list. I think that goes far further than I would allow. But who do you intend to get the testimony in through, and how?
Through Sergeant Lank himself. I think we need to be afforded the ability to cross-examine him. Once that's done, we may need...
if he denies it, and we'll figure that out.
But I think the first step is allowing us to inquire as to his relationships and the connection that he has to the family and this incident that occurred.
So you can certainly inquire as to his relationship with the family. It's the incident. I need to see... Again, just reading of everything that I've read, Sergeant Lank doesn't have... His testimony isn't as lengthy as other witnesses, right?
I don't think that that's necessarily true, Your Honor, as far as our cross-examination.
Okay, but for his direct is not as lengthy as other witnesses.
I think that's fair to say.
Yeah. So all right. So go ahead. So through him, through Chris Albert.
Through him, potentially through Chris Albert as well, Your Honor.
Okay. All right. So Mr. Yannetti's not going to open on this, and he said he wasn't planning on it anyway. So let's see how the evidence develops. It may be that we have a voir dire of Sergeant Lank and Chris Albert beforehand. Okay. So I'm not going to take any action on this right now.
Okay.
But I'm not denying it as the Commonwealth's requesting me to do.
Thank you, Your Honor.
We'll see where we go with this. Okay. All right. So now let's deal with the Trooper Proctor part.
So, Trooper Proctor, Your Honor, in regard to any IA investigation, which we have not received any material in regard to other than its existence. And I want to be clear on that because I think counsel might be a little confused by some material that we provided to them. So there were some interviews in regard to any sort of areas of potential bias with regard to Trooper Proctor and certain members of the Albert family. That was something that we did. So we had asked and a couple of captains from the state police who are completely divorced from the investigation and completely divorced from our office conducted interviews with regard to Trooper Proctor and a few of the other civilian witnesses.
Okay. How recently? I mean, it's all recent. When was that?
That was, I think, all discovery related to that was provided to counsel the week prior to trial.
Okay.
But they were done sort of in the weeks leading up to that.
Is that part complete?
Yes.
Okay.
So as far as the IA investigation goes, just the mere fact that there is an IA investigation, the Commonwealth would submit is not an appropriate area for cross-examination, particularly when it's an open investigation. There are no findings and falls squarely within McFarland and Graham. And I understand what the court's comments before about them being primarily discovery cases, and I would agree with that. But they also go to discovery cases as far as so if something can't be ordered to be provided in the course of discovery, then I would submit inferentially inadmissible. So what I'm suggesting with this motion, what I'm arguing in this motion, is that whereas there is no findings of liability, there's no findings of any wrongdoing or anything of that ilk, just sort of putting out there that there's an open IA investigation without anything more because nothing else exists at this point.
Why wouldn't it go to his bias and his motive? If he's under investigation, why wouldn't he have the motive to testify favorably, or why doesn't it go to that? Maybe not the fact that it's IAD, but just there's an ongoing investigation that he's aware of, that he's involved. And I don't know if his job depends on it. I don't know that. Maybe there's not enough to know. But why isn't that motive and bias on his part? Do you think that's prohibited by Graham and McFarland?
I do. And just for that specific, because essentially what it allows a defendant to do is to pursue a line of questioning that they have no idea what that line of questioning is or what it will eventually be. And it could eventually turn into nothing. And to allow that sort of imprimatur of the court to allow that sort of questioning into an area that is completely unsettled and completely there's no evidence to substantiate other than the fact that it exists without any sort of finding, without any sort of evidence to support it. I mean, we don't have any evidence as far as what that is or that it even pertains to this case. So with regard to all of that, I understand, that outside of McFarland and outside of Graham, that there are other avenues, as the court was alluding to, as far as motive, as far as bias, as far as things of that nature. But when it's just so scant as far as what that is versus sort of the connotation behind those questions, I just think it's unfair to the Commonwealth, it's unfair to the witness to be put in that position when there's really no information available.
All right. What do you say, Ms. Little?
Your Honor, I think that ADA Lally's representation that we don't know what this investigation is about is disingenuous, to say the least.
Why so? Why? Is there
Reason
something in the, hold on, is it something in the information that you've received
Yes, Your Honor.
from Mr. Lally?
Yes, Your Honor.
All right, so can I get a copy of that?
Yes, sir.
Okay.
So, as the court knows, first of all, Graham and McFarland deal with the Commonwealth's mandatory discovery obligations, right? Those courts also very specifically state that there's mechanisms outside of those mandatory discovery obligations for defendants to obtain information that's relevant and admissible at trial. That's why we filed a Rule 17 motion requesting these disciplinary records, and that's why that was granted.
It was granted because the Commonwealth did not object.
So, regardless, we've obtained those records, and the cases that Mr. Lally continues to cite do not stand for the proposition that that's the only mechanism by which information can be produced at trial. Those are discovery cases, they are not admissibility cases. Pursuant to that request, we have received information discussing the IA investigation at which Trooper Proctor is being questioned specifically about this case. This is not an instance where we're questioning whether or not there's a basis for an IA investigation. It's clear this investigation was predicated on the materials that were produced to the Commonwealth by the federal authorities in this case.
And initiated by the Commonwealth. The IID investigation was initiated by the DA's office, correct?
Well, as far, and just to correct what I certainly didn't mean to impute that this case had absolutely no bearing or there was no
I didn't think you did.
But what I was saying with that is we don't know what the full extent of that is. But as far as what counsel is, what the court's question as far as the IED, it was something that our office had spoken to. We felt we had a duty to disclose to State Police Legal Counsel, and then they referred to the IA, and that's how that investigation began. As it pertains to what counsel was talking about, that has nothing to do with IA. So the materials that the Commonwealth has provided, that was a completely separate investigation initiated by the District Attorney's Office.
Okay. Okay.
The IA investigation came on the heels of this information being produced to the Commonwealth. This is not a situation in which we're really questioning what the basis of that investigation is. The Commonwealth has in its possession numerous materials that suggest there has been significant misconduct on the part of Trooper Proctor. That will come out at trial.
How? How?
Through cross-examination.
What if they don't call Trooper Proctor?
We will call Trooper Proctor.
To impeach him?
Yes.
All right, so be prepared to argue that. I don't know. He's on the witness list. He's the first person on the witness list. They're probably calling him. I'm just
He's the lead detective
hypothetically
in this
throwing it out
case.
there.
He's conducted every single step of this investigation.
With others, right?
Excuse me?
With others?
Sometimes, but he is the primary investigator in this case. And I think it's very, very important for the court, and I think you noted correctly, that bias and motive are absolutely critical to Ms. Reed's right to defend herself at trial. We have to be able to explore those issues. And in order for Trooper Proctor to testify, he has a motivation to testify in a certain way to avoid liability in this pending IA investigation. So I think it's unfair to tie our hands behind our back and not be able to question him about this, because it directly drives his bias and motive in this case and gives him reason to testify in a certain way, knowing that he could face career consequences if he doesn't.
Do you intend to try and open on this, Ms. Giannetti? Because I need more information.
I'm not going to mention the IA investigation in my statement.
All right, so Mr. Lally, if you can get me that information that you mentioned that you had sent to counsel, I'll take a look at that. It may well be the fact that there's an investigation without what the nature of the investigation is, but that there's an important investigation, and if you can show me in advance that his job may depend on it, things of that nature, there may be cleaner ways to allow this testimony in. So, all right, so we need a little time. I need to read those materials.
Sure. And for the court's edification, I don't anticipate he's sort of towards the middle, I would say.
Okay. All right, good. And the more fully the record's developed, and the easier to rule on some of these motions. I just want to give you all some idea so you know how to prepare for the next 2 weeks. So, all right. So not in your openings on either one of these, Ms. Giannetti, but you agree to that. So this is still under advisement. It may be certainly with Lank or Sergeant Lank of voir dire of Sergeant Lank and of voir dire of Chris Albert. We'll see how the evidence develops, and I'll read more about the information that the Commonwealth was provided. So 318, also it's 28 bolded from the Commonwealth. All right, so Commonwealth's motion eliminate to admit, this is, you know what, I don't have a number on this one, Jim. Commonwealth's motion eliminate to admit results of defendant's blood draw at Good Samaritan Hospital and resulting serum conversion and retrograde extrapolation.
Judge, that's paper 339.
All right, and the Commonwealth, I mean, the defendant's is 289, so addressing the same issues. Yeah, I told the Commonwealth to put this in writing. So I guess it's defendant's motion, so I'll hear from the defense. Your motion 289.
Thank you, Your Honor. With regard to that, we've put most of our argument in the paper, so I don't want to rehash all of those. The issue is really the foundational issue, not the extrapolation. The extrapolation is sort of a garbage in, garbage out argument, like computers. We think that the underlying blood draw did not follow the proper protocols that it should have followed. Therefore, the veracity of that particular blood draw is at issue.
Right. Can I just ask, the Commonwealth intends to have witnesses here to testify to that, right? How the blood was drawn, all of that?
The Commonwealth would have the doctor that ordered the blood draw, the nurse / nurse practitioner, I summons both, as far as who took the blood, and then the director of the lab at the Good Samaritan Medical Center.
Okay.
But I hope
so let me get back to Mr. Jackson, and then I'll hear you on that. I just wanted that. I'm not sure we had all that information when you filed the motion, but does that change anything, Mr. Jackson?
It doesn't, because the individuals that did the blood draw, it wasn't done in an accredited manner. I'm not arguing with the fact that the blood draw was taken, that somebody was a phlebotomist actually took the blood, but it wasn't done with the protocols or the accreditation that's required under Massachusetts state law and Massachusetts State Police Crime Lab. Their protocols were, I apologize, their protocols were breached internally, and given that breach, we believe that any extrapolation based or founded upon those faulty blood draws, those unaccredited blood draws, are suspect as well. So the sum and substance is that you can't trust the extrapolation if it wasn't an accredited and a foundationally solid blood draw to begin with.
So if all the witnesses are here for cross-examination, why doesn't that go to the weight of the evidence instead of the admissibility?
Because we think that the admissibility is based on the protocols that the Massachusetts State Police have put in place. If they didn't have accreditation protocols, it wouldn't mean anything. It probably would go to the weight, not the admissibility. I think the admissibility is predicated on their own rules. They don't get, in our view, they don't get to break their own rules and then say, oh, well, let's just let it go to the weight, not the admissibility. We believe that it's important enough that it shouldn't ever come in front of the jury in the first place, notwithstanding the fact that we could obviously cross-examine them on the lack of accreditation. We think that it rises to the next level of not being trustworthy, and therefore it's overly prejudicial.
Okay. Mr. Lally, doesn't this happen in hospitals across Massachusetts on a regular basis?
It does, and just to be clear, nobody's breaking anybody's own rules. This wasn't blood work that was taken by anybody at the lab or tested at the lab. It was taken at the hospital, tested at the hospital, and what the technician or the forensic scientist from the Office of Alcohol Testing is doing is essentially mathematical calculations based on that result. So I would submit it goes exactly to the weight of the evidence. It's certainly fertile ground for cross-examination or argument by counsel. But as far as it being admissible, it's certainly admissible. This is what happens in every case. Whether or not Good Samaritan Medical Center's lab is ANAB accredited or anything of that nature is irrelevant. It has nothing to do with the state police strictures because they're not the ones who actually conducted the testing of what was in the blood.
All right, do you want to respond?
I just wanted to refresh the court's recollection. I mentioned this at the last hearing, but just one element of the problem is in the result. The extrapolated result was 124% swing. In other words, we extrapolated based on the blood draw.
Yeah, I know what it means.
And that's just massive. I've never seen a swing that big. It's, you pull somebody over. Well,
Sounds like a great area for cross-examination.
I think it will be. Okay. But if it's not admissible in the first place because it's inherently untrustworthy, then you could save me my breath.
Yeah. I don't see how this doesn't come in.
I'll submit, I don't want to beat a dead horse. I just think that it's so unreliable that it shouldn't be put before the jury, and we run the risk of prejudicing the jury in a way that we can't sort of unring that bell. Yes, we can cross-examine, but I don't think that the underlying blood draw is foundationally solid enough.
Mr. Lally, were you planning on using this in your opening?
I don't have to.
All right, so why don't we wait, and if need be, we'll have... the experts, let's wait until it gets closer to these experts or the folks from the hospital testifying. If we need to have a short voir dire, you need to remind me to do that, Mr. Jackson, okay?
Thank you for that, Your Honor. I appreciate it.
All right. Okay, so the last area I have is sort of logistics and sequestration. So the Commonwealth filed a motion initially. You know what, we'll hold off on the logistics regarding the audiovisual assistant. So there was a motion limine for sequestration that I allowed regarding the family. So the victim's brother, Paul O'Keefe, the sister-in-law, Erin O'Keefe, the niece and nephew, can attend the trial after their testimony. So that motion 293 is allowed. I understand that perhaps, I was going to also allow Mr. O'Keefe's father, who appears for some reason on the defendant's witness list. He is exempt also by me from the sequestration order. All right, so that's John O'Keefe Sr. So I just added that in. So Mr. Clerk, 293 is allowed with the addition of Mr. O'Keefe Sr. So the Commonwealth has filed a two-part motion, a motion for offer of proof regarding calling the elected sitting district attorney of Norfolk County and sequestration order if he is permitted to be called. This also includes Stephen Nelson, who is the victim witness person. So why don't I hear you, Mr. Lally or Ms. McLaughlin? I'll hear you on this motion.
Yes, Your Honor. So the reason for this motion is, as the court noted, they appear on the defendant's witness list. Neither of them, I believe, has received a summons in regard to it, so there's no motion to quash because there's no summons to quash. But with respect to each, as the case law is abundantly clear, in order for these witnesses from the prosecution team to be subject to being called as witnesses by the defense, the Commonwealth is just seeking some sort of proffer whatsoever as to what areas they can testify and only they can testify to. So if it's information that the defendant can elicit either through direct testimony or cross-examination from, and I would submit whatever, I would believe that whatever testimony they seek from either of these witnesses, they could get ample testimony from a multitude of other witnesses. Specifically, the only point that was raised as sidebar during impoundment was with reference to the district attorney testifying as to whatever issues purported issues of conflict or removal of Canton Police Department from the investigation, certainly those are questions I think far more appropriate for members of both the Canton Police Department, members of the State Police CPAC Detective Unit. The head of that unit, Lieutenant Tully, is one of the Commonwealth's witnesses who will be testifying, and I think he's in a far better position to testify to that than Mr. Morrissey. But regardless of that, what the case law is very clear about is that, number one, the victim witness advocate is a part of the prosecution team, and in these sort of areas stands in sort of the same stead as a prosecutor himself. Secondly, with respect to whatever areas of examination are expected or anticipated from these two witnesses, there has to be some sort of proffer of what that anticipated testimony would be that they can't get from some other witness. Certainly, Mr. Nelson has been the victim witness advocate working on this case.
So why don't you explain to me, I did look at the victim's Bill of Rights, but why don't you explain to me exactly what a victim witness advocate does, the nature of the relationship with the victim's family? I know there was a lot of discussion about this in grand jury minutes that I read, about scheduling appointments, meeting with people, things of that nature.
So, I mean, what to say assist, I think, is doing it somewhat of a disservice as far as the prosecution. It's someone who works directly with the prosecutor on virtually every step of the case, as far as investigation, as far as pending motions, as far as trial.
Has Mr. Nelson been the advocate throughout the pendency of this case?
Yes, Your Honor. So for over 2 years, has been the point of contact with the family, has been with the family at each of the court dates, is assistant and very helpful as far as coordinating things with the family, coordinating meetings, scheduling meetings with witnesses in preparation of grand jury, in preparation of trial, has communicated thoroughly with regard to issues of scheduling and all of those types of things.
Does he take calls like late at night from witnesses? Does he have a personal relationship with witnesses governed by a professional relationship? Is he somebody that they are able to call? There's been a lot of allegations of harassment of witnesses. Are those folks able to call him when something like that happens?
That is the person that they would call.
Okay.
Yes. So I think the bulk of the communications and conversations with witnesses who are not members of Mr. O'Keefe's family over the course of the last couple of years have been in relation to that issue specifically, as far as harassment, threats, intimidation, things of that nature, that he's dealt with admirably in relation to those witnesses.
Okay. All right. Who's arguing this for the defense?
I will, Your Honor, and I think it makes sense to separate out D.A. Morrissey and victim witness advocate Steve Nelson in this
let's start with Mr. Nelson.
Sure. Your Honor, the defense acknowledges that there are often times where, let's say, a victim witness advocate sits in on an interview with a witness or an alleged victim, but there are other witnesses in the room to whom or who could testify about the content of that, and that doesn't necessarily make it proper to call a victim witness advocate during a trial. I acknowledge that. I also acknowledge that the victim witness advocate has a job to do, and it puts them as sort of an intermediary between the prosecutors and the police and alleged.
So when you were prosecutor, you worked very closely with victim witness advocates.
I did. Okay. Yes, and it's my experience being on the other side that informs my knowledge of that. But this is a different case with regard to one specific issue, and that is that we learned as a result of the federal materials that victim witness advocate Steve Nelson had conversations with Brian Higgins and we believe Brian Albert, but Brian Higgins talked about him specifically. Mr. Higgins was asked, where is his cell phone? Why does he not have it? Are you aware of the preservation order that was issued by Judge Krupp in the Karen Reed case? And the answer came back that he was given permission to destroy or dispose of his cell phone from victim witness advocate Steve Nelson.
Did he say destroy? I'm trying to remember the testimony. I don't think he said destroy.
I used the disjunct.
Yeah, I mean, every time he say destroy, I'm like, destroy?
Rather than the conjunctive, because from memory I can't remember the precise language, but it certainly was
you being slick.
Conveyed to. I'm told that the precise language was to get rid of, which would be consistent with what I had
told
said.
He could get rid of, not told he must get rid of.
Correct. In other words, Steve Nelson is overruling a colleague of yours, your predecessor on this case, who issued a preservation order which was never lifted, and yet he stepped into the case, gave authorization that he did not have to give for the disposal of a phone, which is relevant.
Okay, is that the sole issue you want to?
Yes.
The sole issue?
Yes, that's with regard to Mr. Nelson. It's different with regard to Mr. Morrison.
What's the Commonwealth's response to that?
I don't believe any of that is accurate. So what counsel was referring to is there was a motion to preserve cell phones. The Commonwealth notified each of the witnesses that were subject to the motions and the orders, sent copies of the motions and the orders, as well as a letter explaining that. There were conversations in regard to that. There was then a subsequent Rule 17 motion filed specifically for the physical phones. There were conversations with those specific witnesses, just advising them that the Rule 17 motion had been filed. They had to hold on to their phones, things of that nature, explaining what the process was. The hearing was conducted. The Rule 17 motion was denied, and then those witnesses were subsequently informed that the motion had been denied. I believe even from Mr. Higgins' testimony in the federal grand jury the counsel was referring to, he was specifically asked whether or not he had been ever advised by Mr. Nelson, myself, or anyone from our office that he could or should get rid of his phone, and he said no. So I don't know what further needs to be explored on that particular point, as the question was, all of these issues were explored in that particular area. And
I'm saying, though, if the motion gets denied, that means we don't need your phone. But why would you even suggest getting rid of it? Like, I mean, is something wrong with it? Is it broken? Like, did it stop working or something? Like, why would you suggest getting rid of it? If they don't need it, then you get to keep your phone and don't gotta turn it in. Why would you want to get rid of it? What's wrong with it? Is the phone like? I'm a little confused. Why would you even suggest to get rid of it? I just don't understand that.
Be explored on that particular point, as the question was, all of these issues were explored in that particular area, and just because counsel, I think, may not like the answer or doesn't believe that the answer is truthful or whatever, that does not then permit bringing in this witness to testify to what they know is not true.
All right, so Ms. Giannetti?
We believe that that's a misstatement of what was testified to. I think it probably makes sense for this court to look at his very testimony so that you can make a decision on this, Your Honor.
Okay.
So here's what I'm going to do. Let's wait and see how Mr. Higgins testifies. Okay, I am not going to order
Man, I can't wait to hear these people testify.
sequestration of Mr. Nelson, and let's see how the testimony is. And if you need to call him, you let me know, and we'll have another hearing on it.
Okay, we'll do it. And just to answer an anticipated question from the court, I do not open on this issue.
You cannot open on that issue, Ms. Giannetti. You still need the 45 minutes?
that takes away nothing from my opening.
All right, so Jim, I'll start writing. I'll write something on this.
Your Honor, with regard to the sequestration, I think it would be appropriate for the court to order that Mr. Nelson and Mr. Higgins not discuss this issue from here forward.
Are you willing to have that happen, Mr. Lally?
That's fine, Your Honor.
Yeah, I'd order it, but he's willing to do it.
Thank you.
All right, so I just need a minute to write this out.
Sure.
Hey, listen, this case is interesting. I ain't gonna lie. It's definitely interesting. This is definitely movie worthy, series worthy. This is something you could watch a couple episodes of, man. Like Law and Order, like the extended version, bro. Like, man, this one right here. Especially if you don't, if I was doing this trial live, it would be intense. Like if I was actually covering it while it was happening, man, I would be animated. I would be like, yo, this is great. You know what I mean? I'm animated. If y'all don't know me, I'm animated. Hi, my name is Animated. Nice to meet you. That's me. I'm animated as hell. I would be flinging my arms, all type of shit. All right, let me skip some of this quietness.
Of the
All right, so regarding D.A. Morrissey.
Yes, well, thank you, Your Honor. So, Your Honor, the integrity of the investigation that was done in this case is certainly a live and important issue that is part of the defense in this case. I think the court would agree that we're entitled to question the integrity of the investigation, to attack it where we can. And it goes without saying that as the district attorney in Norfolk County, Michael Morrissey is in charge of that investigation. Now, in the usual case, that doesn't necessarily make a district attorney a witness. That would be unusual. There probably have been very few requests to have a district attorney testify in that regard. However, this case is different for...
I don't think I've ever... Yeah, now that you mentioned that, I don't think I've ever seen a DA testify. I'm trying to think right now. I do not think I've ever seen a district attorney on the witness stand. I don't know. Maybe I don't remember, but I don't think so.
For two reasons. One is the conflict of interest regarding the Canton Police Department, which Mr. Morrissey was involved in. The second is the manner in which he injected himself into this case personally and made representations that we should be allowed to challenge.
Do you want to play that video?
We haven't made that decision yet. It may be that we elect to play portions of the video. It may be that we just elect to question D.A. Morrissey.
I have to think of other ways, right? That's part of the analysis that I have to follow in the law. So that's why I'm asking.
Of course. And I think before we get to that issue, Your Honor, the conflict issue is what puts him on the stand first. And we learned from the federal materials that former Chief Kenneth Berkowitz notified D.A. Morrissey at a very, very early juncture at 8:30 a.m. A phone call from Chief Berkowitz to D.A. Morrissey notified him that Kevin Albert is on their force. He's the brother of the homeowner whose lawn contained the lifeless body of John O'Keefe, and that D.A. Morrissey was involved in that decision. He received the information from former Chief Berkowitz and concurred that the Canton Police were conflicted out. And then the problem is that the Canton Police they had their hands in this investigation, including that day after 8:30 a.m. and going forward. And there were, updates that were provided to Kevin Albert by a trooper under D.A. Morrissey's control. That there were violations of that sort of conflict of interest, taking Canton out of the case that DA Morrissey became aware of and that DA Morrissey did nothing about. And so in terms of us being able to attack, question the integrity of the investigation.
Why can't you do it through other witnesses?
We can, but the buck stops with District Attorney Michael Morrissey. He was the one that was involved at a very early juncture on this precise issue of the conflict, and he became aware that that conflict was violated time and time and time again, and he did nothing. And I believe that that's ripe for cross-examination. And with regard to his statement to the press, this may even be more compelling. Not because of the bias necessarily that he showed. That's not the strongest part. I think it is strong, but it's not the strongest part of his statement. His statement makes factual assertions, some of which we heard for the first time. In that videotape statement, he announced to everyone, including potential jurors, that Trooper Proctor never reported to the scene on January 29th. That's in direct conflict to police reports that we received from the troopers saying that they reported to the scene. And we would argue, trying to use semantics to get out of that, and now saying that for the first time in my career, I've heard that the crime scene is actually the police station that's across town. That doesn't make any sense. It doesn't pass the straight face test. But those are his own words, and he made himself a witness by uttering those words. And he also talked about his view of what witnesses did or didn't do and whether they're suspects or not suspects. Again, he injected himself into this case. He made himself a witness, and there's really nobody else we can question about his knowledge that he had when he made those statements and why he made those statements, and also the fact that he was involved in this conflict decision from the beginning. So that's our offer of proof.
Mr. Lally?
I mean, as far as his statements, his opinions are completely irrelevant. And I think what counsel is referring to as proper for cross-examination, they might be. But this will be a witness that they're calling themselves. So for direct examination of your own witness, I think it's improper, number one. Number two, there is ample other avenues to explore this through other witnesses, which counsel can certainly do, as related to whatever.
As the law tells me I have to consider.
Correct. And so, as it pertains to whatever extent the court allows as far as the Bowden defense is concerned, then I think it's fertile ground for cross-examination of other witnesses in respect to that. But as to whatever statements were made or not made by something that someone doesn't have recipient knowledge of, because I don't think anybody's saying that Mr. Morrissey was at 34 Fairview Road. So with all of those things in consideration, I don't think that it's even close to a valid proffer as to why the district attorney or Mr. Nelson need to testify on their own as to any of those things. The last thing I would just note is with respect to Mr. Nelson, the alleged mischaracterization that I made in regard to Mr. Higgins' testimony is actually contained on page 140 of his testimony. 140? 140.
Could you read it? Do you have it there? If you don't have it there.
It's more so I don't know that I'm
okay. Okay.
Your Honor, if I could just add one thing that I should have mentioned, which is on this issue of whether there's another witness that could testify.
Yes, because you did say, yes, we can get it in through other witnesses.
Yes, except the one thing we can't get in through other witnesses, potentially, is the phone call from Chief Berkowitz to DA Morrissey, where, as I'm understanding it, there were only two people on that call, and the Commonwealth is seeking to take Chief Berkowitz off the witness stand as well.
Are you? I didn't see anything like that.
No, I'm not seeking to keep him off the witness stand. What I informed counsel is as to his current medical condition, and informed counsel that's why I didn't summons him. But I'm not seeking
I knew nothing about this.
Prohibit him from testifying.
My understanding was that the prosecution didn't believe that he would be able to testify.
This is the first time hearing any of that. All right. So it is a stretch. It is an uphill battle for you, Ms. Dianetti. I will allow you to revisit the ADA Morrissey at the close of the Commonwealth's case. Right now, that your offer of proof is not enough. I'll give you the opportunity to do it again based on the testimony that comes in, and I am not excusing him, or he is not subject to the sequestration order.
Understood, Your Honor. Thank you.
Okay. All right. So, Jim, I'll write something short on that. I've written the part about Mr. Nelson that I'll give you afterwards. All right. So, when we had our motion in limine hearing, I think we went much of the day that Friday. I don't remember if it was last Friday or the Friday before. I ended that with saying twice, is there anything else we need to discuss regarding housekeeping or logistics? And I was told no by both parties. And then I get a motion the following April 19th, the end of last week, about wanting to use not just having a technology audio visual assistant at counsel table, but to use, it's much more extensive than what I expected. The Commonwealth filed their motion, and it was allowed previously because it happens in every single case in these courtrooms, and the Commonwealth shares their equipment. Please tell me exactly what it is you want to do, and I'm mindful also of the fact that during impanelment, while we were actively on trial in this case, in a critical part of the case, your audiovisual person, who I had never seen, was sitting where you are, Ms. Dianetti, talking to your client. So it sounds like he's taking liberties in this courtroom, and I need to know exactly what you need him for and what it is you intend to do. Keeping in mind also, it sounds like he's taking liberties in this court. Person who I had never seen of the fact that during impanelment, while we were actively on trial in this case, in a critical part of the case, your audiovisual person, who I had never seen, was sitting where you are, Mr. Yannetti, talking to your client. So
What? Yo, what we doing?
So it sounds like he's taking liberties in this courtroom, and I need to know exactly what you need him for and what it is you intend to do. Keeping in mind also that we're going to be now in a much smaller courtroom. So tell me, are there any agreements of counsel? Is there any, I know nothing about this, and I asked for information previously, so I could have thought about it and, you know, seen a demonstration or heard something. What is it you're asking me to allow?
Thank you, Your Honor. It's very modest. We did mention that we were going to ask for this.
But you didn't do it in writing, and you didn't give me specifics.
Your Honor, we asked you, and you then said put it in writing, then we put it in writing.
But the first time it was brought up was after I had asked about logistics. Go ahead, tell me exactly what it is you want to do.
Okay, so it's a very modest request. Under ordinary circumstances, and we've utilized his services before, he would sit at counsel table and he would run sort of the AV to make it seamless and smooth for everybody, for the jurors, for the court, for the court reporter, for opposing counsel.
Why does he need to talk to the defendant though? I hear all that other stuff. Why he need to be talking to Karen though? That's what I need to know.
He can put monitors at the request of the court, monitors on the bench, monitor in front of the court reporter, a monitor in front of Commonwealth, and a monitor here, all small, relatively inobtrusive monitors. He also can run the system of...
To back it up, hold on. Let me go back for a second.
Going to be now in a much smaller courtroom. So tell me, are there any agreements of counsel? Is there any, I know nothing about this, and I asked for information previously, so I could have thought about it and, you know, seen a demonstration or heard something. What is it you're asking me to allow?
Thank you, Your Honor. It's very modest. We did mention that we were going to ask for this.
But you didn't do it in writing, and you didn't give me specifics.
Your Honor, we asked you, and you then said put it in writing, then we put it in writing.
But the first time it was brought up was after I had asked about logistics. Go ahead, tell me exactly what it is you want to do.
Okay, so it's a very modest request. Under ordinary circumstances, and we've utilized his services before, he would sit at counsel table and he would run sort of the AV to make it seamless and smooth for everybody, for the jurors, for the court reporter, for opposing counsel. He can put monitors at the request of the court, monitors on the bench, monitor in front of the court reporter, a monitor in front of Commonwealth, and a monitor here, all small, relatively inobtrusive monitors. He also can run the system of AV, in other words, putting up evidence. I'm looking at evidence binders that Mr. Lally and I are going to be visiting about through the day today and tomorrow. There's hundreds and hundreds of photographs in here, multimedia, that's going to need to be played and shown throughout the course of the trial. Instead of walking back and forth and doing it sort of...
No, and that's what we do every day in this courtroom.
Right, and that's what he does every day in courtrooms as well. I mean, all we're asking for is an accommodation exactly like the Commonwealth has. It's just easier for us. If I'm up on a cross-examination or Mr. Yannetti is up on a cross-examination and we say, okay, let's say we've got internal bait stamps that show photograph number 231, he'll know what photograph number 231 is. He'll have an outline that tracks our cross-examination or our direct examination.
So it will be only things that are in evidence or will be coming into evidence? You're not going to do that with disputed?
Absolutely not. We would never do that. If there's anything that's disputed or even remotely controversial, my habit and practice is to ask to approach the bench. We all walk up. I say, this is what I'm proposing to show the jury, and the court rules on it. No, all it is just a sort of a facile accommodation of seamlessly showing multimedia or playing an audio or playing a video for the jurors.
All right, what's the Commonwealth's position on this?
Your Honor, given that representation, I mean, that's precisely what we do in every case in which we have either Ms. Gilman or Ms. Crawford or whoever assisting with the trial. If that's what it's limited to, I don't know about the additional monitors or things of that nature, whether or not, especially if we're going to be in courtroom 25, whether that's really necessary. But certainly whatever logistically we have as far as equipment or screens or whatever is obviously fully, we would fully make accessible to defense counsel as well, as we do in every case.
All right. So, in Suffolk County, there are monitors. The audiovisual equipment is fantastic. There are the jury seats. They're for everybody to see. There's even a way if something is an objected to motion, it can just be seen on the lawyer's screen and the judges. So the bottom line is, if we had known about this 2 months ago, we would have been able to really put the time into seeing exactly how this works. Mr. Yannetti, I'd like to finish first, and I'll give you the opportunity to speak to Mr. Jackson, to really see how this works, see how we set it up. I can't devote that time to it right now. No monitors. I don't want to monitor. I'm not allowing, or Madam Court Reporter is fine. We're in that very small courtroom now at your request. So we don't need monitors on the tables. I don't have the time to physically go see how this all looks. Ms. Gilman's here. Perhaps she can speak with your audiovisual person, and then you can all make a presentation to me. But again, this, months ago would have been much better.
Well, I understand the court's concern. This is extremely modest, and it's not going to take a whole lot of presentation. If the court doesn't want to monitor, the court says, I don't want to monitor.
I don't know if I want monitors on those tables so close to the jury.
That's fine. Then the court can say, I don't want monitors that close to the jury. Then what I would do is just use paper copies. When I'm up on direct or cross-examination, I don't want to have to, I can't prepare with the Commonwealth's.
No, I understand that. I don't think he'll fit at counsel table.
I can't. I think he would. I think accommodate him. Or if he doesn't fit right at counsel table, we've also set up, he was on a relatively large case that we had in a small courtroom back in California, just behind counsel table, and he's got his own laptop, and nobody else can see it. And he's got a type of screen that you can't see it from angles. So jurors are not going to be seeing anything, but I need to be able to, and Ms. Little and Mr. Nettie need to be able to prepare with him. And I think the court.
No, and I understand that. I don't have a problem with that. It's the 4 monitors on the tables, 1 on the bench, 1 for the court. We're in a small room.
We won't do that.
And I'm concerned about the amplifying sound. I mean, is it like movie theater sound? I mean, it's, again, a tiny room at your request.
He uses very modest speakers that are appropriate for the space.
Sound,
so in this space, it would be probably a couple of speakers that are larger so that the jurors can hear.
You worried about sound?
In a small space, he'll just pare it down and use small speakers. And there's a switch. So for instance, he will work with Commonwealth's AV expert, and there's a switch on both tables. When it's my turn, switch, and now.
All right, so is that switch, are you putting wires? I mean, these are all the things that I shouldn't be dealing with. I mean, we just got Wi-Fi in this building a week ago. I mean, it's not
about a week
that,
ago.
We can just last minute. It's a beautiful old historic building. We want to keep it that way. So,
and we will not mess anything up. As a matter of fact, I was told that by the Commonwealth that she uses switches, consistently. That's not new technology. It's very simple. It just allows both of us to be able to prepare with the audiovisual portion of the case.
She don't want that. Listen, she already got a problem with that audio dude. He already was talking to Karen. She really don't want him there. That's what it is. She really like, man, I don't really even want. She really just needs to say, man, to be honest, I don't want him here.
More seamlessly. That's all. We just want to make it more seamless and more professional for the court and for the jurors.
So it would be during your case in chief.
It would be during my cross-examination of every one of the witnesses. I mean, the bulk of the case is going to be the Commonwealth's case in chief.
Boy, she's frustrated. Everything she hear about this is like, nah. She don't want no problem.
Into evidence, you're not trying to enter exhibits.
Every one of the witnesses. I mean, the bulk of the case is going to be the Commonwealth's case in chief.
All right, with exhibits that are already into evidence, you're not trying to enter exhibits during cross-examination?
I mean, unless it's an impeachment that I didn't see coming. But even in that case, my habit and practice, my custom and practice would be to approach, if it's a matter in controversy, or tell the Commonwealth in advance, I'm about to show this photograph, do you have an issue with it? No, I don't. And then we'll show it. But I would never, the point of it is not to ambush anybody. It's just to make what is going to be shown and what's allowed to be shown seamless and more professional looking.
Does the Commonwealth and Ms. Gilman have an opportunity to spend a little time today to take a look at it and see? I mean, everybody's preparing for trial, obviously. Again, this is, I don't have the time to do it, and I understand if you don't, but.
I think Ms. Gilman can spend some time. She actually had made arrangements to meet Mr. Bates here last Friday, and he didn't appear when we were told he was going to be here. So, but I'm happy to have Ms. Gilman.
Ms. Gilman, are you willing to spend some time today? Thank you.
By the way, just Mr. Bates' defense. Yes, he was supposed to come last Friday. He was told he couldn't come because he hadn't gotten permission from the court yet.
Okay.
We did not.
Well, that makes sense, frankly.
I just don't want there to be a sort of a hanging chad where that's concerned. He didn't leave.
Well, especially where he didn't start out well, right? Being at counsel table during impanelment.
I understand that, and he's been told that was inappropriate and obviously would never happen again.
All right. So some sort of ground rules. Only one counsel, whoever's doing the cross-examination of the witness, objects. Just one, not all of you. It's not a tag team. So one person objects. If you want to approach the witness, you must ask permission. At sidebar, there will only be one person talking again, and it'll follow with whoever does the examination. Many times I allow counsel to discuss things, and many times I call directly on maybe appellate counsel or counsel who's been the big law person. So you can ask me for permission for that, and no basis for your objection. You just simply object.
I'll probably hear my air conditioner, man. Just cut it out.
That's it. And if we need to see you at sidebar, we'll see you at sidebar. But I don't want a whole litany of reasons why the testimony you think is inadmissible. So those are pretty standard rules. I'd like to see counsel at sidebar regarding a jury issue.
Bar regarding the jury issue. Like we got to wrap this up. Huh? Sidebar regarding the jury issue. This is it. That's all. All right. So the next time I go live is gonna be to to see trial day one. Let's make sure that's what it is. It should be the official day one of the trial. All right, man. So I got some understanding. I got some straightening. I don't know what happened. But I do know that some of these officers involved has been lying, and there seems to be a cover up of something for some reason. And I'm on the case. It's definitely a cover up of something for some reason. So that's what I got from that. And now I'm gonna collect the details as we go through this trial, and I'm gonna try to be my own jury. And you guys can join me, and we gonna see if we came up with the same decision the jury came up with. You know what I mean? Like, do we see it the way the jury see it? You know, because this is great. It's great. So far, it seems like there's a lot of questions and side eyes to the police department over there and the law enforcement people over there. Yeah, so shout out to the chat. I'm about to get up out of here. I appreciate everybody rocking out. Be on the lookout for more of these. We'll see y'all again. We doing part 2. We got a bunch of parts, but yeah, this is a series right now. I gotta check this out. Thank you everybody for coming out, and enjoy the rest of your evening. Take care.